The drug. ನೋಡ್ರಿ ಸರ್ ಕೊಡ್ರಿ ಬೇಕು ಫಸ್ಟ್ ಮೆನ್ಷನ್ ಮಾಡೋದು ಕರ್ದಾಗ ಇರೋದು ಕರ್ದಾಗ ಮೇಡಮ್ ಅದ ಇದ್ದ ಲಿಸ್ಟ್ ಕೊಡ್ರಿ
ಮೇಡಮ್ ಮೇಡಮ್ ನಂಬರ್ ಹಾಕಿದ್ರಿ ಸೀರಿಯಲ್ ನಂಬರ್
ಅವ್ರೇನು ಮೆಮೊ ಮಾಡಿದ್ರಿ ಅಂತ
ಶರಣು ನಿನ್ನಿದ್ ಬಂಡಲ್ ಒಯ್ದಿದೆ
ವೈದ್ ಟೇಬಲ್
ಮೆಮೊಗಳು ತೆಗೆದಿದ್ದಾರೆ
ಆ ಟೇಬಲ್ ಮೇಲೆ
ಎಲ್ಲ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಆಗಿ ಬರ್ತದೆ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಆಗಿ ಬರ್ತದೆ
24, 23, 19.
ಹಂಗೆ ಬ್ಲಾಕ್ ಟೈಪ್ ಮಾಡ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಒಂದು ಹೊರಗಡೆ ಒಂದು
ಉತ್ತರ ಕೊಟ್ರ ಬ್ಲಾಕ್ ಅಂತ್ರಿ ಆಮೇಲೆ ಅಂತ್ರಿ ಹೆಂಗ್ ಬರ್ದಿರಿ ಅವು ಸರಿಯಾಗಿ ಗೊತ್ತಾಗಲ್ಲ
ಬರ್ಕೊಂಡ್ರಿ ಅದರ್ ಸೈಡ್ ಇನ್ ಕೇಸ್ ಅರ್ಜೆನ್ಸಿ ಬೇರೆ ಅಂತ
ಮುಂದಿನ ಸುಖ ಒಂದು ಸೋಮವಾರ ಯಾವ GM ನಂದ್ರಗಿಲ್ಲ ಯಾವ ಸರ್ವಿಸ್
ಸರ್ವಿಸ್ ಲೇಬರ್ ಎಜುಕೇಶನ್ ಅದು ಈ ಕಡೆ ಹಾಕದಿತ್ತು ಎಜುಕೇಶನ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಒಂದಿನ
ಮಂಗಳವಾರ
ಈ ವಿಷಯ ಬಿಟ್ಟು ಬಹಳ
ಎಲ್ಲ GM ಬರಲ್ಲ ಇಲ್ಲ ಸೋಮವಾರ
ಮಂಡೇ ದಿನ ಜನರಲ್ ನಾಗ ಯಾವ ಗೊತ್ತಾಗದು ಕ್ಲಾಸಿಫಿಕೇಶನ್
ಪೊಲೀಸ್ ಎಲ್ಲ ಎಲೆಕ್ಷನ್ ಅಂದ್ರೆ ಯಾವಾಗ ಸಂಬಂಧಪಟ್ಟ ರೈಲ್ವೆ ಎಲೆಕ್ಷನ್ ಎರಡು ದಿವಸ ಕೆಲಸ ಮಾಡಿದ ಸಾಕು ಮುಂದ ಇದು ನಾನೊಬ್ಬನಿ ಎಲ್ಲ ಇದು ಟ್ಯಾಕ್ಸ್ ನಾನೊಬ್ಬನಿ
ಅದೊಂದು ಹೇಳಿ ಬಂಗಾರ ಹಾಕೊಂಡ್ರಲ್ಲ ಮುಗದಾಯ್ತು ವಾರಕ್ಕೆ ಒಂದಿನ ಬಂದು ಅಂತ ನಡೀತು
ಸಾವಿಗೆ ಹೇಳಿ ಇದ್ರ ಸಂಗತಿ ಇದೊಂದು ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟ್ರು ಕಡಿಮೆ ಇದಾವ MCPC ಇರ್ಬೇಕು ಟ್ಯಾಕ್ಸ್ ಭಾಳ ಕಡಿಮೆ ಇದಾವ ನಾವ್ ರೆಡಿ ಅದರ್ ಸೈಡ್
ಸಬ್ಜೆಕ್ಟ್ ಟು ರಿಸಲ್ಟ್ ಆಫ್ ಲಿಟಿಗೇಷನ್ ಮಾಡಿದ್ದದ ಎಲೆಕ್ಷನ್
ಇವತ್ತ ಮ್ಯಾಟ್ರು 345 perpetual
ನಮ್ದೇನ್ ರೀಚ್ ಆಗಲ್ಲ 75
80 ನಾನು ಲೈನ್ ಹಿಡಿದ್ರೆ ಹೌದು ಬಂದ
ಮಾಡಿಲ್ಲ ಲಾಸ್ಟ್ ನೋಟಿಸ್ ಮಾಡಿದ್ರೆ ಅದು ಮತ್ತೆ ಡಿಸ್ಪೋಸ್ ಆಗಕ್ಕೆ ಕಿರಿಕಿರಿ ಶುರು ಆಗ್ತಾವು ಸೀರಿಯಲ್ ನಂಬರ್
ನಾನು ಮಾಡ್ಬೇಕಲ್ಲ ಅಂತ ಹೊಡೆದು ಬಂದೆ ಅಷ್ಟೇ ಬ್ಯಾಗ್ ಅಲ್ಲಿ ಇಟ್ಟಿನಾಗಿತ್ತು
ನಮಗ ಟೆನ್ಷನ್
But fresh apply reno.
ಹಲೋ ಫೋಟೋ ತೆಗೆದಿದ್ದೀನಿ ಮೆಮೊ ಕೊಡತ್ತೀನಿ ಕೊಡು ಕೊಡು memo for withdrawal. I filed.
With your lordships, kindly.
I filed memo for withdrawal. It will take
We
on
have
Monday.
classified the matters to be listed on particular dates.
For withdrawal, my lord, Monday. Monday.
End of the list.
The withdrawal ಬೇಕಿದ್ರೆ ನಾಳೆಗೆ ಹಾಕಿ.
ಇಲ್ಲ, tomorrow I will not be available. Monday, my lord.
With your lordships, kindly, my lord.
ಈ ನಾಳೆಗೆ ಹಾಕಿ withdrawal ಏನಂತ.
My
My
lord.
lord, I am saying
Back
Monday,
for
my lord.
end of
For
list,
withdrawal, Monday.
Withdrawal ತಾನೆ ನೀವೇನಕ್ಕೆ
I am seeking liberty, my lord, to file fresh Monday.
ಮಂಡೇ ಆಗಲ್ಲ ಯಾವತ್ತು ನೋಡಿ ಯಾವ ಮ್ಯಾಟರ್ ನೋಡಿ
Service ಇದೆ.
ಸರ್ವಿಸ್ ಯಾವತ್ತು ವೆನ್ಸ್ಡೇ
Service matter,
Fresh matters.
memo for withdrawal, my lord.
ಕೊಡಿ ಎಲ್ಲ ಮೆಮೋಗಳು ಕೊಡಿ.
Fresh matter, my lord, election matters. Sunday is the Sunday is the election, my lord. I am seeking for voting right, my lord. Tomorrow it will.
12th is the election day. End of the list matter, your lordship. 12th is the election day. Dead voters are being included in the voters.
Yes.
ಇದರಲ್ಲಿ ಎರಡು ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಇದೆ. ಸೇಮ್ 12th is election, my nomination is rejected.
I told.
ಇದು ಎರಡು
My lord, with your lordships, kindly, my lord, 3 matters I am moving for end of the list, my lord. All 3 are same, my lord, tender matters, my lord. Where the financial bid may open tomorrow, my lord, and my technical bid have been rejected. Therefore, I am before this honorable court, my lord. 2:30 today, my lord. End of the list.
ನಾಳೆಗೆ ಬರ್ಲಿ ಶ್ರೀನಿವಾಸ್.
ಅಲ್ಲ ನಾಳೆ ಫೈನಾನ್ಷಿಯಲ್ ಬಿಡ್ ಓಪನ್ ಮಾಡ್ಬಿಡ್ತಾರೆ ಅಂತ ದಟ್ ಇಸ್ ದಿಸ್ ಥಿಂಗ್ ಮಿಲಟ್ ದೇರ್ಫೋರ್ ಐ ಆಮ್ ಬಿಫೋರ್ ದಿಸ್ ಆರ್ಬಲ್ ಕೋರ್ಟ್ ಟೆಕ್ನಿಕಲಿ ಐ ಆಮ್ ಆಲ್ಸೋ ಕ್ವಾಲಿಫೈಡ್ ದೇರ್ ಇಸ್ ಎರರ್ ಮಿಲಟ್
ಆಯ್ತು told.
My lord, with kind permission. With kind permission.
Yesterday I have moved, my lord, but it is not posted today, tomorrow. Today 2:30.
ಯಾಕೆ ನೋಡ್ರಿ ಯಾಕೆ ಬಂದಿಲ್ಲ ಅದು
2:30.
ಯಾಕೆ ಬಂದಿಲ್ಲ ಅಂತ ಆಯ್ತು ನಾಳೆಗೆ ಹಾಕಿ.
2:30. Tomorrow is the, my lord, the general body meeting. I have sought for, my lord, the direction. my lord.
ಆಯ್ತು
2:30.
My lord, with kind permission on matter tomorrow, my lord. Bank director's election is,
ಆಯ್ತು ನಾಳೆ.
please.
Service matters, my lords, next week. Service matters, my lords, covered by judgments is there. Service matters.
ಅದು ಹೊರಗಡೆ ಒಂದು ನೋಟಿಸ್ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಹಾಕಿ ಯಾವ ಯಾವ್ದು ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಯಾವತ್ತು ಅಂತ ಹಾಕಿ
Please.
My lord.
My lord, seal number 32, my lord. Our objection file, my lord, rejoined track like sir. Next week, any date. I am appealing for petition, Sanjay.
The counsel for the petitioner seeks time. List on.
Any date.
Service matter ನೋಡ್ರಿ.
16th, 17th. my lord. Much.
My lord, serial number 36, my lord. I am for petitioner, I seek for adjournment, my lord.
36. The counsel for the petitioner seeks time. List on.
36. 13th, but next week. Please.
My lord, seal number 60, my lord. I am participating on 1 and 2. Next week, any date, my lord.
ಯಾಕೆ
Objection to file, my lord, in this case.
ಮಾಡಿ ಇದೆಲ್ಲ ಯಾವ್ದು ಜನರಲ್ ಮಿಸ್ಟೇಕ್ಸ್
Next week, my lord.
ಲಿಸ್ಟ್ ಆಗೋದ್ ಕಷ್ಟ ನೀವು ನೋಡಿ ಏನ್
ಇಲ್ಲ sir.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಸುಲಭನಾಗಿ ಹೇಳ್ತೀರಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ರಿ ಏನಾಗುತ್ತೋ ನೋಡೋಣ.
Next week, any date, my lord.
Counsel for the respondents 1 and 2 seeks time. List on date.
Oh, let's see.
Seal number 58.
ಜನರಲ್ ಮಿಸ್ಟೇಕ್ಸ್ ರೀ ಸೋಮವಾರ ಮತ್ತೆ 21 ಅಂತೀರಾ 20th ಜನವರಿ.
Sir, seal number 58. my lord.
ಯಾಕೆ ಜೋಶಿ ಎಲ್ಲ
ಇಲ್ಲ, tomorrow, sir. ನಾನೇನೆ ಮಾಡ್ತೀನಿ. File
2015 ನೋ ಸಾರಿ
tomorrow, sir. Only tomorrow, sir.
ಸಾರಿ 2015, no adjournment.
ಅಲ್ಲ tomorrow ಮೇಲೆ only tomorrow sir. ಯಾಕಂದ್ರೆ ಒಂದು
Sorry.
ಫೈಲ್ ಸಿಗ್ತಲ್ಲ sir tomorrow I just
ಹಳೆ ಮೆಟಲ್ ದಯವಿಟ್ಟು ಕೇಳ್ಬೇಡಿ.
only one day sir tomorrow I am ready sir.
No adjournment. Yes, next. Yes.
Lord's kindly, serial number 73, my lord. I am
Ah.
filing a statement of objection on behalf of respondent.
Also for the respond number 3 time. Entry order ಇದೆಯಾ?
ಇಲ್ಲ, there is nothing.
List on 20th. 20th ಆಗುತ್ತಾ?
Lord, 27th, my lord. Oh, bless.
20.
Serial number 74, my lords. Filed Wakalat yesterday, I applied for certified copies.
Alert.
A week time may kindly be granted for respondent number one
Copies of what?
of the claim petition and other relevant documents, order sheet and all.
My lord, sir, may I say? Serial number 974 and 77 are, my lords, challenged on the ground of that delay in filing the claim petition, my lord. The SLP is filed, PIL SLP is filed before the Apex Court. That is dated on 15th, my lords, may be taken on 22nd, all these matters. Serial number 974 and 77.
Serial number 9 na?
Yes.
Serial number 974
ಅವೆಲ್ಲ
and
ಕ್ಲಬ್ ಮಾಡಿದ್ದೆ ನಾನು, ಸಪರೇಟ್ ಆಗಿದೆ.
serial number 974 and
77,
77. List on date.
22nd. 15th ಲಿಸ್ಟ್ ಆಗಿದೆ.
Obliged.
Your lordships,
Very.
matter your lordships, memo for posting your lordships, education matter your lordships.
ನಾಳೆ
Tomorrow.
Yes, correct. Praveen Kumar Raikote.
And I appear for the petitioner.
Ah,
Since the amended cost title was not filed, it was dismissed on the
please
same day it was.
2003, please do it, do some.
I have done,
do some-
I have done it already, my lord. It has to be recalled, my lord, that's all.
What has to be recalled?
And on that day, my lord, amended cost title was not filed.
IA. IA 2 of 23 is filed to recall the order dated 4/7/2023. The petitioner, this petition was dismissed for non-prosecution on 4/7/2023. An application is now filed to restore the writ petition by recalling the order. Though the cost shown for not complying though the cause shown is not convincing yet, since the petitioner has substantial interest in the writ petition, common opportunity deserves to be granted to the petitioner. Hence, IA 1 of 23 is allowed.
IA
2 of 23 is allowed, and the order dated so and so is recalled. ಯಾವತ್ ಮಾಡ್ತೀರಿ ಆರ್ಗ್ಯುಮೆಂಟ್?
Next week, my lord, Monday, your lordship.
ಎಲ್ಲಾರು ಯಾವತ್ ನೋಡ್ರಿ? Thursday. ಯಾವತ್ತು?
Tuesday.
Tuesday, ಕೊಡಿ ಯಾವತ್ತು?
Please,
21st.
please, grateful.
List on 21st January as a last chance. Next. ಏನಿದು IA 1 of 23 ಏನಿದು? ಏನ್ರಿ ಇದು? Recalling. IA 1 of 23 is filed for conduct of delay in filing the application to recall the order dated so and so, by which the petition was dismissed for non-prosecution. Office has raised objections on this application. However, having regard to the fact that the petitioner, however, accepting the reason assigned for not filing the application in time, IA 1 of 23 is allowed, and the delay in filing the application is condoned. In view of the order passed on IA 1 of 23, and since the petitioner is pursuing a substantial remedy, IA 2 of 23 is allowed, and the order dated so and so is recalled. ಎಷ್ಟು ಕಾಸ್ಟ್ ಎಷ್ಟು ಕೊಡ್ತೀರಿ ರೊಡ್ಡವೀರ ಶೆಟ್ಟಿ subject to payment of cost of rupees 500 payable to the Advocates Association, High Court Unit, Kalaburagi. Within 1 week from today, failing which this order shall not be given effect to and the petition shall stand dismissed for non-prosecution. Yes. Please do the needful passover. The Gate.
Appears for petitioner one.
Ah,
Respondent herein appeared party in person. He made some
ಆಯ್ತು.
request to the honorable court, my lord, that was not
Since the
granted.
petitioner is
Summons
now-
were also served.
since the petitioner is now represented by an advocate,
No, my lord, respondent, my lord.
respondent is. no?
Respondent is also advocate, but he appeared, tried to appear in party in person.
Matter of merits,
Yes,
common merits,
please.
facts here.
My lord, this writ petition is filed, my lord, challenging the rejection of IA number 4, 5 and allowing IA number 7 for police protection. The writ petitioner is the plaintiff, my lord.
Hmm.
He filed a suit for perpetual injunction as against the defendant and sought for amendment of the plaint because there are some variation in the boundaries. Before those IAs are filed, my lord, after appearance by the defendant, he moved a memo before the honorable trial court that he should be granted an order of injunction. But meanwhile, the memo was taken on record and both the parties were directed to maintain the status quo, my lord.
Hmm.
That status quo order was till next date of hearing as per page 38, my lord.
Yes.
Order, the memo filed by the defendant is allowed. Both the parties are hereby directed to maintain the status quo in the suit settled properties as mentioned the boundaries in this plate till the next date of hearing. During pendency, during operation of this order, the plaintiff has filed IA number 4, 5, my lord. That is, the relevant portion of the order starts at page 86, my lord, wherein IA number 4, which was filed under order 26 rule 9 of CPC, praying for appointment of the court commissioner on the ground that still the evidence is not let in by other the parties. So that application came to be rejected. Then IA number 5, my lord, filed by the plaintiff under order 6 rule 17, my lord, seeking permission to amend the plaint as per the application.
Hmm.
This application also came to be rejected by order dated 26/5/2023, my lord.
At what stage of the suit you filed this application?
Even before beginning the evidence, my lord. Even evidence was not started. Before that only this IA number 5 was filed, my lord. That was rejected. And after this, my lord, the respondent herein, he files IA number 7.
Hmm.
Seeking police protection, my lord.
Hmm.
On that IA number 7, annexure A, my lord, annexure J, my lord, page 103.
Hmm.
The trial court proceeds to allow this application and directed the police concerned to give the police protection to this defendant to implement the temporary injunction order passed on IA number 2 by this court on 28/6/2022.
Hmm.
My respectful submission, my lord, on 6/6/2022, when there was already a direction to maintain the status quo by both the parties. Ignoring that order, subsequent order is being passed. And even before that, there is one more order on IA number 6 filed by the defendant, my lord, page 95.
Yes.
Page 95, my lord. Office is directed to register a separate civil miscellaneous case against the plaintiff on IA number 6. My respectful submission would be, my lord, if the court has already taken a view that the temporary injunction order is being disobeyed by the plaintiff and it requires a separate proceedings to be taken under Order 39 Rule 2A of CPC.
Yes.
Once this IA number 6 is allowed, my respect submission, my lord, filing IA number 7 and seeking police protection is an abuse of process of the procedure, my lord. So therefore, my humble submission, the orders passed on IA number 7, keeping in view of the order of status quo and also order on IA number 6, this order could not have been passed by the Honorable Trial Court.
Where is IA number 7?
IA number 7, my lord, at page 100, my lord.
Hmm.
100. Even while filing the application, my lord, the respondent himself has admitted that as per IA number 6, the Honorable Trial Court has already opened a civil miscellaneous number 22/23. When that civil miscellaneous number was already opened, my respectful submission, my lord, allowing application for giving the police protection.
The order of injunction granted in favor of the defendant.
I number 2, my lord.
Where is that order?
Please, please. Page 72, my lord. This is after the status quo order is being passed, my lord.
It's all right. Where is the order?
At page 72, my lord.
72, Defense Counsel present replied matter is passed
Yes,
for orders on IA number 2.
this is IA number 2, my lord. This was the temporary injunction as against the plaintiff, my lord, in the suit filed by the plaintiff only.
So this order is not challenged.
This order is not challenged, my lord.
So
Therefore, civil miscellaneous is open, my lord.
correct, it's a for violation. But how to enforce this order?
Already civil miscellaneous is filed, my lord. In that civil miscellaneous, certainly some inquiry has to be held, my lord.
Correct.
Yes,
To enforce the order of injunction.
yes.
Why shouldn't a police order protection be granted?
To enforce the order of injunction on IA number 2, my lord, since IA number 6 was filed, and the Honorable Trial Court has taken a view that it requires inquiry,
Astena?
39 Rule 2A.
Astena?
So because of that, my humble submission, my lord, subsequently allowing IA number 7 is not proper. And so far as rejection of the application for amendment,
Yes.
the application for amendment, at least even it was filed even before beginning of the evidence, my lord.
If they
Even
got-
issues are also not framed.
Cool. The plaintiff in OS number 134 of 2021 on the file of the civil judge, junior division, at Humna,
Is for junior division.
has filed this petition challenging the correctness of an order passed therein dated 26/5/2023, by which applications filed by him, bracket IA number 4 and 5, was rejected. The plaintiff has also challenged an order dated 8/8/2023, passed on IA number 7, providing police protection to the defendant. Next para. The suit in OS number 134 of 2021 was filed for perpetual injunction to restrain the defendant from interfering with the possession of the plaintiff in the suit scheduled property. Full stop. The suit property was land bearing survey number 91/2 of Kattalli, Humnabad Taluk, Bidar district, measuring 4 acres, 4
Yes, sir.
acres.
4 acres. My lord.
Full stop. The suit was contested by the defendant, who also raised a counterclaim and sought for perpetual injunction against the plaintiff in respect of the land bearing survey number 91/2D, measuring 4 acres and 91/2E measuring 1 acre 25 guntas situated at Kattalli village. Full stop. Next para. When the suit was issues frame agilina,
ಏನಾಗಿಲ್ಲ ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ.
stop. Before the issues were framed in the suit, the plaintiff filed IA number 4 under Order 26 Rule 9 of CPC for appointment of a commissioner for a local inspection of the suit property as per the memo of instructions attached to the application. Full stop. He also filed an application, a memo of instruction. This application was contested by the defendants on various grounds, including that an application for appointment of a commissioner could not be entertained even before evidence in the suit had commenced. Full stop. The plaintiff also filed an application under Order 6 Rule 17 of CPC to incorporate an additional relief of declaration of title to the suit shell property. Declaration in respect of 5 acre 26 guntas in survey number 91/2. Full stop. He also sought to introduce additional pleadings in support of his in support of the relief of declaration of title, and also sought to introduce the boundaries of the land bearing survey number 92/1, 91/2. Full stop. This application was also contested by the defendants, who claimed that the plaintiff claimed that the amendment changed the nature of the suit as well as the cause of action. Full stop. Next para. The defendant filed IA number 2 for interim injunction to restrain the plaintiff from interfering with his possession in the land bearing survey numbers so and so. As the 91/2E, 2D and Itala of Kattalli village. The trial court, after considering the application filed by the defendant, passed an order dated page 72 Allah.
Yes, my lord. Same 26/5.
Order dated
23, my lord.
28/6/2020.
That was yes, ma'am. Yes, sir.
Granting interim injunction to restrain the plaintiff from causing obstruction or interference with the possession of the defendants in the land bearing survey number 91/2D and 91/2E of Kattalli village. Full stop. Later, the defendant filed IA number 6 under Order 39 Rule 2A of CPC, alleging that the plaintiff had violated the order of injunction granted, interim injunction granted. So the trial court directed registration of a civil miscellaneous case. Full stop. Later, the defendant filed IA number 7 for police protection to implement the order of injunction granted on 28/6/2022. Full stop. The trial court, after considering the contentions of the plaintiffs as well as the defendant on IA number 4 and 5, rejected both the applications on the ground that an application for appointment of commissioner cannot be, on the ground that a commissioner cannot be appointed for local inspection in a suit for injunction, that too before the evidence of the parties was adduced. It also held that the amendment sought for by the plaintiff would change the nature of the suit as well as the cause of action. Full stop. Insofar as IA number 7 is concerned, the trial court held that the plaintiff defendants is entitled to protect his possession by enforcing the order of injunction dated 28/6/2022 and thus allowed the application. So being agreed by the aforesaid orders, the plaintiff is before this court. Next para. The learned counsel for the plaintiff contended that the defendant had raised a counterclaim in respect of the land bearing survey number 91/2D and 91/2E, measuring 5 acres 25 guntas. He submits that since the defendant had raised a contention that he was the owner of the property claimed in the counterclaim, the plaintiff was advised to seek for declaration of his title to the suit property. He submits that since the amendment sought for was prior to the framing of issues, the court must have allowed the application so as to avoid multiplicity of proceedings. Full stop. Full stop. He also contended that the need to seek for amendment of the suit arose in view of the peculiar defenses raised by the defendant in the written statement. Insofar as IA and Order 26 Rule 9 of CPC is concerned, the learned counsel contended that in the memo of instructions attached to the application, the plaintiff wanted a local inspection of the land so as to record the specific characteristics of the suit property. Full stop. Therefore, he contends that this did not in any way amount to collection of evidence, and therefore the court must have allowed the application. As regards the application filed by the defendant, IA number 7 for interim injunction which was granted, the learned counsel contended that when the court had already registered civil miscellaneous case on IA number 6 for alleged violation of the order of injunction, there was no need to grant police protection to the defendant to enforce the order of injunction dated 28/6/2022. Next para. The defendant, though served with the notice of the suit, had entered appearance, has not filed the prescribed form number C to appear in person. As stated above, the suit is filed for perpetual injunction in respect of 4 acres of land in survey number 91/2. The defendant entered appearance and claimed that he was the owner of the land bearing survey number 91/2D and 2E, measuring 5 acres 25 guntas. Full stop. Thus, the plaintiff was bound to establish his better title to the suit property.
With kind permission, there are two server numbers he is claiming, Manoj.
Yeah,
That's 91/2D and 91/2E.
Thus, the plaintiff was bound to establish his better title to the suit shell property. Full stop. Since the amendment sought for to include the relief of declaration of title of the plaintiff to the suit shell property was in view of the specific defense raised by the defendant, the court below must have allowed the application so as to avoid multiplicity of proceedings. And also since the amendment sought for was prior to the framing of issues. Full stop. Under the circumstances, the application filed by the plaintiff to amend the plaint deserves to be allowed. Next, for insofar as the application filed by the plaintiff and Order 26 Rule 9 of CPC is concerned, the plaintiff, even before the evidence in the suit had commenced, tried to get the facts elucidated through the appointment of a commissioner, which is impermissible in law. Full stop. The plaintiff is bound to establish the facts set out by him in the memo of instructions in the course of his evidence. It is only upon the trial court being satisfied that there is a need to appoint a commissioner that an application for local inspection can be entertained. In that view of the matter, the application filed by the plaintiff deserves to be rejected for the present, with reserving liberty to the plaintiff to file necessary application only after the evidence in the suit is completed. Full stop. Insofar as the order passed on IA number 7 is concerned, the plaintiff did not challenge the order of injunction granted in respect of order of injunction granted in favor of the defendant to restrain the plaintiff from interfering with the possession of the defendant in the land bearing survey number 91/2D and 2E of Kattalli village. Full stop. Therefore, the defendant is entitled to enforce the order of injunction through all possible means. The plaintiff, having once suffered an order of injunction, cannot overreach the process of the law by interfering with the possession of the defendant. In that view of the matter, the impugned order passed by the trial court on IA number 7 does not merit any interference. Full stop. Consequently, the following order is passed. The writ petition is allowed in part. The application filed by the plaintiff under Order 6 Rule 17 of CPC to amend the plaint and incorporate the relief of declaration of title and for incorporation of additional pleadings and additional pleadings and the boundaries of the property is allowed. So the plaintiff is at liberty. The plaintiff shall amend the plaint. So it is open for the defendant to file any written statement if so advised. Number 2, the application filed by the plaintiff under Order 26 Rule 9 of CPC is rejected. However, liberty is reserved to the plaintiff to file appropriate application for local inspection after the evidence of the parties is concluded. Number 3, the order passed by the trial court on IA number 7 granting police protection to the defendant to implement the order of injunction dated 26/2022 is upheld. Full stop. Yes.
Much obliged.
Here, Ramchandra
Kindly grant week's time, I will need,
is granted to do the need.
please.
Yeah, respondent, yeah,
But he is not available to.
standing
serve-
counsel ilva.
Tirumalesh is there, my lord, but he is not available to serve the cop.
Not available ಅಂದ್ರೆ ಅವ್ರು ಎಲ್ಲಿದ್ರೆ ಅಲ್ಲಿ ಹುಡ್ಕೊಂಡು ಹೋಗ್ಬೇಕು. ತಿರುಮಲೇಶ್ ಇಲ್ಲಿ
Please,
ಬರಲ್ವಲ್ಲ.
week's time within a way,
ಬೆಂಗಳೂರಲ್ಲಿ ಇರೋದು.
please.
1 week time is granted to do the needful. In addition, learned counsel for the petitioner is directed to serve Mr. M. Tirumalesh, who appears for the respondent.
Please.
Yes.
All the respondents are represented by government.
1 to 4, huh?
1 to 4.
AGA is directed to accept notice for HCGP and AGA is directed to accept notice for response 1 to 4. Counsel for the petitioner is directed to serve a complete set of the writ petition to learn AGA. Yes, list on
One date, maybe.
3 weeks.
Till 21. Since it's a small matter,
Objection act.
it's
Next, Nitesh Padiyal. List after
Appear-
service of notice to respondent.
It may be dispensed, madam. She is sister of the deceased, she is sister of petitioner number 2, madam. It may be dispensed.
Learned counsel for the petitioner seeks dispensation of notice to respondent number 4. The submission is noted and the notice to respondent number 4 is dispensed. List
Sure.
on date.
Short matter, my lord. Compassionate appointment,
Manvendra Reddy.
compassionate appointment.
Manvendra
Good.
Reddy.
My lord, on short matter, compassionate appointment.
Bharat, ಯಾವ ಒಂದು date? This memo for withdrawal.
Please.
Memo is filed to withdraw the writ petition.
One submission, the matter was settled, my lord. There, what happened, my lord, under this order, the plaintiff has, with the apprehension that suit will go against them, they have deposited 10 lakhs rupees, my lord. So my submission, my lord, the order we challenge, my lord, that regarding referring the compounding the document to the sub-registrar, my lord. Page, I will I have challenged this order at page, my lord. 104, my lord. 104, my lord.
ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಅಂತಿದೆ.
ಈ 10 ಲಕ್ಷ ಏನ್ ನಾವು ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದೇವೆ ಅಂಡರ್ ದಿಸ್ ಆರ್ಡರ್, that will be losing plaintiff. Therefore, settlement ಆಗ್ಯದ. If this order goes, my lord, they will get 10 lakhs rupees.
ಏನಿದು ಸೆಕ್ಷನ್ 33 ಆರ್ಡರ್ ಏನಿದು?
ಇದು 34 ನಾಗ ಮಾಡಿದಾರ, my lord. They ought to have been referred to a district registrar in with the light of the recent judgment of Apex Court.
ಏನಂತಿದ್ದು? IA number 20 filed by the plaintiff under section 37 of the Karnataka Stamp Act is hereby rejected.
Yes, my lord. In that view, the matter, I will not press that IA and it will be disposed of. They'll get that benefit of 10 lakhs. That is my answer.
Yes, I'm undertake that 1 to 4. I'm undertake that 1 to 4 ಗೆ appear ಆಗ್ತೀನಿ. Trial court advocate inform ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲಿ ವಿಡ್ರಾ ಮಾಡ್ತಿದೀವಿ ಅಂತ ಹೇಳ್ತಿದ್ರಲ್ಲ.
ಅಲ್ಲ, suit settlement
Good settle ಆಗಿದೆ after this order of the.
So this, only this hurdle, my lord, I will be losing because I have paid 10 lakhs by order dated.
ಅಲ್ಲ, ರೀಫಂಡ್ ಕ್ಲೇಮ್ ಮಾಡ್ಕೊಳ್ಳಿ ಇಲ್ಲಿ.
ಇಲ್ಲ, ಅವರು ಬರೋದಿಲ್ಲ ಅಂತ, unless this order is there.
ಸರ್, ರೀಫಂಡ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೆಂಗ್?
ಇಲ್ಲ, ಕೋರ್ಟ್ ಫೀ ಅಲ್ಲ ಸರ್, ಇದು this
ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿನೇ.
This has been paid as per the order of sub registrar.
ಸೆಕ್ಷನ್ 38 ಓದಿ ಕೊಡ್ರಿ ಅವರು.
Assignment of stamp duty by deputy commissioner or reference being made with the trial court procedure discretion comes from deputy commissioner. ಅದೇ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಬಲ್ಲಿ ಆಗೇ ಇಲ್ಲ ಆರ್ಡರ್ ಅಗೇನ್ಸ್ಟ್.
ಅಲ್ಲ, ಇವಾಗ ಕಲೆಕ್ಷನ್ ಆಯ್ತಲ್ವಾ?
ಮಲ್ಲ
ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಕಟ್ಟಿದಿರಾ?
ಒಂದು 10 ಲಕ್ಷ ಕಟ್ಟಿದ್ದೇವೆ.
ಟೋಟಲ್ ಅಮೌಂಟ್ ಪೇಯಬಲ್ ಇಸ್
65 lakhs. Suit dismiss ಮಾಡ್ತೇವೆ on the threat we have paid 10 lakhs rupees. After paying 10 lakhs, I have filed a writ petition. That is a hurdle. In law,
ಆಯ್ತು, then will permit you to go before the deputy commissioner and seek for refund. ಈಗ ದುಡ್ಡು ಕಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ದುಡ್ಡು ಕಟ್ಬಿಟ್ಟಿದ್ದೀವಿ.
ಅದು ಗವರ್ಮೆಂಟ್ ಹೋಗ್ಬಿಡ್ತದು.
ಅದೇ
ನೀವು ಗವರ್ಮೆಂಟ್ ಇಂದ ವಾಪಸ್ ತಗೋಬೇಕು ಅಂದ್ರೆ ಕೋರ್ಟ್ ಕೆನಾಟ್ ಡೈರೆಕ್ಟ್.
ಇಲ್ಲ, I am not, if this writ petition is allowed, then I will get the benefit ಅಂತ ನಂದು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಯಾಕಂದ್ರೆ the very jurisdiction of referring the matter to sub-registrar is unknown to law. As per 37, they should refer for compounding the document 37 as per even Apex Court judgment also. So if that order goes, then automatically I will have a benefit of receiving party to object. Impounding and refer to a district registrar ಅಂತ ಇದೆ, page 1076.
ಹೌದು, ಡಿಸ್ಟ್ರಿಕ್ಟ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಗೆ ಹೋಗ್ಬೇಕು.
But the trial court has referred to sub-registrar, man, and sub-registrar has compounded the document. Now note the page 104, my lord. Hence, both the documents are impounded. Office to send a copy of agreement of sale dated to the sub-registrar Bidar, and sub-registrar Bidar has calculated 65 lakhs. So that whole procedure adopted by the trial court is wrong. If this order goes,
ಸಬ್ ಬೀದಕ್ ಕಳ್ಸಿರೋದು ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಎಷ್ಟು ಕಲೆಕ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅಷ್ಟೇ. Now the senior civil judge has followed the judgment of the division bench of this court.
Yes.
ಯಾವ್ದು ಎಂತದ್ರಿ ಇದು? 2005 ILR 2005 ಜಸ್ಟಿಸ್ ಕುಮಾರ್ ಅವ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಇತ್ತಲ್ಲ, ಯಾವ್ದು?
compound ಆಗಿಲ್ಲ ಸರ್, ಡಾಕ್ಯುಮೆಂಟೇ compound ಆಗಿದೆ.
ಭಾರತಿ
ಕಾಂಪೌಂಡಿಂಗ್ ಆಗೇ ಇಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್.
ಇಂಪೌಂಡ್ ಆಗಿದೆಯಲ್ಲ?
ಆಗಿಲ್ಲ.
ಇಂಪೌಂಡ್ ಆಗದೆ ಹೆಂಗ್ ಕಳಿಸ್ತಾರೆ?
That's what my
ಸರ್, ಇಂಪೌಂಡ್ ಆಗಿದೆ ನೋಡಿ ಸರ್, ಪೇಜ್ 104 ಬನ್ನಿ ಸರ್.
104 is
both the documents are impounded. Impound ಆಗಿದೆಯಲ್ಲ?
the argument, one argument and concept and stamp duty agreement of the documents declared, possession delivered. both the documents are not registered. No proper stamp duty is paid. Hence, both the documents have to sub-register.
Are impounded. Impounded is ನೋಡಿ. Hence both documents are impounded.
No proper stamp duty is paid, hence both the documents are impounded.
The
But-
document is impounded. The division bench of this court said, once a insufficient document, stamp duty is paid,
Yeah.
then the court has no other option than to collect 10 times and duty and send it to the district registrar for appropriate action under section 37.
37 daga.
Who will permit you to go before the district registrar and seek for refund or whatever. Very cool. A memo is filed to withdraw the writ petition. In view of the memo, the petition is dismissed as withdrawn. However, liberty is reserved to the petitioner to approach the concerned deputy commissioner or district registrar for refund of the penalty paid. For refund of the penalty paid in OS number 58/2017 in respect of the agreements bearing agreements dated 28/5/2008 and 19/2016. Yes. Notice is awaited. Awaiting service of notice in respect of R3. Yaar R3 yaar.
R3 is one of the, my lord, my brother.
Retrieve plaintiff or defendant.
My lord, he is a defendant.
And what have we challenged?
My lord, challenging the order of the, my lord, trial court, by the, in RA. My lord, a suit for partition and it was decreed. And FDP is filed, my lord, FDP was also disposed of. That order have challenged in RA. And because of the not, my lord, marketing.
List after service of notice to respond number 3.
There is interim order.
Interim order granted and is extended to the next. Respond number 15. Ashok Moolage.
The writ petition become impractical.
Practice apa.
Annexure C has been challenged.
Will undertake to file wakalat for respond number 10 months.
Panchayati ka sabhenu nadasalagudu adu dinaka neevu.
Annexure C, my lord.
No confidence.
Yes, Mr.
Barcode. The petitioner has challenged the no confidence motion against him. Imma Harra against her.
Her.
Which was held on 17/12/2024. Since the no confidence motion is passed successfully against the petitioner, this writ petition does not survive for consideration. Hence, the petition is dismissed.
Serial number 12, I represent the petitioner, my lord.
Rohit Nagesh.
Serial number 12, I represent the petitioner, my lord. Lords, it's await service of notice, my lords.
List after service of notice.
Interim order may kindly be extended, my lords. My lords, interim order is there.
I heard it.
Please, my lords. Sorry, my lord. Sorry, my lord.
List after service of notice to response 1 and 2. Interim order granted early is extended till the next date.
Much obliged, my lord.
Anna Raya.
My lord, seal number 13, my lords, I appear for the petitioner. My lord, in this case, on the last date of hearing, after issuance of notice, there is an order passed for consideration.
Objection 27 in office objection 27.
My lord, the annexure E, my lords, it is not legible. Page number 28, my lords. That is the office objection. My lords, right now I'm not relying upon it, my lords. It is not.
For the petitioner submits that he would not rely upon annexure E.
Page 28, my lords. That is the sharattugalu anta conditions ಇದೆ, my lords.
Be that as it may, since annexure E is legible, office objection is overruled. Yes, Mr. What is the case?
My lord, here in this petition, I have challenged the constitutional validity of section 32(5) of the Karnataka Urban Development Authorities Act. Because, my lord, the private layout which was formed by me was, at the time of approval of the layout, the condition precedent was to relinquish civic community sites to the Urban Development Authority, Bijapur Urban Development Authority. Accordingly, I have done it, my lords, and thereafter they have been allotting it to private parties. My lord, my colleague Anna Rai is producing one memo. There are certain developments in this matter. With respect to the very same issue, my lords, the division bench of this honorable court has dismissed the petition. Document number 1, my lords, page number 2, my lords, if your lordships may kindly peruse.
Yes.
Judgment reported in ILR 2007, Karnataka 755.
Hmm.
My lord, here the constitutional validity was upheld, stating that relinquishment does not amount to acquisition, hence the owners of the land are not entitled for compensation. And my lords, this order was further relied upon another division bench judgment at page number 12, my lords.
Hmm.
My lord, this has been carried to the Honorable Supreme Court at page number 15, my lords. Along with this case, I am told that there are around 25 to 30 matters which are pending before the Honorable Supreme Court, wherein at page number 15, my lords, the order passed is status quo in regard to the civic community sites in the layouts in dispute.
No, but when did you execute the relinquishment deed?
My lord,
When did you execute the relinquishment deed?
my lords, in the year 2022, my lords.
22.
Please, my lords.
Then what is the interim order that has to be granted to you?
My lords, similar to the orders granted by the Honorable Supreme Court, wherein status quo needs to be maintained with respect to allotment of those civic community sites, because the larger issue is being heard, my lords, by the Honorable Supreme Court, and it has been stated that status quo needs to be maintained, and it is the same Urban Development Authority, my lords, the Bijapur Urban Development Authority. With respect to some of the layouts, they are maintaining status quo for allotment of civic community sites to third parties.
Where is the order of status quo passed by the Supreme Court?
My lords, page number 50, my lords, in the memo which I have produced, document number 3.
Who appears for this Bijapur?
Let's,
Amaresh Rosana?
Same.
Vijaypur Development Authority. SS Harali. Urban AG is directed to accept notice for respond number 1. Mr. SS Harali, na? SS Harali for R2. Issue emergent notice to respondent number 3.
Let's notice was ordered, my lords, on the last date of hearing. I will serve copies on Mr. Roja, my lords. Notice has been ordered.
In view of the statement of the learned counsel for the petitioner, that the question whether relinquishment of civic community sites amounts to acquisition or not is pending consideration before the Honorable Supreme Court in SLP Civil, in SLP 8459/2009 and other petitions, where the Honorable Apex Court has granted an order of status quo in respect of the civic community sites, the petitioner is also entitled to a similar relief. Consequently, the respondent number 2 is directed to maintain status quo in respect of the civic amenity sites formed in the layout in survey number?
My lord, 97, my lords.
97 of?
In Mahal Bagayat village, Vijaypur Taluk.
Mahal Bagayat village, Vijaypur Taluk. PF Katilva ನೀವು?
Lords, today it has been done, my lords. Needful has been done.
Yes.
Much obliged.
Learned counsel for the petitioner submits the process is paid to issue notice to respondent number 2 and 3. If the process is in order, office is directed to issue notice to respondent number 2 and 3. Yes.
Much obliged.
Shivlinga Swami. ಏನಿದು ನೀವು ಇಷ್ಟೊಂದು ಕೇಸ್ಗಳು ಆಗ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಇದು ಒಂದೇ
ಹಾ?
ಇಲ್ಲ ಜಾಸ್ತಿ ಹಾಕಿಲ್ಲ ಮೇಡಮ್.
ಏನಕ್ಕಿದು?
ಇದು ಎಜುಕೇಶನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಕನ್ಸರ್ನ್ ಇದೆ ಮೇಡಮ್.
AG is directed to accept notice for respondents 1 to 7, 8, 1 to 9. Office objection 27 ಏನಿದೆ? Office objection at serial number 27 shall be considered later. Copy ಕೊಡಿ ಅವ್ರಿಗೆ. ಗೌರ್ಮೆಂಟ್ ಕಾಪಿ ಕೊಡಿ.
ಸರ್ ಮಾಡಿದ್ವಿ.
ಮಾಡಿದ್ಯಾ?
Sir.
ಮತ್ತೇನು?
So secure the documents ಅಂತ ಹೇಳಿ previous occasion that direction. ಇಲ್ಲ ಇನ್ನ secure ಆಗಿಲ್ಲ. So 1-2 weeks time 23.
Current SCGP seeks time to secure documents, records as per order dated 19/12/24. List on
23.
20th.
20th.
Till that may grant me the stay for the annexer came. Still that have
No
to
stay.
grant.
No stay. Yes, next. Satish Kumar Gadkar. Satish Kumar Gadkar. There is no representation for the petitioner. List on date. Shri Hari Kutsa.
Appear for petitioner, my lord. Office objection has to be complied. Maybe 1 week time may be granted. Interim stay may be extended.
1 week time is granted. Interim order granted is extended till the next date of hearing.
Much obliged. Much
If
obliged.
office objections are not complied within 1 week, the interim order granted on so and so date shall stand vacated automatically.
Much obliged.
Rato, list after service of notice respondent. Interim
week's
order
time may
ಇದೆಯಾ?
be granted. A week's time may be granted for compliance of his objection.
1 week time is granted to do the needful. ನೀವು ನೋಟಿಸ್ ಇಶ್ಯೂ ಆದ್ಮೇಲೆ ಯಾಕೆ ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ?
ನೋಡೋದು ಹಾಲಿಡೇಸ್ ಬಂದಿದಾಗ ಅದು
ಮಾಡಿ
ಮಾಡಿಲ್ಲ.
ಪಾಸ್
Yes. Yes.
ಪ್ಲೀಸ್ ಕಂಪ್ಲೀಟ್ ಪಾಸ್ ಓವರ್.
My lord, it is also infructuous, my lord.
Huh?
Already no confidence motion held on 3/1/2020.
Challenge the notice of no confidence motion. Full stop. It is now stated at the bar that the no confidence motion was held on
3/1/2020.
Kindly pass over.
3/1/2025.
25.
Connected of the matter.
Submission.
One submission.
Kindly.
In one connected matter, in that matter, on no conference meeting was conducted 2/1/2024.
Connected matter.
Connected matter. There are two matters.
First matter held re.
First matter only 3/1.
3/1.
Submission.
In second matter,
Kindly pass over minutes.
For what?
Senior counsel has been engaged. Kindly pass over.
Sorry, inconvenience. Serial number 16 interim order ಇದೆ ಸ್ವಾಮಿ.
Serial number 16 ಅಲ್ಲಿ ಏನೋ entry ಮಾಡಿದ್ರೆ. ನೀವು ಕರ್ದಾಗ ಬಂದಿಲ್ಲ, ನೀವು ಕೇಸ್ ಕರ್ದಾಗ ಬರ್ಲಿಲ್ಲ. Serial number 16 ಅಲ್ಲಿ. It's already extended. Why are you disturbing the court? You should wait for your turn. ನಿಮ್ಗೆ ಹೇಳ್ತಾರೆ ಯಾದವ್. 16 ಕೇಸ್ ಕರ್ದಾಯ್ತಲ್ಲ.
My colleague was there.
ಕರ್ದಾಯ್ತು, entry ಮಾಡಿದ್ರೆ extend ಆಯ್ತು.
Please.
ನೀವು ಇಲ್ಲಿ ಬಂದು ಕೇಳ್ಬೇಕು. Don't disturb the court procedure.
Sorry.
Regard to the
Objection number
submission, eligible copy of
ನೋಡ್ಬೇಕ್ರಿ ನೀವು. ನಾನ್ ಕೇಳ್ದ ನೋಡ್ಬೇಕು. Eligible copy of annexure G.
It is a readable, they not relied that the judgment.
The learned counsel for the petitioner submits that he would not rely upon annexure G. Therefore, the office objection at serial number 27 is overruled.
One more,
Full stop. Since the petitioner is a proprietary concern represented by its proprietor, there is no need to affix the proprietor's seal. Full stop. Hence, office objection serial number 31 is also overruled.
please. Now the
Yes.
matter pertaining the laying the road,
Yeah?
road, which is the sanction as per annexure A1, kindly peruse the agreement pertaining in page 10, second line, in Kalaburagi Taluka, Kalaburagi district, improvement of the road from the ring road NS 218 to Kusnur to via Azadpur.
ಎಲ್ಲಿ
That is,
ಓದ್ತಾ ಇದ್ದೀರಾ? Where are reading?
please, page number 10.
ಹಾ.
ಎರಡನೇ ಲೈನ್ ಕಲಬುರ್ಗಿ ಇನ್ ಕಲಬುರ್ಗಿ ತಾಲೂಕು ಮ್ಯಾಗಿಂದು ಶಾಪುರ್ದು ಇದೆ.
Page number 10
10 ಮೂರನೇ ಲೈನ್
ಹಾ.
ಇನ್ ಕಲಬುರ್ಗಿ ತಾಲೂಕಾ ಆಫ್ ಕಲಬುರ್ಗಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಬಿ ಇಂಪ್ರೂವ್ಮೆಂಟ್ ರೋಡ್ ಫ್ರಮ್ ರಿಂಗ್ ರೋಡ್ NS 218 to Kusnur to Azadpur. That is a Kusnur to Azadpur road. Again, will be notice to annexure A1. Notice to proceed the work will be issued on 27/8/2024. It is the same road. I will be take lordship will be attention whether they are proceeding the as per annexure A1 and A1. I will be produce the map of the Taluka village. Now they take the indicated the road of the 218 NS. Now the proceeding the work in respect of the Hagarga road, NS state highway. Therefore, they have no right to lay the road in respect of Gulbarga to Hagarga road.
How are you aggrieved?
I am the become the owner of the land pertaining the Hagarga village, abutting to the my 100-feet road.
How are you aggrieved, sir? How are you aggrieved?
Because of the Hagarga road now will be 100-feet wide road. Now I will be abutting to the 100-feet road, plot number 16770 134, just to abutting. Now by taking the particle influence, now they laid the road only 66 feet to reducing the road 100 feet instead of 100 feet, reducing 66 feet. Ultimately, I'll be encroacher or creating some document. Ultimately I'll be obstructed to my right to enjoy my property.
Yes, madam.
I will take the notice.
Percol, AG is directed to accept notice for respondents.
SCGP.
Sorry, HCGP is directed to accept notice for respondents 1, 2, 3, 4, 5,
7.
7.
and 7. Yes, list on yavat.
Interim order, my lords. Because of will be take not
No, sorry,
precipitate.
no interim order. List on yavat.
2 weeks, your lordship.
No.
22 or
List
22?
on.
22.
Get instructions as to whether
It laid the road or not. It will be.
learned HCGP is directed to secure instructions whether there is any official document authorizing the laying of Hungarga Road.
Hagarga village road.
Hagarga Village Road. Yes. List on.
My lord,
7th.
because of the matter, work is proceeding on. If it is a proceed, again will be maybe writ petition will be in place.
Agalla.
It will be short date, otherwise.
27th.
27.
Next.
Please.
Still submission is with regard to my lord.
Yenido? What is the office objection?
Office of, I have given submission stating that my lord, since there are number of petitioners, the signatures of few petitioners are obtained on the blank paper, my lord, which can be treated as, my lord, executed on the wakalat itself.
Yeah, blank paper.
On white sheet, my lord, signatures have been taken. However, my lord, petitioner, one of the petitioner is signed on the wakalat, regular wakalat.
So how can we take this, Mr.?
For the time being, my lord, I may be.
Time being, ಇದಕ್ಕೆ ಸೈನ್ ಮಾಡೋದು ಅದಕ್ಕೆ ಯಾಕೆ ಮಾಡಕ್ಕಾಗಲ್ಲ? Time being ಆಗಲ್ಲ. Please produce a wakalat.
There is no sufficient space in order to get.
ವಕಾಲ್ ಸಿಲ್ವಾ?
ಅಲ್ಲ, sufficient.
ಅಲ್ಲ ವಕಾಲ್ ಸಿಗಲ್ವಾ ಕಲಬುರ್ಗಿನಲ್ಲಿ?
My lord, It is very difficult, my lord.
ನೋಡಿ ಎಷ್ಟು ಬುದ್ಧಿವಂತರು, ಇಷ್ಟೊಂದು ವಕಾಲತಿ ಹಾಕಿದ್ರೆ ಅಷ್ಟು ವೆಲ್ಫೇರ್ ಸ್ಟ್ಯಾಂಪ್ ಹಾಕ್ಬೇಕು.
No, my lord. I'll undertake, my lord, to pay stamp duty, my lord.
Fresh ವಕಾಲತಿ.
It is.
Office object.
My lord. It is election matter, my lord. On 12th, the elections are scheduled. I'll pay, my lord.
ಹಂಗಿದ್ರೆ ಯಾರೋ ಒಬ್ಬನ್ನ ಹಾಕಿಸ್ರಿ.
ಒಬ್ರದ್ದು ಹಾಕಿದೀನಿ.
ಅದೇ ಆಯ್ತು, ಹಂಗಿದ್ರೆ you will restrict your writ petition only to that person.
Voting rights, my lord, I am seeking.
They are all ineligible voters. That's why they have made party, my lord.
My lord, I am seeking voting rights, my lord, in respect
ಫಸ್ಟ್
of.
ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಕಟ್ಟಿ ಎಲ್ಲ
I'll pay.
ಒಬ್ಬೊಬ್ರಿಗೂ ಕಟ್ಟಬೇಕು. ಒಬ್ಬೊಬ್ರಿಗೂ ಕಟ್ಟಬೇಕು ನೀವು. ನೀವು ಬುದ್ಧಿವಂತಿಕೆ ಉಪಯೋಗಿಸಿದ್ರೆ ನಾವು ಬುದ್ಧಿವಂತಿಕೆ ಉಪಯೋಗಿಸ್ತೀವಿ.
I am not on that point.
ಒಬ್ಬೊಬ್ರಿಗೂ ನೀವು ವೆಲ್ಫೇರ್ ಫಂಡ್ ಸ್ಟಾಂಪ್ ಕಟ್ಟಿ. ವೆಲ್ಫೇರ್ ಕಟ್ಟಿ.
Each page, my lord, 50 I have to affix.
ಈಚ್ ಪೇಜ್ ಅಲ್ಲ, ಅದೇ ಹೇಳದ್ನಲ್ಲ, ನೀವು ಬುದ್ಧಿವಂತಿಕೆ ಉಪಯೋಗಿಸಿದ್ರೆ ನಾವು.
No, my lord, I am not on.
ವಾಟ್ ಎಲ್ಸ್ ಇಸ್ ಇಟ್ ಮಿಸ್ಟರ್?
I'll undertake.
ಮಾಡಿ, ಫಸ್ಟ್ ಮಾಡಿ, ಆಮೇಲೆ ನೋಡೋಣ. ಪಾಸ್ ಓವರ್
Please.
Lord, I appear for the petitioner, my lords. Lords, the office of raised objection regarding the typed copy of annexure C9 to C14, my lords. Those are the enclosures of the respondent number 5, my lords, who was enclosed along with his application, my lords.
ಟೈಪ್ ಕಾಪಿ ಹಾಕ್ಬೇಕಲ್ವಾ?
Yes, my lords. I'll undertake to submit that during the course, my lords.
Counsel for the
My lords.
petitioner is directed to
Once,
furnish type copies of annexures C9, C10, C11 to
for
C14.
time being, I'm not relying upon that because the respondent number 5 has to.
Time being ಅಲ್ಲ, will you rely upon it or not?
As of now, my lords, I'm not relying, my lords.
As of now, ಒಂದು produce the, ಹೇಳಿ.
My lords. My lords, petitioner is challenging the appointment order of Gram Sahayaka, my lords, of respondent number 5, my lords. Petitioner being the meritorious candidate than respondent number 5, my lords, without following the government order, GO, my lords, and without specifying as to why the petitioner was not appointed by the annexure D, my lords. Yes, one line order has been passed regarding appointment of
How
respondent.
are you more meritorious?
My lords, as per the government GO, my lords, the family of the Walikar's family has to apply for the application for the post of Gram Sahayaka, my lords, wherein I have enclosed the order copy of my father as well as my sister, who has been appointed as a Gram Sahayaka earlier, my lords, and who was working as a Walikar, my lords.
ಇವರು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5 ಅವ್ರ ಗ್ರಾಮ ಸಹಾಯಕ ಇದು ಅವರು ಇವರಲ್ವ ತಳವಾರಲ್ವಾ?
Talwar idar, my lords, but he has not enclosed any of the documents to show that his family was doing Walikari, my lords. And moreover, my lords, in the 10th marks card, my lords, the petitioner is having more marks than the respondent number 5 also, my lords. That is also another ground.
10th marks ಕಾರ್ಡ್ ಬರೋದಿಲ್ವಲ್ಲ ಗ್ರಾಮ ಸಹಾಯಕಗೆ?
No, my lords, the education. Yes, my lords.
The purpose of gram sahayak was
Yes, my lords.
village office abolition ಆದ್ಮೇಲೆ ಅವ್ರಿಗೇನ್
Yes.
ಕೆಲಸ ಇರಲ್ಲ.
Yes, my lords.
ಅದಕ್ಕೆ ಒಂದು ಕೆಲಸ ಕೊಡೋದು ಗ್ರಾಮ ಸಹಾಯಕ್.
Yes, my lords.
So are you a gram sahayak of the same village?
My father and my sister was working, my lords, and to that I have enclosed the annexure as well, my lords.
Yes, what about respondent number 5?
Respondent number 5, my lords, he has only given the statement that his family was doing Walikari, my lords. Apart from that, no order has been enclosed along with the application, my lords. The statement of the respondent number 5 is I have enclosed at page number 40, my lords, type copy C.
Page number?
Page number 40, my lords. This is the only thing he has referred to. He had given statement before the assistant commissioner, before the Tahsildar, my lords.
You had also applied?
Yes, I have also applied, my lords. I have enclosed the order copy of my father as well as my sister along with the state.
Issue the AG is directed to accept notice for response 1 to 4. Issue emergent notice to respondent number 5. The appointment of the respondent number 5 as Gram Sahayak of so-and-so village
Devargipurgi.
is stayed till the next date of hearing.
Please.
The copy of this order shall not be furnished and shall not be uploaded unless the typed copy of annexures C9, C10, C11 to C14 are furnished. Yes.
Please, my lords, oblige.
27. Annexure D. Annexure D.
ಯಾವ್ದು?
There is no appearance for the petitioner. The office objection to furnish type copy of Annexure D is overruled. This is the petition for preliminary hearing on statehood. Yes, Mamdapur.
Yes. Let's page number 12, annexure B.
27 office objection.
Let's document at annexure B is mutilated. It is incomplete. Original nu hage ide. There is imminent threat of demolition and eviction. Lots.
What is Annexure B?
Annexure B is a rent deed in respect of lots petitioner number 2. It is a very old document. Original nu ashte ಉಳಿದ್ಬಿಟ್ಟಿದೆ ಸ್ವಾಮಿ.
ಏನು ಇಲ್ವಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ಕೆ ಏನಿದೆ ಅಲ್ಲಿ?
ಇಲ್ಲಿ ಒರಿಜಿನಲ್ ಅದಕ್ಕೆ ಅದು ಒಂದು ಪೋರ್ಷನ್ 25% of the document, but name is there and it is also.
ಇದ್ರಲ್ಲಿ ಏನಿದೆ? ಅಂಜುಮನ್ ಇಸ್ಲಾಮಿಯಾ.
ಅವರು they have inducted the second petitioner as a tenant in their property. Let's now these petitioners, they are tenants in notified Wakf property in survey number 1029. Now, respondents 9 and 10, they approach Deputy Commissioner Vijaypur to take action for eviction of the petitioners and other persons who are occupying CTS 1029. Pursuant to that, the Deputy Commissioner, he addresses a letter to the Assistant Commissioner Sindhi to take action for eviction of the occupants of the land. Since no action was taken, 2 writ petitions were filed. One is at Annexure D, page number 14, that is filed by respondent number 9. This Honorable Court holding that internal page, page number 20, holding that there is no notice issued to the occupants of the land, no inquiries held, and the order passed by the Deputy Commissioner cannot be implemented. However, liberty was reserved to initiate action in accordance with law. Thereafter, one more writ petition was filed by respondent number 10, Annexure E. In this writ petition, there is only a writ of mandamus to consider the representation. There is no any positive order passed by this Honorable Court directing eviction of the occupants from the property. Now, the respondent number 4, TMC, on the basis that this Honorable Court has directed the authorities to evict the occupants from the premises, have making announcement that within 3 days they would be evicted and properties would be demolished. They have not issued any notice, no inquiry, nothing is done. This is what I may be sorry.
Correct, but how can you file a writ petition? If you want to protect your possession, go before the tribunal.
No. They have to approach the tribunal, the Wakf institution.
So what have you come for?
Now without issuing notice, without holding inquiry, without approaching tribunal, they have this is what if I am permitted to submit this ಇದೊಂದು ವಿಡಿಯೋ ಆಟೋ ಅಲ್ಲಿ ಕಾರ್ಪೊರೇಷನ್ ದವರು ಮೈಕ್ನಲ್ಲಿ ಅನೌನ್ಸ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ 3 ದಿನದಲ್ಲಿ ಎಲ್ಲ ಮನೆ ಒಡೆದಾಕ್ತಿವಿ ಅಂಗಡಿಗಳನ್ನ ಅಂತ ಹೇಳಿ.
Please come to the order.
Yes.
2007 ಏನಂತ ಬರ್ತಿದ್ದಾರೆ?
200755. Yes, this was filed by respondent number 9. To issue a direction to the Assistant Commissioner to take action for eviction of the occupants.
The petition is dismissed.
Dismissed.
Now you please come to the appeal.
Appeal. There, this was filed by the respondent number 9 against the order passed at Annexure E.
F bandri.
F, yes.
Come to F.
Yes. This writ appeal, it was filed by respondent number 9 against the order.
This writ appeal is not filed by respondent number 9.
How so?
It is filed by Anjuman Islam.
Other respondent 9, sir.
9 avra?
Avre sir. Avrenu namuk party madlardane idun writ petition madidare and they have sought for got it disposed of without making us a party. So this Honorable Court after while disposing of the writ appeal, had Lords observed that the claim of the respondent number 9 also be considered while holding inquiry and here. Page number 33.
Yes.
At the time of hearing of the appeal, learned counsel for the appellant submits that grievance of the appellant would stand redressed if a direction is passed as against the Deputy Commissioner Vijaypur and Chief Officer Sindhgi Municipality, that is respondent 4 and 7, against whom direction is passed to consider the representation dated 29/11/22 and 30/11/22 produced at Annexure D and E before the learned single judge by the petitioners. And during such consideration, as ordered by the learned, if the appellant herein is heard, no grievance would remain. Taking note of the limited request, this writ appeal came to be dismissed, disposed of. Now, Lords, neither in the order passed by this honorable court at Annexure E, there is any direction. Only direction is to consider the representation.
Yes.
Then, Lords, Annexure D. Allinu, this honorable court has held that without issuing notice, without holding inquiry, and without the authority approaching the tribunal, no order can be passed to implement the order passed by the Deputy Commissioner to evict the occupants of the property. Despite of all this, Lords, now they are making announcement in public that within 3 days they would be.
Pursue a remedy in other forums.
Lords, may I kindly peruse this one judgment of this honorable court.
Right, Mr. Now that you got some order.
No, I am not a party to any of this writ petition.
May not be a party.
Yes. In none of this writ petition or writ appeal, I am not a party. I am a tenant. Israel, non party. This is all behind my back.
Then you please go before the tribunal and work out your.
Tribunal, it is the authority.
No, that is right. If you are a tenant under the Wakf.
Yes.
Go before the tribunal, protect your possession.
Want to, evict me. The Wakf institution, they have to approach the tribunal for eviction.
If you want to protect your possession, where do you go? If you want to protect your possession, where do you go?
My submission is, if they had followed the procedure, if they had issued notice, if they had conducted inquiry without anything, or Bandhu.
This is not a instrumentality of the state. A Wakf is not an instrumentality of the state. Article 12 al Baradilla. How can you come to the
Israeli, judgment of this honorable court. Adralli, notices were issued for eviction of the tenants under section 54. This honorable court, taking note of the provisions of the act, held that the Wakf authority, they have to approach the tribunal and they cannot directly take recourse to public premises.
Therefore, if you want to protect possession,
Israel tenants, then
if you want to protect your possession, can you come to the High Court?
Let them take action if they want to evict.
Issue a direction against a non-entity, non-state. How can the High Court issue a direction to the Wakf, which is not a state? 226 young birth rate.
Now the action is being initiated by the TMC, Lords.
Yearly.
Our announcement ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಏನಿದೆ?
Yes, sir. ಅದನ್ನು ಅವ್ರ ಕಾಪಿನೂ ಇಶ್ಯೂ ಮಾಡ್ತಾ ಇಲ್ಲ. If Lords. ಈ ಹಾನರಬಲ್ ಹೈಕೋರ್ಟ್ ರಿಟ್ ಪಿಟಿಷನ್ ಆರ್ಡರ್ ರೆಫರ್ ಮಾಡಿ ಅದರಲ್ಲಿ ಏನೂ ಇಲ್ಲ, ಬರೇ ಕನ್ಸಿಡರ್ ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಅಂತಿದೆ. They don't issue any documents, they don't issue notice.
You can't come to the High Court, I'm sorry.
Lords, this is within one or by today or tomorrow, Lords, they will demolish the property.
You can't come to the High Court, you should have gone before the tribunal. If you want to protect your possession, go before the tribunal. Any person anta irodu. Please read section 85 adu. What is?
Well, but this action is now, Lords, being initiated by the fourth respondent, TMC.
What fact could read? 83 na 85 adu.
83.
83. ಓದಿ 83 ಏನು ಹೇಳುತ್ತೆ? 83 na 85
83.
ಓದಿ ಏನ್ ಹೇಳ್ತದೆ?
Milords, 85 is bar of
Or
juris.
any other person agreed by any order passed made under this act or rules may make an application within the time specified in this act or where no such time has been specified also.
ಅಲ್ಲ ಏನು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿಲ್ಲ, ನೋಟಿಸು ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ. It is milords in blatant violation of the milords provisions.
ಕರೆಕ್ಟ್ ಎಲ್ಲ ವೈಲೇಷನ್ ಕರೆಕ್ಟ್ ನೀವ್ ಹೇಳೋದು, ಬಟ್ ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಅನ್ನೋದು ಪ್ರಶ್ನೆ.
ಇಲ್ಲ ನಾನು, if milords, my limited submission is, if they want to evict us, the Wakf institution, for them the proper milords forum is to approach the Wakf tribunal. That is what this honorable court has.
Give you 1 month's time, please go before the tribunal and work out your remedy. Till then I'll protect your possession. ಅಷ್ಟೇ ಬರ್ಕೊಳ್ಳಿ. The petitioner is before this court seeking for a direction to implement the order dated 26/9/2023 passed in WP number 202696/2023 and WP number 200755/2021 dated 10/8/2021. And grant an opportunity to the occupants, including the petitioner. Next para. The petitioners contend that they are tenants under the respondent number 9 in respect of certain portions of the property bearing survey number 1029 of Sindhigi town. Full stop. They contend that the respondent number 9, in order to illegally evict the petitioners and other occupants, had approached the assistant commissioner, had approached this court for a direction to the assistant commissioner to implement the orders passed by the respondent number 4 in WP number 200755/2021. The petitioners contend that this court dismissed the writ petition in terms of the order dated 10/8/2021. Full stop. Thereafter, the respondent number 10 approached this court in WP number 202696/2023 to consider his representations. Full stop. This court directed the dispose of the writ petition directing the respondents 4 and 7 to consider the representations in accordance with law. Full stop. The petitioners allege that taking advantage of the order passed in WP number 202696/23, the respondent number 10 has started negotiating with the occupants of survey number 1029 of Sindhigi town and has assured that no proceedings would be initiated against those occupants who agree to the proposed terms by the terms proposed by the respondent number 10. Full stop. The petitioners have therefore sought for a direction to the respondents to consider the order passed in WP number 202696/2023 and also grant an opportunity to them and proceed in accordance with law. Next para. The sum and substance of the case of the petitioners is to protect their possession in a portion of survey number 1029 of Sindhigi town against the respondent number 10. The respondent number 10 is admittedly a Wakf institution governed under the provisions of the
Respondent 9.
Respondent number 9 is admittedly a Wakf institution governed under the provisions of the Wakf Act 1995. And therefore, any person such as the petitioner who is aggrieved by any order that is passed under the Wakf Act is bound to challenge the same before the Wakf tribunal in view of Section 83 of the Wakf Act 1995. In that view of the matter, no indulgence can be shown to the petitioners in this writ petition. However, since the petitioners have alleged that the respondent number 9, through the respondent number 8 is attempting to dispossess the petitioners from the suit property, the possession of the petitioners deserves to be protected till the petitioners approach the tribunal. Hence the following order: writ petition is disposed of, granting liberty to the petitioners to approach the tribunal and work out their remedies before the tribunal within 1 month from today.
2 months.
Full stop. Until then, the respondent number 8 and 9 are restrained from disturbing the possession of the petitioners in the suit in the property. Until then, the respondents 8 and 9 are restrained from disturbing the possession of the petitioners if they are in possession of survey number 1029 of Sindhigi town. Yes.
4, 5, 8 and 9.
Notice
4,
may be
5,
issued.
8 and 9.
4, 5, 8 and 9. ನಿಮ್ಗೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಲ್ಲ?
ಹೌದು ಸರ್.
HCGP is directed to accept notice for response 1,
1,
2,
2, 4, 5,
4, 5,
7,
7,
8.
8 ನೀವೇ ತಗೋತೀರಾ? ಚೀಫ್
ಇಲ್ಲ
ಆಫೀಸರ್
ಸಿಂಧಿ CMC ಇದೆ ಸರ್.
ತಗೋತೀರಾ?
ಇಲ್ಲ ಬೇಡ.
Relief is granted against them. ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಮಾಡ್ಬಿಡಿ. ಅದು ಏನಂತ ರಿಲೀಫ್ ಏನಂತ ಕೊಟ್ರಿ? Yes, shock. Yes.
Please.
Arun Kumar.
Objection is with regard to annexure F, my lord, is not readable. My lord, relevant portion is readable. Relevant portion is legible, my lord. It is
The
at,
relevant portion.
my lord, page 41. To that extent, I am placing reliance, and otherwise, even otherwise, my lord,
The relevant portion, Mr.
page 41, my lord,
41 is annexure F1.
sorry, annexure F, my lord, page 33, my lord.
33 is the relevant portion.
Yes, my lord. Item Roman 7, my lord.
Number called office objection serial number 27 is overruled by accepting the submission of the learned counsel for the petitioner that the relevant portion of annexure F is legible. Yes.
My lord, the case of the petitioners is that, my lord, the petitioner is appointed as Anganwadi helper in the year 2017 itself, my lord. And she completed more than, my lord, 5 years. And in terms of guidelines, my lord, at annexure F, and even revised guidelines at annexure F1, since, my lord, they are put in more than 5 years of service, more than 5 years of Anganwadi service as Anganwadi helpers, and they are residing within 3 radius kilometers, my lord. There cannot be any, my lord, notification inviting applications from, my lord, other candidates than the, my lord, Anganwadi helpers. That is provided in the guidelines itself. Contrary to, my lord, annexure D came to be issued.
So you're already working as an Anganwadi helper.
Helper, now, my lord,
What is
posts in respect of Anganwadi workers are fell vacant. Therefore, annexure D recruitment notification came to be issued.
Yes, Barcode. Whether this page 33 has been modified?
Yes, well, even revised guidelines also provides for same thing, my lord. May I invite lordship's attention to page 41. Page 41, Roman 12, my lord. Same, as it is, my lord, it is adopted. Corresponding. All 3 criteria laid down in the, my lord, guidelines petitioner is fulfilling. Nonetheless, my lord,
you are a helper.
Yes, she petitioner is helper, ma'am.
Next post ಯಾವುದು?
ಅಂಗನವಾಡಿ ವರ್ಕರ್. ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ, ಅಂಗನವಾಡಿ ಸಹಾಯಕರನ್ನು ಕಾರ್ಯಕರ್ತರನ್ನಾಗಿ ಪದೋನ್ನತಿಗೆ ಇಟ್ ಈಸ್ ಆಸ್ ಗುಡ್ ಆಸ್ ಮೈ ಲಾರ್ಡ್ ಪ್ರಮೋಷನ್.
Therefore, issue emergent notice, sorry. HCGP's director accept notice for response 1 to 4. Issue emergent notice to respondent number 5. Till the next date of hearing, where's the notification?
Annexure D, my lord.
Annexure D is state insofar as?
Insofar as my lord, Dupat Mahangaon, my lord, serial number 8.
Huh?
Serial number 8.
8 ah?
808. Sorry, my lord. 14, my lord. So, 14, my lord. Serial number. This Anganwadi center is, my lord, one Chandra Maharaj Tanda.
Annexure?
Annexure D, my lord. Page 21, my lord.
14 is Hedgapura.
Edgapura is a village, my lord, Gram Panchayat. And Anganwadi center is Chandra Maharaj Fund.
Insofar as Chandra Maharaja Tanda
Please.
is concerned. List down on date code.
Please. Second is also same, my lord. It is in respect of same submission.
Annexure, office objection serial number 27 is overruled by accepting the submission of the learned counsel for the petitioner that the relevant portion of annexure F is legible. HCGP is directed to accept notice for response 1 to 4. Issue emergent notice to respond number 5. Till the next date of hearing, the recruitment to the post of Anganwadi worker at
Dupat Mahangaon Tanda, my lord, serial number 8, annexure D, page 18.
at Dupat Mahagaon Thanda. Bijapura idu?
Aura Bidar.
Aura Taluk Bidar district is state.
Great.
Yes, next. List down on date code. Avanish Nath R. Taranath.
My lord.
One of the is filed for extension of time for.
My lord, I'm seeking for an extension of time, my lord. The preliminary order has been passed and the FDP has also passed. FDP is pending, my lord. And appointment of the officer and loss accounting, my lord. Therefore, an extension of 6 months time, my lord.
The time for conclusion of the arbitration proceedings is extended by 6 more months from today. It is made clear.
May please, my lord.
Extension. It is made clear that no further extension shall be granted. Yes, next.
May please, my lord.
Nitish Padiyal. There's no representation for the petitioner.
I am petitioner.
Yes, what do you want?
Matter pertains to regularization, my lord.
Madi.
Senior counsel is appearing in the matter. Senior counsel is appearing. There is an interim order.
There is no representation for the respondent number 1 and respondent number 2.
There is an interim order.
As a last chance, list down on date code. Interim order granted release extend till the next date. You, Sharana Reddy.
Your Lordship, the writ petition was filed only for the modification of the order, my lord, even after 16 years of the
objection for IA 2 of 25.
Because once again, during the pendency of the petitioner, my lord, by raising the issue of 2008, 74 years, 74 days absentee, my lord, they once again terminated, my lord.
To IA 2 of 25 amendment.
Amendment, my lord, since earlier corporation had filed that
Amendment yenta objection.
Amendment additional.
IA 2 of 25 is filed for amendment of the writ petition to incorporate, to amend the amend the prayer as well as the interim prayer sought for. Though this application is opposed by the learned counsel for the respondent number 1, Since the amendment is necessary for the purpose of considering this writ petition, IA 2 of 25 is allowed. Counsel for the petitioner is directed to make appropriate amendment in the writ petition. Full stop. It is open for the respondents to file statement of objections to the amended petition. IA 1 of 25 shall be considered along with the main petition. Yes. M. Sudarshan.
Let's be permitted to appear, Lord.
Mr. Manmohan is appearing.
Huh?
Mr.
The respondent in this matter, my lords.
If I permit to appear for the petitioner, Lord, the respondents not have filed a memo with not certain documents. Can I seek for some time to file objections
No,
to
my
it?
lords, I just have one submission, my lords, if I may be permitted. My lords, I'm appearing for the State Pollution Control Board. My lords, we look at the prayer which they have sought for. They are saying that we
Whom do
should
you
not take it.
represent?
My lords, I appear for State Pollution Control Board, my lords. CH-3.
Pollution Control Board.
Yes, my lords.
Ah.
That's Italy. The prayer which they have sought for is to say that we have a writ of mandamus, page number 17, my lords, can look into. Not to take any action in terms of withdrawing consent or taking coercive steps without following the due process of law. That's the interim order which they've obtained is that we should not go inside and even inspect the premises.
No, where's the interim order kottidya?
Interim order kottidya, and we have filed an IA for vacating also. So let's look at the interim order.
Lord, what has happened is, Lord,
That's my only request.
Lord, may
My only request is that, my lords, at best, my lords, even if the writ petition is allowed, we have no problem because my lords, we would not.
How can you stop any official from entering the premises of the factory?
what? Not preventing it from entering the factory, Lord. What has happened is they had already conducted, they'd come, Lord, conduct the spot inspection. Lord, in fact, the chairman was due to retire. But he came to the property, Lord, he conducted inspection, and Lord, there was a threat of not forcible closure, Lord, because the season has already commenced.
Now the chairman is retired.
And Lord, in the interregnum, Lord,
chairman is
retired.
He is right
Chairman,
now.
No, the chairman is retired.
Yes.
So therefore, there's
Now
no
he
threat
is
from
retired.
this. You know,
Yeah,
I know
but-
what you mean. Manmohan, I know what you mean.
Yes.
But now that the chairman is retired, your perception is, I think, ill-found now. So we'll direct them to take action
Lord,
only in
what has
accordance with
happened is,
law.
Lord,
In accordance with law itself, we'll do it, my lords.
can I seek one
This is the reason
indulgence? On 26th, Lord, of December, one my such. Lord, can hear me, Lord?
I can hear you.
Lord, sir, able to hear me, Lord?
Yes, I can hear
Please.
you.
Lord, on 26th, Lord, they have supposedly please, Lord. But the Pollution Control Board not supposedly conducted an inspection on 26/12, but without notice to us, not outside the property, not with. Now, my learned filed a memo along with those documents not day before yesterday, because not now, not they want to say that not there is pollution, etc. In fact, not we had filed an affidavit of undertaking, but before the Pollution Control Board sin.
No, we can't stop any authority from inspecting the factory of the petitioner. Let them
The
conduct
inspection, Lord, in fact, they have already done it, Lord. Look, I have also produced the document. Kindly permit me to take notes to page, Lord, 92.
Yes, if that is the apprehension of the petitioner,
But they
yes,
conducted
we'll issue a notice. We'll issue a notice.
Let me please finish.
So 1 second, I'm just trying to find a solution, sir. We'll issue a notice. We'll address your concern. We'll issue a notice to them, and then we'll conduct inspection and take action according
So
to
we'll
law.
record his submission, close the petition.
Yes.
Barkul. The petitioner is before this court.
Lord, can I seek one
for a
request, Lord?
writ in the nature of mandamus.
Can I seek one indulgence, Lord? My apologies. Lord, because it's sugar season right now,
Yes,
Lord,
go on.
my only request is, Lord, the interim order that they shall not close, Lord, the factory or not take any coercive action is my only request. Because Lord, if Lord,
Don't
they
indul-
proceed to Lord close down the factory or do anything, Lord.
Today, Pollution Control Board has to do its work.
Please.
In Dharwad, industrial effluents are discharged in the air during midnight.
No, I cannot dispute that. That's all right.
I'm telling you what is happening. Industrial effluents are discharged in the midnight when people are asleep. When Karnataka Pollution Control Board is also sleeping and the residents of Dharwad are also sleeping, industrial effluents are discharged in the air during midnight. So therefore, we can't stop the Pollution
In
Control Board from inspecting your unit. Don't pollute the atmosphere.
No, Lord. We are not polluting. In fact, Lord, they conducted inspection. I have placed that also on record. They have collected samples that also have placed on record. But my concern was that, Lord, there was that threat, Lord, which was hanging on my head, and Lord, sugar season had come in.
May make this
Therefore, my
submission, my lords,
request.
it may be recorded
One
also.
minute, let me please
No,
complete.
the procedure is being superseded,
let
my
me
lords.
please
We have to
complete
issue
my-
show cause notice. ಅದಾದ್ಮೇಲೆ NPD ಅಂತಿದೆ, notice for proposed direction, and then we, my lords, have to
Before
issue.
this court seeking for a writ in the nature of mandamus to direct the respondent not to take any coercive action against it, including withdrawal of consent to and withdrawal of consent to operate and forcibly shut down the petitioner's factory without following the due process of law. Next para. The petitioner contends that it is operating 5 factories at Athani, Munnoli, Raibag, Havalaga, and Gokak. Full stop. Insofar as the factory at Havalaga, the respondent had issued consent for operation under Section 25 of the Water Act 1974. 74 or 72 in the Water Act?
74, my lords.
74, Lord.
And Section 21 of the Air Act 1981, which is in force till, which is valid till 30th of June 2026. Full stop. The petitioner contends that the plant is running successfully and is providing direct and indirect employment to various persons in the locality. Full stop. The petitioner contends that since the new sugar factories have come into existence, the management of a few inimically ill-disposed persons have lodged complaints to various authorities, including with the respondent. Full stop. The petitioner contends that the respondent constituted a committee to go into to investigate the complaint regarding contaminated water, regarding supply of contaminated water to Kalaburagi city. And the said committee inspected the unit on 2/11, inspected the factory on 2/11/2022 and made certain observations. The committee then made recommendations for improvement of the operations. Full stop. On 4/2/2023, the respondent issued a show cause notice to the petitioner, and the same was replied by it. Subsequently, on 21/8/2023, in order to verify the status of compliance, the industry was inspected by the District Environmental Officer, Kalaburagi, who reported that the petitioner was yet to comply certain recommendations made by the committee. Full stop. Later, a technical hearing was held on 20th of September 2023 before the respondent, and on 26/9/23, certain directions were issued to the petitioner for immediate compliance. The industry was again inspected on 2/2/2024 by the District Environmental Officer Kalaburagi, who made certain observations. On 11/2/2024, the respondent caused a notice for alleged non-compliance and directed the petitioner to appear for a personal hearing so that further action could be initiated under section 33A. Before further action is initiated under section 33A of the Water Act 1974 and section 31A of the Air Act 1981. Full stop. Next para. The petitioner contends that on 8/2/2024, the Taluk President of Ambedkar Seva Samiti lodged a complaint against the petitioner, where it was alleged that the agricultural activities were affected due to the fly ash from the factory of the petitioner, and also due to the discharge of effluents from the industry into the Bhima River. Full stop. In that connection too, the respondent had issued a notice of personal hearing on 18/4/24, where it was stated that the District Environmental Officer Kalaburagi had inspected the unit of the petitioner on 15/4/2024 and had made certain observations. Full stop. The respondent directed the petitioner to file an affidavit in terms of a communication dated 29/5/2024 and directed the petitioner to comply with the undertaking to undertake the compliances made within a time-bound manner. Full stop. The petitioner submits that it had taken positive steps and had positive steps and had also undertaken necessary improvements. Full stop. On 29/6/24, yes, at the personal hearing, personal hearing, the petitioner had filed its affidavit and submitted the date, month, and year-wise complaints of the observations made by the respondent, and also provided a specific time-bound action plan with budgetary estimate. So as per the affidavit, the petitioner had initiated compliance work and accordingly completed certain work in a time-bound manner. Full stop. When things stood thus, on 20th of July 2024, the respondent issued a notice for non-compliance of the provisions of the Water Act 1974 and Air Act 1981. Full stop. It also indicated to the petitioner that the request of the petitioner for time till the year 2027 to comply the directions cannot be accepted, and therefore called upon the petitioner to submit a revised time-bound action plan within 15 days. In compliance, the petitioner addressed a communication dated 14/8/2024, submitting a revised time-bound action plan and budgetary estimate. Full stop. The petitioner contends that on 28/10/2024, the chairman of the respondent inspected the unit of the petitioner and recorded his observations. Thereafter, the respondent took certain water samples without intimating the reason for securing the samples and also did not share a control sample with the petitioner for their independent testing. Though the petitioner requested for a sample of the water so collected by the respondent, however, the officials of the respondent failed to provide the same to the petitioner. The petitioner therefore submitted a request on 29/10/2024 to provide a sample of the water sample already collected. Full stop. The petitioner contends that the respondent has not replied to the same, and on the contrary, the petitioner received oral communication from the respondent on 5/11/2024 that the factory would be closed any time. The petitioner submits that it has not received any order for closure, nor has the respondent passed any order of closure of the unit. It contends that since the sugar season is due to commence in 7 to 10 days time, if the respondent forcibly closes the factory, the petitioner would suffer irreparable loss and injury. So therefore, the petitioner has sought for the aforementioned reliefs. Next, the learned counsel for the petitioner reiterated the above submissions and submitted that the respondent is determined to close down the unit without following the due process of law. Full stop. He submits that since the crushing season is scheduled to commence shortly,
Commenced, my lord, already.
Schedule
It's
commenced.
it's already commenced.
Submits that since the crushing season has already commenced, any precipitative action by the respondent would result in untold hardship and injury, apart from enormous monetary loss to the petitioner. Therefore, he submits that the respondent be restrained from taking any action during the crushing season and not to close down the factory of the petitioner. Per contra, the learned counsel for the respondent submits that the respondent would take action against the petitioner only in accordance with law. He submits that the petitioner has approached this court
Lord, on
maturely.
one kind submission. The 20th/11, the entire detailed report in compliance to Lord, what has been.
That why should we look into now?
We place it on record.
Why should we look into
Please,
it? Let
please.
the KSPCB look into it. Yeah, prematurely, and has obtained an interim order to restrain the respondent from even entering into the factory premises of the petitioner. He therefore submits that any action that may be initiated by the respondent shall be in accordance with law. Full stop. Next para. If the petitioner has been given time, if the petitioner had undertaken to comply with the observations recorded by the respondent, there is no escape for the petitioner but to comply with the observations made by the respondent. Full stop. The petitioner seems to be asking for time till the year 2027 for complying with the directions. Full stop. This appears to be this appears on the face of it to be impermissible, as operating the unit without complying with the pollution control norms, cannot be permitted.
Lords, kindly not.
Therefore,
if not
I'm not saying anything against you. I'm only saying that you sought for time till 2027. It is not permissible. Every day, if you discharge water and pollution into the atmosphere, every day is a cause of action.
No, my lord, true, my lord, but if my lord says so, my lord, then my entire my lord, I'll be worse off, my lord, than my lord, what I was.
So better than you withdraw the writ petition if that is the case.
If my lord says, my lord,
pollution.
ಹೇಳಿದ್ರೆ ಕಷ್ಟ ಆಗೋಗುತ್ತೆ.
Next,
Then the entire portion of the request for 2027 itself may be
the-
taken off. Points.
it up next for the contents of the writ petition and the assertions made by the learned counsel for the petitioner point to a certain fact that the respondent has conducted certain inspections and has also recorded certain observations for complaints by the petitioner. Full stop. Therefore, the petitioner cannot restrain the respondent from taking action in accordance with law and cannot certainly restrain the respondents from entering the factory premises of the petitioner. Full stop. Therefore, without going into the question whether the petitioner has complied with the undertaking or the observations recorded by the respondent or not, this writ petition deserves to be disposed of, directing the respondents not to take any action without the due process of law. Full stop. It is made clear that before the respondent issues any order of closure, the respondent shall ensure that each and every provision of law as prescribed under the Water Act 1974 and Air Act 1981 and the rules made thereunder are strictly followed strictly followed. Full stop. Yes, anything else?
But can I request, but instead of saying order of closure, not say before taking any action, closure.
They use that specific word in
No, Lord, kindly not say order of closure, Lord, but kindly say, Lord, action in accordance with law.
Yes, they say that.
Lord, can I request, Lord?
Yes, next.
Lord, I'll be really worse off, Lord, because then, Lord, it's like saying, Lord, that
any order.
Lord, may say any order, Lord, not an order of closure.
Any order. Any order.
Grateful.
Any order.
The prayer is sought for to shut down. I mean, not to shut down, which is as good as a closure order.
Even shutting down has to be by an order.
In accordance with law.
In accordance with law. Yes, next.
Law.
Please.
My lord, other two writ petition are pending, my lord, similar matter. Please connect.
See number 30.
Yes, my lord. Please connect this matter with the other two.
GM police, yenidu?
It's a COCA order challenge, my lord. It has been passed the respondent 2 and 4.
You challenge the COCA order?
Yes, my lord.
List this petition along with WP number sounds. Next.
My lord, there is an interim order.
Interim order granted is extended till the next date of hearing. Yes. Avinash Uplankar.
My lord, I am appearing for petitioner. Petitioner is having gun license in the year 2020. Same was cancelled by the respondent number 2 by order dated 10/6/2020 on the basis of criminal cases are pending against this petition. Thereafter, the petitioner approached Regional Commissioner Belgavi. There also same was confirmed. And the revision petition was dismissed. As per section 17 of the gun license.
Gun excise?
Yes. Arms.
Excise ante idiyalla illi. Gun license idu?
Yes, ma'am.
Yes.
In similar matter, Annexure F, my lord, 28.
What are the offenses alleged against you?
So many cases.
What offenses nim virudda irodu?
323, 279, and 427.
And you're a teacher?
Yes.
Gun license?
For security.
Are nanagu bekappa. I also decide so many cases. Nanagu beku. Nimgu beku. Why teacher needs a gun license?
For his family.
School alli helkodtidira?
No, man.
Then why do you need a gun license, mister? Is there any threat to your life?
Yes. Some property dispute between his relative.
Property dispute putpudi. Whether your opponent also has a gun license, property dispute ಇದೆಯಲ್ಲ ಅವ್ರ ಹತ್ರ ಗನ್ ಇದೆಯಾ?
I don't know.
ಮತ್ತೆ ಅವ್ರ ಹತ್ರ ಮಚ್ಚಿದ್ರೆ ನೀವು ಮಚ್ಚಿ ಹಿಡ್ಕೊಳ್ಳಿ, ಅವ್ರ ಹತ್ರ ಗನ್ ಇದ್ರೆ ನೀವು ಗನ್ ಹಿಡ್ಕೊಳ್ಳಿ. ಅವ್ರ ಹತ್ರ ಮಚ್ಚು, ನಿಮ್ಮ ಹತ್ರ ಗನ್ನು. ಇಟ್ ಇಸ್ ನಾಟ್ ಲೆವೆಲ್ ಪ್ಲೇಯಿಂಗ್ ಫೀಲ್ಡ್ ಅಲ್ಲ ಅದು.
Family protections.
That is okay, mister. ಏನು, ವಾಟ್ ಆರ್ ದೀಸ್ offenses? ಎಷ್ಟು ಕೇಸ್ ಇದೆ?
ಇದರಲ್ಲಿ 6 cases ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. Some of the acquitted, my lord.
Rowdy charge sheet also.
Is there any case which is still pending?
2 cases are pending, my lord.
ಯಾವುದು?
Column number 6 ಅಲ್ಲಿ page number 21. Crime number 8 for 2020.
Page number 21.
Page number 21.
ಸಿಂದಗಿ ಪೊಲೀಸ್ ಠಾಣೆ ಅಪರಾಧ ಸಂಖ್ಯೆ 8, column so and so, 143, 147, 323, 24, copy of it. 307 is whether this weapon was used in any of this offense.
No, my lord. In 2 months, they have cancelled the gun license after obtaining the gun license.
And you, ಇದು ಬೇರೆ ಪಿಸ್ಟಲ್ ಬೇರೆ.
Yes.
It's a pistol.
Yes.
What is your argument?
Yes, ma'am.
What is
As
your
per section 17 of the gun license act, Indian Arms Act.
Arms Act. Yes.
Merely pendency of the criminal cases. Cancel ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. In similar matter, this honorable court has coordinate bench has passed the similar order. Annexure F, page number 20.
Yes, annexure F ಏನಂತ ಹೇಳುತ್ತೆ?
As per section 17, pendency of a criminal cases cannot be the circumstances that would warrant revocation of the arm license that is granted to the petition.
Yes.
So many cases against him registered, my lord. There is no any acquittal order as produced, my lord. Rowdy charge sheet also. Again.
ಒಂದಲ್ಲ 5-6 ಕೇಸ್ ಇತ್ತಲ್ಲ ವಿರುದ್ಧ.
ಎಲ್ಲ ಅಕ್ವಿಟ್ ಆಗಿದೆ.
No any
Acquit ಆಗಿದೆ.
judgment.
Acquit ಆಗಿರೋದಲ್ಲ ಪ್ರಶ್ನೆ. There are some 6 cases which are registered, which were registered against you. Acquit for various reasons.
ಇಲ್ಲ, ಒಂದರಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್ ಕೇಸ್ ಇದೆ ಇದರಲ್ಲಿ.
I don't know.
ಸೀರಿಯಲ್ ನಂಬರ್ 279-338 ಅದು ಆಕ್ಸಿಡೆಂಟ್ ಕೇಸ್.
ಸೀರಿಯಲ್ ನಂಬರ್
ಪೇಜ್ ನಂಬರ್ 21 ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 279-338.
ಆಯ್ತು, ಒಂದು. ಆಮೇಲೆ 323, 324, 504, 506 ಸಿಂದಗಿ ಪೊಲೀಸ್.
ಟ್ರಯಬಲ್ ಬೈ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಮೇಲೆ ಅಲ್ಲ.
ಇಟ್ ಇಸ್ ಓಕೆ. ಸಿಂದಗಿ ಪೊಲೀಸ್ ಠಾಣೆ ಅಪರಾಧ ಸಂಖ್ಯೆ so 427, 341, 147, 504, 323, 324 ಎಲ್ಲ 504, 323, 324 ಎಲ್ಲ
ಅಕ್ವಿಟ್ ಆಗಿದೆ.
ಅಕ್ವಿಟ್ ಆಗಿರೋ ಸರಿ ಕಣ್ರಿ. ವಾಟ್ ಅಬೌಟ್ ಯುವರ್ ಕಾಂಡಕ್ಟ್, ಮಿಸ್ಟರ್? What about your conduct? ನೀವು ಗನ್ ತಗೊಂಡೋದು ಎಲ್ಲ ಕಡೆ ಹೊಡ್ಕೊಂಡ್ ಬರ್ತೀರಿ ನೀವು.
No, my lord.
ಗನ್ನಲ್ಲ ಹಿಂಗ್ ತೋರಿಸ್ಕೊಂಡು ಹಿಂಗ್ ಹೊಡ್ಕೊಂಬರ್ಬೇಕು. You can't be donning your pistol, mister. Take notice, mister.
Notice.
Notice ಆಗಿದ್ಯಾ? When will you file objections?
File them.
ಯಾವಾಗ?
1 week time.
ಬೇಗ ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿ. ಯಾವತ್ತು ಹೇಳಿ?
20.
Learned AJ seeks time to file objections. List on 20th. Yes. Mallikarjun Basareddy.
This is the appointment of the D grade trainee, my lord.
Huh?
D grade trainee on the ground of land losers, my lord.
I didn't get you. Please come again.
Pardon, sorry.
ಏನು ಅರ್ಥ ನಂಗೆ ಕೇಳಿಸ್ಲಿಲ್ಲ.
Land losers ಮೇಲೆ ground ಮೇಲೆ appointment ಕೇಳ್ತಾ ಇದ್ದೀವಿ sir. But this my land, my father's land was, my lord, acquired. Total extent of 28 acres of land, my lord, for the benefit of the respondents. But in the year, my lord, 1978. But then, my lord, they issued the scheme, my lord. That is, my lord, scheme is produced, my lord. That is page number F, my lord.
Yes.
This is the, my lord, they introduced the scheme on 21/9/2005.
Yes.
For appointing the, my lord, land losers, my lord, sons or LRs, my lord, to the grade D post, my lord. Then, my lord, I made the application to them. They, my lord, kindly see, my lord, their remarks, my lord, page number 54, my lord. Serial number 290. But Sugangoda Tande Nagappa ದತ್ತಕ ಪುತ್ರ ಇವರು ಸರ್ವೆ ನಂಬರ್ 401, 402 ಮೇಲೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರನ ತಂದೆಯ ಸೋದರನಾದ ನರಸಪ್ಪ ಇವರ ಮಗ ಸೂಗನಗೌಡ ಇವರ ಅರ್ಜಿ ಸಂಖ್ಯೆ 170ರಲ್ಲಿ ಮನೆ ನಂಬರ್ 68 ಮೇಲೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸೂಗನಗೌಡ ತಂದೆ ನರಸಪ್ಪ ಹಾಗೂ ಸೂಗನಗೌಡ ತಂದೆ ನಾಗಪ್ಪ ಇವರು ಒಂದೇ ಕುಟುಂಬದವರಾಗಿರುವುದರಿಂದ ಈ ಇಬ್ಬರಲ್ಲಿ ಒಬ್ಬರಿಗೆ ನೌಕರಿ ಕೊಡಬಹುದಾಗಿದೆ ಎಂದು ಪ್ರಕಟಿಸಲಾಗಿತ್ತು. ಸೂಗನಗೌಡ ತಂದೆ ನಾಗಪ್ಪ ಇವರು 4161 ನಂತರ, ದಟ್ ಈಸ್ ಮಲಡ್ 9/12/1998 ರಲ್ಲಿ ದತ್ತಕ ಪುತ್ರರಾಗಿರುತ್ತ ಇವರ ಅರ್ಜಿಯನ್ನು ಮುಂದಿನ ಪ್ರಕ್ರಿಯೆ ಪರಿಗಣಿಸಿರುವುದಿಲ್ಲ. One contention, my lord, that is my cousin brother is also obtained the job. But kindly see, he is not up. He given the affidavit, my lord, stating that, my lord, he don't want the post, and that may be given to me. That is, my lord, kindly see, affidavit is filed.
For the respondent.
Yes, sir.
My lord, I appeal for the respondent.
Why don't you give the job to this man if the other person is not interested?
My lord, because, my lord, this is based on an adoption deed.
That's okay, mister. Now the other person to whom you had given the job,
Please.
he is willing to give it up to this person. What is your problem?
My lords, there are two rules, my lords, to this. The first rule, my lords, is that only one person from a family is eligible. Therefore, that person is eligible.
Mister,
And the second
the person to whom the job is given,
yes,
he has no objection to accept that he is a member of the family. Who are you to say that he is not a member of the family?
my lords, because at the time of adoption, the adoption deed that they have submitted, the petitioner, my lords, was 20 years old. Under the Hindu
Mister,
adoption
let
and
it be anything, mister. Let it be anything. ಅವನಿಗೆ ತೊಂದರೆ ಇಲ್ಲ.
Illa, Kanun Prakara cannot be adopted, my lords, if he is older than 15 years.
Mister, who are you to say that?
The law says that, my lords, under the Hindu maintenance.
Mister, that man doesn't have objection.
My lords, he
A
cannot
member
be
of the family does not have objection to be treated him as an adopted son. Who are you to dispute that?
My lords, if I may point out to section 10 of Hindu adoption.
That is okay, mister. A person who is a member of the family has no objection.
My lords, this affidavit is filed belatedly, my lords.
Yes.
Both of them made their application.
Yes.
We select, my lords, one person because he's the natural heir, and the other person is adopted, my lords. His application is rejected because his adoption deed shows that as on the date of adoption is 20 years old.
Yes.
Now, my lords, only to benefit them, they are claiming that the other person doesn't want the job. The other Suguna Gowda, that is the cousin of the petitioner, he has come for training, he's been trained. After training, he says that I am not interested in the job, my lords. So the amount spent, my lords, by the corporation on his training has gone to waste. And now, my lords, this
Tell us how much
representation.
is, tell us
Now-
how much is the money you spent on him? We'll direct him to pay that.
No, the
ಎಷ್ಟು
other
ಖರ್ಚಾಗಿದೆ?
the other aspect to this is, my lords, that this scheme came out in 2005. Application is made in 12, and the challenge to the representation of 2016 is being made now in the year
Yes.
2024.
All those things are fair enough, but you please provide employment to this man.
Lord, it's training, but Lord, our only contention is that as on the date of adoption, he was a major person and he cannot
Yes.
be adopted.
Yes.
That is our-
ಅಷ್ಟೇನಾ?
Please.
ಬರ್ಕೊಳ್ಳಿ.
My lords, our objections are not on record. My colleague is there, my lords, in court. She
Objections?
filed objections.
The petitioner has sought for a writ in the nature of certiorari right to quash the communication hearing number so and so dated 18/11/2016 issued by the respondent number 2. He has also sought for a writ in the nature of mandamus to direct the respondents to consider his representation dated 24/6/2013 and 8/7/2016 and provide employment as per the scheme. Next para. The petitioner contends that the land bearing survey number 401 and 402 of Devasugur village, Raichur Taluk and district, measuring 12 acres 12 guntas and 16 acres 15 guntas, was acquired for the purpose of establishment of a thermal power station. Full stop. The respondent formulated a special scheme, bracket, training and absorption for land losers of KPTCL projects.
KPCL, my lords.
KPCL projects. So as to provide employment to one member of a family of the land loser. Full stop. The petitioner contends that he being the adopted son of Sri Nagappa and Srimati Vishalakshi submitted an application with requisite documents for the purpose of employment under the scheme. Full stop. The respondent number 1 published a list of eligible persons for the appointment. In the said list, the name of the petitioner was mentioned at seal number 43. Full stop. After an interview, it was held that the petitioner was eligible for employment. Full stop. It is contended that one Sugana Gowda, who also had lost land, made an application for employment, and his name was found at serial number 28. Full stop.
He lost the house, my lord. Lost house.
Lost the house, land anta bardidira?
House.
Land anta bardidira.
Sorry.
Who had lost his house also made an application for employment, and his name was found at serial number 28. The petitioner contends that the respondents, without providing any opportunity, published a list where the petitioner was not considered for employment on the ground that he was adopted after the notification was issued. After the acquisition notification was issued. Full stop. The name of the petitioner appeared at serial number 14 in the list of applicants who were not considered. Full stop. The petitioner contends that Sugana Gowda who is his cousin, was appointed full stop. The petitioner therefore filed OS number 392 of 2013 for declaration to declare that he is eligible for the post of trainee grade D in Thermal Power Station Corporation, and to direct the selection committee to consider his application, consider him as an eligible candidate. Full stop. The said suit was dismissed on 7/8/2017 on the ground that it was not maintainable. The petitioner filed RA 38/2017. Full stop. During the pendency of the appeal, he filed an application for amendment of the plaint in OS number 392 of 2013, which was dismissed on 15/6/2020. The petitioner therefore filed WP number 226361/2020 before this court. It is contended that when the writ petition was listed before this court on 3/1/24, this court expressed that the suit is not maintainable against rejection, and therefore the petitioner filed a memo to withdraw the writ petition and sought liberty to withdraw the suit and file necessary petition before this court. The said memo was disposed of as on 4/1/2024, and this court granted liberty to the petitioner to seek appropriate remedy in accordance with law. The petitioner contends that his brother, who was his cousin who was issued an order of appointment, was informed to join training grade D post. However, he was not willing to join to the said post. Full stop. Hence, he submitted an affidavit stating that he has no objection to appoint the petitioner to the said post. Accordingly, the petitioner submitted a representation on 24/6/2013 requesting the respondent number 1 to consider his candidature in the place of his cousin. Petitioner contends that the respondent has not considered the request of the petitioner and for the petitioner is before this court seeking the aforementioned reliefs. Next para. The learned counsel for the petitioner contended that though the petitioner was the adopted son, he was entitled to claim the benefit of the scheme, as it was his adoptive parents who had lost the land in the acquisition for establishment of the thermal plant, establishment of the thermal plant. Full stop. He therefore contends that the petitioner is entitled to be appointed. He further contends that since the brother of the petitioner is not interested to be appointed, there is no impediment against the petitioner being appointed. However, the respondents have filed a statement of objections contending that the petition is not maintainable. They contend that the scheme was formulated by the respondent number 2 in order to alleviate the difficulties of the land losers. So it is contended that under the scheme, one eligible member of the land loser, one eligible member of the family of land loser is entitled to be trained and recruited as a Group D employee, as a Group D employee. Full stop. it is contended that the petitioner claimed that he was the adopted son of Nagappa and applied on 17/10/2005 for the post of a trainee grade D, as his father was a landloser of survey number 401 and 402 of Devsugur village. It is claimed that the respondent received 554 applications, of which 199 applications were shortlisted. So the petitioner attended the interview on 21/6/2011. Full stop. After such interview, the respondent published an assessment sheet along with list of candidates for further process, and the name of the petitioner appeared at serial number 43. And he was found eligible to be recruited. It further contended that it notified a list of ineligible members, list of members who were not selected, and had also cited the specific reasons. Full stop. Insofar as the petitioner is concerned, it was held that he was not entitled to be selected as his brother, as his cousin had also applied for the post, and his application was at serial number 170, and that the committee, after detailed verification, found that the brother of the petitioner and the petitioner belonged to the same family. It also held that as per the scheme, job would be provided to only one person of the family. And since the petitioner was the adoptive son of Nagappa, and as the deed of adoption was registered after the preliminary and final notification, the petitioner was not entitled to entitled to the benefit of the scheme. Therefore, it contended that the petitioner is not entitled to be recruited as trainee grade D. Full stop. Next further. The purpose of the scheme is to provide an employment to one of the members of the family of the landloser. It is not in dispute that the property which was acquired for the benefit of the respondent, namely the land in survey number 401 and 402 of Devsugur, belonged to Nagappa. Full stop. It is also not in dispute that the brother son of Nagappa had also applied, claiming the benefit of the scheme, and that he was considered for the post. However, the petitioner, being the adoptive son of Nagappa, had also applied. The adoptive son of Nagappa, Nagappa, in terms of a deed of adoption dated 9/11/1998, had also applied for the post. Ideally, between the petitioner and his cousin, one of them was entitled, ideally better, between the petitioner and his cousin, one of them were entitled for an appointment, as both of them belonged to the family of the landloser. Full stop. Now that the brother of the petitioner has given an affidavit that he has no objection, that he is not interested to be appointed as a trainee with the respondent, it is appropriate that the petitioner is granted the benefit. Full stop. The respondent cannot deny the benefit of the scheme to the petitioner on the ground that his adoption was doubtful or that the adoption was not in accordance with law. Full stop. This defense is available only to a member of the family and not to a stranger. In that view of the matter, this writ petition deserves to be disposed of. Directing the respondent, number
Respond 1 and 2.
1 and 2, to forthwith recruit the petitioner as trainee D and also subject him to such training as is prescribed. Full stop. However, since the cousin brother of the petitioner who had undergone training,
But he is not undergone, but he is not at all joined.
not at all joined.
Yes.
Full stop. This shall be done within a period of 3 months. from the-
Let there be observation saying if training is undergone, then we are entitled to recover.
You recover it. You recover it in the
That he is undergone training.
training ಏನ್ರಿ even a space ಕಳಿಸ್ತಿದ್ದೀರಾ?
ಇಲ್ಲ
You're
ಸ್ವಾಮಿ,
not sending him to space.
there is a stipend that is paid at 6,000 rupees per month.
For
Which is
whatever
paid.
that he has done, whatever work that he has done, you are paid. File ಎತ್ಕೊಂಬ, ಪುಸ್ತಕ ತಗೊಂಡೋಗು, ಅಲ್ಲಿ ಕೊಡು, ಇಲ್ಲಿ ಕೊಡು, ಅದು ತಗೊಂಬ, ಇದು ತಗೊಂಬ. He has done work. Where is the question of paying it back? 3 months for compliance.
Very well.
This shall be complied within 3 months from the date of receipt of a copy of this order. Yes. Mr. H.M. Patel. Notice ಆಗಿದೆಯಾ? Yes, Mr. Whether you have use ಮಾಡಿದರೆ ಯಾರು, who is the answering respondent?
3 and
Hmm?
3 and 4.
ಯಾರು ಪಂಚಾಯತ್ ರಾಜ್ ಯಾದಗಿರಿ ಯಾರು? You also appear for executive engineer Panchayat Raj. Huh?
Government will not appear, my lord. Penal advocate.
ಅಲ್ಲ ಯಾದಗಿರಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಅಲ್ಲಿ ಪಂಚಾಯತ್ ರಾಜ್ ಇಂಜಿನಿಯರ್ ಅಂತ ಯಾರು ಇದಾರ? ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ಇದ್ದಾರಾ?
Executive engineer.
ಅವ್ರಿಗೆ ನೀವು ಅಪಿಯರ್ ಆಗ್ಬೋದಲ್ಲ?
ಇಲ್ಲ, my lord, separate penal advocate is.
Issue emergent notice to respondent number 3 and 4. Aske Suryakant.
My lord, I am the petitioner. My land has been utilized by the government, by the state in the year 2010 and 11 without payment of compensation and without recourse to law. So I filed the writ petition. A direction was also issued by this honorable court. When they did not comply with the directions, I filed contempt also, sir. And the detailed order has been passed in contempt proceedings. That may kindly be perused, sir. Page number 41. Accordingly, they paid 22 lakhs against the order of 25 lakhs. And later on, they issued the 11-1 notification, that is a preliminary notification for acquisition of the land. But subsequently, they did not take any further steps. So that proceedings is also vitiated now.
Yes, Mr. Madam.
I will take the notice and I will take the
AG is
extension.
directed to accept notice for respondent number
I have served copy to 1 and 3, 4
1,
and
2,
5 to
3. Urban Development Authority, Bidar yaru?
It is Mali Patil, I suppose.
Huh?
Mali Patil.
Mr. P.S. Mali Patil is directed to accept notice for respondent number 4 and 5.
Sir, 4 is Kashampur.
Huh?
4 is
CMC.
municipality.
Municipals. Kashampur.
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 Yes, sir.
They are not-
Municipality.
5 for B.S. Mali
5 for
Patil.
Mali Patil, sir.
5 P.S. Mali Patil. Hmm. I think the order dated 17/12/2024 granting interim relief shall not be given effect to. Yes. Santosh Kumar Maradi. List after service of notice to respondents 5 to 7.
Already issued.
ಅಲ್ಲ ಇನ್ನು ಸರ್ವ್ ಆಗಿಲ್ವಲ್ಲ?
Please.
List of the service of notice to
interim prayer.
wait, serve ಬರ್ಲಿ ಆಮೇಲೆ move ಮಾಡಿ.
Please.
C number 38.
It may be taken 230.
ಯಾವುದು 38?
38. I have to produce this tender allotment work order copy and a rejection copy.
List 230. Next. So
Hearing for the petitioner.
Harshvardhan.
The petitioners are the owner of land survey number 206/4 and 206/5. And your lordships bar 6 and totally measuring 6 acres 38 guntas, your lordship. Your lordship, the said land was converted into non-agricultural land and layout is also approved by the town and country planning, your lordship. In view of the government order, your lordship, the petitioner sought to deposit 4% instead of 9%. Your lordship, the respondents have sought for the petitioners to deposit 9% for the supervisory charges, your lordship. Your lordship, there is a government order at Annexure E, which says that instead of 9%, it is reduced to 4%. And your lordship, in similar matters, your lordship, this honorable court has also said the 4% will be the appropriate development charges, your lordship, which is at Annexure G.
How much are they claiming?
9%, your lordship. There is a government
Alexa?
order at Annexure E.
Page number 32.
No, that is okay. That is in 2005. ಎಲ್ಲಿದೆ 9% charge ಮಾಡೋದು ನಿಮ್ಮ ಹತ್ರ? What is there to show that they have charged 9%?
Chalan, may. Next year, F Milord, page 31. It's a chalan for Milord 14,50,000 and odd. As against Milord, the estimate of 1,61,20,000. It is at Annexure D, page 19 and 31, Milord, if we correlate.
19,
19 is the estimate, Milord, 1,61 lakhs and odd. For that, Milord, 9% works out to 14 lakhs and odd, Milord, which is the chalan at Annexure F, Milord, page 31.
14 lakhs.
Yes. Similar matters, Milord, the court has said that, Milord, directed to accept 4%, Milord, subject to result of the suit, and Milord, I may be permitted.
ಅದೇ ಇದು 2005 ಅದಾದ್ಮೇಲೆ ತಿರುಗೇನ್ ಆಗಿದ್ಯಾ?
ಇಲ್ಲ ಸರ್.
ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ?
No, Milord, this is holding good, Milord, is my instructions.
ತಾಳಿಕೋಟಿ.
ಹೌದು. The other matter is also pertaining to Milord Tali.
HCGP is directed to accept notice for respondent number 1. Mr. Chaitanya Kumar Chandraki is directed to accept notice for HCGP for 1 and 3.
1 and 3. Only chief officer.
Chaitanya Kumar Chandraki for respondent number 2. The demand of supervision charges at 9%. Demand of supervision charges at 9% by the respondent number 2 is state subject to the petitioners paying supervision charges at the rate of 4% within a period of 4 weeks.
Yes. And Milord, after that payment, I may be permitted to proceed, Milord, that.
It is open for the petitioner to proceed with the development work in accordance with the sanction plan.
Yes, after payment of 4%.
After payment of the supervision charges.
Great.
This is however subject to the result of this writ petition. See number?
40.
Same, your lordship.
Same order. 41.
It's a writ of mandamus, Milord, seeking, Milord, for consideration of representations. My land is acquired, Milord, without acquisition.
AGA is directed to accept notice for respondent number. Boy, KB Jain.
KB Jain.
Yaar,
Krupa
yaar
Sagar.
KB Jain. Krupa Sagar.
Yes.
Krupa Sagar Patil is directed to accept notice for the respondent.
1 and
Next.
2, my lord.
1 and
3 and
2.
4. 3 and 4, my lord, will be government.
3 and 4 government, huh?
Additional special land acquisition officer, assistant executive engineer, Almaty.
3 and 4 government, AGA. Next. Ramachandra K. Ramchandra K. Next is C.
An order of Lord change of mutation entry is made, Lord, in the year 2024, based on Lord 1989 Lord entry or Lord an order. Lord, a suit is also filed by the respondents. The dispute is this, my lord. The original landowner was one Channappa. We are, my lord, the LRs, the petitioners, are his descendants. The contesting respondents, they claim that, my lord, they are the LRs of brother of Channappa, and in partition, they have got this property. Lord, this is the dispute. Lord, based on Lord Virasat, Lord, our entries are there, Lord. Our entries have continued, Lord, till 24. They file an appeal before Lord the Assistant Commissioner.
Is that a registered partition?
No, there is no registered partition.
But on what basis?
It's a proper. Lord, there is no basis for them, Lord, for claiming that. They have filed a suit, Lord, in the year 2023, saying that, Lord, we got that by virtue of a partition. In the alternative, they also sought for a partition. Not that is pending. In the meanwhile, they also seek for Lord change of entries. Our contention is it is exclusive property of that Channappa. I produced the sale deeds.
What has happened to the suit?
That suit is pending. During pendency of the suit, my lord, in an appeal, my lord, the Assistant Commissioner entertains that and he changes the entry in their name, saying that, my lord, based on partition. Lord, they also contend that, Lord, in the 89, there is some entry saying that it should have been in their name based on the alleged, my lord, partition.
1979 ME entry. 1979/89
Yes. Then
that seems that is not produced.
well, it's not.
Produce ಮಾಡಿದ್ರು. But the Learned Counsel for the petitioner is directed to place on record the mutation in DME 1979/89 referred in Annexure C. List after the same is done. Yes, next. Shivanand Patil.
Pertains to Wakf entry in the column number 11.
Pertains to?
Wakf entry in the column number 11, the ROR.
The AG has accept notice for response 1 and 2. PS Mali Patila, yaru?
Yes, ma'am.
Naresh V. Kulkarni.
Naresh Kulkarni.
Is directed to accept notice for response 3, 4, and 5. Till the next date of hearing, the entries made in column number 11 of the land bearing survey number
138 Hissa 5.
138 Hissa B.
Hissa B was earlier, my lords.
Now renumbered as.
Now renumbered as 138 Hissa 5. Situated at Kavitala, Sirvara Taluk, Raichur district, measuring 6 acres, 5 guntas. Is state.
Right.
Yes.
My lord, petitioner and respondent number 1 are husband and wife, my lord. The respondent number 1 is working as a police constable at Women Police Station, Raichur, my lord. She is filed suit for declaration of decree of dissolution of marriage. Along with children's, my lord. The trial court granted maintenance of ₹10,000 to the petitioner, respondent number 1, without issuing notice to the petitioner and passed order annexure B, my lord. So the respondent number one is not entitled to any get maintenance, my lord.
Okay.
As he is having a salary, my lord, for about 42,000 salary, my lord. I produced the certificate, annexure C, my lord.
Annexure?
C, my lord.
Annexure C, page number?
Page number 26, my lord. She is getting net salary of rupees 47,026, my lord.
She is also employed.
She is also employed, my lord. Police constable.
Pyari, no, Pyari Begum.
Pyari Begum, my lord.
ಆಯ್ತು ಮಕ್ಕಳಿಗೆ
ಮಕ್ಕಳ ಬಗ್ಗೆ ನಾನೇ ತಕರಾರು ಮಾಡ್ತಾ ಇಲ್ಲ ಬಟ್ respondent number one is not entitled, man.
ಬರ್ಕೊಳ್ಳಿ issue emergent notice to the respondents. Interim stay of the impugned order subject to the petitioner paying the school fee. Subject to the petitioner paying maintenance of rupees
5,000 respondent number 2 and 3.
Bari 5,000 each.
5,000 each is there, sir.
Subject to the petitioner paying a sum of rupees 5,000 to to each of the respondents 2 and 3.
2 and 3.
Yes, the arrears of maintenance
Against
payable to the respondents 2 and 3 at the rate of 5,000 shall be deposited before the trial court within a period of 4 weeks.
4 weeks.
Yes, next.
Respondent number 1 stayed.
Huh?
Respondent number 1 stayed.
Let's stay at
Yes, please.
Mr. Ganesh Naik.
And the appearing for the petitioner, my lord. The respondent number 5 to 11 is the moved the no confidence motion against the petitioners, my lord. As per the annexure D, my lord, there is the page number 15. My lord, as per the rule 3.1 is the, my lord, is the mentioning the 2 persons where the personally present and give the form with the 9 members is the initial to the my lord is the requisition. But as per the my lord, only the 7 members is the initial there. One bit.
Only one has appeared.
Please, my lord, is the one is the appeared, but my lord is the mentioning is the 2 person and the 9 members, my lord, is the signed in the requisition letter and Baridar.
Sir, how many has to be there have to be 2 persons?
2 persons, my lord.
ಎಷ್ಟು ಜನ appear ಆಗಿದ್ದಾರೆ?
ಅಲ್ಲೇ ಅವ್ರು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ ಎಂಡಾಸ್ಮೆಂಟ್ ಅಲ್ಲಿ melody is the as per the Karnataka Grama Swaraj and Panchayat Raj motion of no confidence against the Adhyaksha and Upadhyaksha rules 1994 as per the rule 3.1 the 2 persons members were the personally present and give the form with the 9 members signed on it ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಎಲ್ಲೋ
page number 15 melody there annexure D.
As per Karnataka Gram Swaraj and Panchayat Raj so 2 persons were personally present and gave form number 1 with 9 members signing on it.
As per the serial melody has the 1, 2 and melody the 5 to 9 is the mentioned. They only there 7 members is the signed the requisition melody.
I didn't understand you.
Melody the 9 members initial ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು requisition ಅಲ್ಲಿ. But only the 7 members is the signed melody.
ಎಲ್ಲಿದೆ ಅದು?
Melody the page ಅದೇ same page 1, 2 5, 6, 7, 8, 9 melody. 3 and 4 is the gap ಇದೆ ಸರ್.
3 and 4 ಎಲ್ಲೈತದು?
ಇಲ್ಲ ಇಲ್ಲ. On base of that, my lord, is the key influenced by the my lord, the third respondent.
What is the total strength of the panchayat?
My lord, is the key 15 members.
15.
Please, well. 14.
14
ಇದೆ ಸರ್.
14
ಹೌದು ಸರ್.
Total strength. How many members have to submit the representation?
Only the 2 person ಅಂತ ಹೇಳಿದ್ರು.
ಎಷ್ಟು ಜನ ಸಬ್ಮಿಟ್ ಮಾಡಬೇಕು ರೂಲ್ಸ್ ಪ್ರಕಾರ?
ರೂಲ್ ಪ್ರಕಾರ 1/3 ಅಂದ್ರೆ my lord is the 4 members ಆಗುತ್ತೆ. 4 members.
4 members. ಇಲ್ಲಿ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
My lord, the 7 members.
ಆಯ್ತಲ್ಲ.
But my contention that my lord has per the key influence under the respondent number 3, my lord. These the persons are the not initial before the key, my lord, is the authority, my lord.
I think
1 minute. Second one, my lord, as per the key import notice, my lord, as per the annexure A, they not a 15 days clear notice, my lord.
ಎಲ್ಲಿದೆ ಓದಿ?
My lord, the page number 9, my lord. Annexure A.
ಯಾವತ್ತು ನೋಟಿಸ್?
24/12/2024, my lord.
ಯಾವತ್ತು?
My lord, we are the key issued on my lord the 26/12/2024.
10, 125. ಎಷ್ಟು
Please.
ದಿನ ಆಗುತ್ತೆ?
16 days.
60 15 ದಿನ ಇದೆಯಲ್ಲ.
But he served on my lord the 26, my lord. He without my lord has the my lord the 24.
ಊರ್ ಬಿಟ್ಟು ಹೋಗ್ಬಿಟ್ರೆ ಸರ್ವ್ ಮಾಡೋದು
My lord has the 26th. My lord is the same is the record is the furnished as per the rule 3.3 ನಲ್ಲಿ my lord ನಾನು ಲಾಸ್ಟ್ ಇರೋ ಪ್ಲೇಸಿಗೆ my lord at least affects ಮಾಡಬಹುದಾಗಿತ್ತು, ವಾಟ್ಸ್ಆಪ್ ಮೆಸೇಜ್ ಕೊಡಬಹುದಾಗಿತ್ತು, RPD ಮಾಡಬಹುದಾಗಿತ್ತು. ಯಾವುದು ಮಾಡೇ ಇಲ್ಲ ಸರ್ ರೂಲ್ 3.3 ನಲ್ಲಿ.
Does it say 15 days clear notice from the date of service? ಕೊಡಿ ಇದು.
Please, my lord.
ಕೊಡ್ರಿ ರೂಲ್ಸ್. ಯಾವ ಸರ್ವಿಸ್ ಆಗಿದ್ ನೋಟಿಸು?
26 ಆಗಿದೆ.
ಅಲ್ಲ ನೀವ್ ಹೇಳೋದು, ಅವ್ರು ಹೇಳೋದು ಹೇಳ್ಬೇಕು. ಗವರ್ಮೆಂಟ್.
My lord, notice issued on 24/12, my lord.
ಯಾವತ್ ಸರ್ವಿಸ್ ಆಗಿದ್ದು?
26/12 ತೆಗೆದುಕೊಂಡು ಇನ್ನೊಂದು ಅನಕ್ಸರಿ ಕೆಳಗಡೆ.
ಯಾವತ್ ಸರ್ವಿಸ್ ಆಗಿದ್ದು ಯಾವತ್ತು ಅಂತ? 24ನೇ ತಾರೀಕೆ ಸರ್ವ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ 26 ಅಂತ ಹೇಳಿ ಅನಕ್ಸರಿ ಇದರಲ್ಲಿ ಕೆಳಗಡೆ
ಅವ್ರು ಬರ್ಕೊಂಡಿರೋದು.
ಐ ವಿಲ್ ವೆರಿಫೈ ಮಾಡಿ.
ನೀವ್ ಯಾವತ್ ಸರ್ವ್ ಮಾಡಿದಿರ ಅಂತ ಹೇಳ್ಬೇಕಲ್ಲ.
ಆಯ್ತು 2:30 ಆಯ್ತು.
ಹ್ಮ್ 2:30 ಪಾಸ್ ಓವರ್.
Please.
ಇವನ್ ಅಸ್ಯೂಮಿಂಗ್ ಮಾಡ್ಬಿಡ್ಸ್ ಆಸ್ ಪರ್ 26 ಹಿಡಿದ್ರು ಸಹಿತ 15 ದಿವಸ ಕ್ಲಿಯರ್ ನೋಟಿಸ್ ಆಗುತ್ತೆ.
ಹೆಂಗಾಗುತ್ತೆ?
26, 27, 28, 29, 30, 31 6 days.
26 ಬಿಡ್ಬೇಕಲ್ವಾ?
That even if that is left, that 10 ಈ ಕಡೆ 10 ದಿವಸ.
27, 28, 29, 30, 31.
10 days.
10 days ಆಯ್ತು.
ಈ ಕಡೆ 9 days.
ಬಟ್ ಇದು 10th ಡೇ ಇಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ 15th.
ಯಾವ್ದಾದ್ರು ಒಂದು ಹಿಡಿ. One day has to be.
ಇಲ್ಲ
15th
first
day
time my lord last day my lord has the exclude ಮಾಡ್ಬೇಕಂತ judgment.
This is the second round of litigation, my lords. Already one time ಆಗಿದೆ, ಸ್ಟೇ ಆಗಿತ್ತು, ಅಡ್ಜನ್ ಆಯ್ತು. ಆದ ನಂತರ this court has directed.
ನೋಡಿ ಹೇಳಿ ಅವ್ರು ಯಾವತ್ತು ಸರ್ವ್ ಆಯ್ತು ಅಂತ.
Please.
ಪಾಸ್ ಓವರ್. ಭೀಮಾಶಂಕರ್.
For petitioners, writ of mandamus directing to consider the annexure B, my lord.
Mandamus for what?
Direction seeking implementation of the order.
Tahsildar as order passed, my lord,
Removal of the entry made in the column number.
made in column number 11.
ಯಾವಾಗ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀರಾ?
Yes,
ಯಾವಾಗ?
my lord, within 4 weeks.
4 weeks ಅಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಬಂದು ಹೇಳಿ. You will not again come to your office.
My lord, next care.
ತಹಸೀಲ್ದಾರ್ ಕರೆಸಿ ತೆಗೆದಾಕಿದೆ ಅಂತ ಬಂದು ಹೇಳಿ. ಜನಗಳು ಅವ್ರ ಕೆಲಸ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ನಿಮ್ಮಿಂದ ಸುತ್ತಾಡೋದೇ ಕೆಲಸನ. ನೀವ್ಯಾವ ಕೆಲಸ ಮಾಡೋದು ಮತ್ತೆ? You complain and come and report to the court.
My lord, it may be taken tomorrow, my lord, I will.
AGA is directed to accept notice for respondents to 4. The respondent number 4 is directed to be present before this court on yavat.
ಇಲ್ಲ tomorrow I will comply, my lord. I will.
Comply ಮಾಡಿಸ್ತೀರಾ? Yes. ನಾಳೆ ಕರೀಲಾ? List tomorrow.
Please.
Mahesh Patil.
My lord, the petitioner, my lord, is an elected panchayat member. My lord, the
petitioner is a
my lord, elected, my lord, panchayat member. My lord, the fourth respondent, my lord, the chief executive officer, my lord, he sends a proposal to the regional commissioner, my lord, alleging certain misconduct, my lord, with in respect of an events, my lord, prior to, my lord, he becoming, my lord, as being elected as a panchayat member. For those things, my lord, there is no prohibition for him to, my lord, do those acts. Now, my lord, he sends a proposal to regional commissioner. My lord, regional commissioner, my lord, has issued a show cause notice, my lord, which is under challenge, my lord. Now, at page 11, my lord, annexure B.
Notice ಹೆಂಗ್ challenge ಮಾಡ್ತೀರಾ ನೀವು?
my lord, because my lord, he is not empowered. It is the government, my lord, who has to issue the show cause notice, and he has started a full-fledged inquiry against me by again, my lord, issuing notices, summoning witnesses, materials, and my lord, and extraneous documents. Now, my lord, this notice, my lord, at page 11, my lord, it is issued, my lord, under 43A, it is mentioned, my lord, page 12, under 43A, my lord, of the, my lord, the Panchayat Raj Act. Now, my lord, 43A, my lord, is very clear.
Yes.
My lord, the government, if it thinks fit on the recommendation of the Gram Panchayat or otherwise, may remove any member after giving him an opportunity of being heard, and after such inquiry, as it deems fit necessary, if such member has been guilty of misconduct in the discharge of his duties or any disgraceful conduct, or has become incapable of performing his duties as a member. My lord, it is very clear, my lord, that the government, my lord, has the, my lord, power to issue notice and to make inquiries, my lord, if they deem fit.
Yes.
Now, my lord, this is now not only the show cause notice is issued, and further notices are issued, my lord, to, my lord, conducting a full-fledged inquiry, which is at page 39.
No, but there is a government order, if I remember, authorizing the regional commissioner to look into all these cases.
But, my lord, here in the show cause notice, he, my lord, themselves, page 12 ಅಲ್ಲಿ government ಗೆ ಯಾಕೆ recommend ಮಾಡಬಾರದು ಅಂತ, my lord, they issue show cause notice. If it is so, my lord, 43A ಅನ್ವಯ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸದಸ್ಯರು ನಿಮ್ಮನ್ನು ತೆಗೆದುಹಾಕಲು ನಿಮ್ಮ ಸದಸ್ಯತ್ವ ರದ್ದುಪಡಿಸಿ ಸರ್ಕಾರಕ್ಕೆ ಏಕೆ ಶಿಫಾರಸು ಮಾಡಬಾರದು ಅಂತ ಹೇಳ್ತಾರೆ. And, my lord, 43A, my lord, government is empowered, and, my lord, now they have launched a full-fledged inquiry, my lord, which are not empowered, and even otherwise, my lord, these, my lord, 43A, my lord, provides, my lord, during the course of his, my lord, the office. Now, these allegations, my lord, holding of an APL card, and, my lord, and receiving some remuneration. That, my lord,
submit your reply first and then come to the court.
As, my lord, I have replied, my lord. I have replied. That is.
Where is your reply? Annexure F.
Yes, Lord. Annexure F. And, my lord, on each, my lord, point, my lord, I had, my lord, submitted saying as to these are all the events, my lord, prior to, my lord, I becoming a member. And, my lord, and there is no misconduct even on that, in that context also. And, my lord, hence, my lord, they cannot, my lord, prima facie, my lord, conduct an inquiry. Now, my lord, they are, my lord, Annexure G, my lord, page 39, page 40, my lord, the relevant portion.
Now that you replied, should you not allow the authority to decide this?
My lord, here, my lord, two things, my lord. One, my lord, the 40, in terms of 43, my lord, my lord, the government has to, my lord, take a decision, my lord, with regard.
Government.
Take notice here.
ಯಾವಾಗ ಹೇಳ್ತೀರಾ?
Within 1 week.
My lord, in the meanwhile, my lord, let them not proceed, my lord. They are conducting.
ಯಾವತ್ತಿಗಿದೆ? Is any date fixed?
Yes, my lord. My lord,
ಯಾವತ್ತಿಗಿದೆ?
16 and 17 ಕೊಟ್ಟಿದ್ದಾರೆ.
16th and 17th. Are you sure?
I'm not sure, my lord.
But if you are not sure, how are you making a
my lord, my lord, this month, month ಅಲ್ಲಿ
is directed, corrected date. HCGP is directed to accept
yes,
notice for the respondent number
1 to 3.
1 and 2.
1 to 3.
1 to 3.
My lord, in the meanwhile,
Is
my lord,
directed to secure instructions
Please.
as to whether the respondent number 1 or the regional commissioner, yes, the respondent.
Respondent number 3.
Whether the respondent number 3 is authorized to conduct an inquiry under section 43A against the petitioner. List on 16th.
16.
Yes.
In the meanwhile, my lord, let them not proceed, my lord, against the. ಯಾಕಂದ್ರೆ ಅವರು
ಯಾವತ್ತಿದೆ ಅಂತ
notices
ಗೊತ್ತಿಲ್ಲ.
my lord,
Yes,
ಇದರಲ್ಲಿ my lord, page 40 ಅಲ್ಲಿ the last, my lord, 12 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅವತ್ತು ಯಾರನ್ನೊಬ್ರು ಸಾಯಿಸಿ ಅಷ್ಟೇ.
Please.
Sachin Mahajan.
Lord, appear for the petitioner. Lord, annexure, Lord, E, the impure tender notification, which is at page number 20, Lord, is called in question. The HESCOM, Lord, that is Body Electricity Company, has invited tender, Lord, for repair and reconditioning of faulty conventional, Lord, transformers of various capacities. In that, Lord, page number 21, if your Lordship kindly sees, condition number 7, I am a manufacturer and, my lord, I'm into repairs.
Should it go before the Dharwad bench?
My lord, this is pertaining to the work, my lord, of Bijapur district.
Bijapur district.
Yes.
Ah.
Condition number 7, my lord, it is, my lord, deliberately designed to keep, my lord, the manufacturers out of the fray. What it says, my lord, the bidder into bracket transformer repairer should have repaired minimum 80% of the field distribution transformers at respective divisions, subdivisions, that is 427 numbers, in any of the preceding 5 years. My respectful submission, my lord, the material that I have placed at annexure A to C, my lord, it reflects, my lord, that I am a manufacturer who has the wherewithal, my lord, of rendering the service, my lord, including the repair. Now, what they have deliberately done, my lord, is they have kept out, my lord, the manufacturers out of the fray. In fact, my lord, in a similarly situated matter pertaining to this very petitioner, my lord, in WP number 200405 of 2023, my lord, there was an interim order permitting, my lord, the petitioner to participate. I am both manufacturer, my lord, and servicer. Or deliberately I am kept out. All other conditions, my lord, I fulfill. I hold the MSME certificate, the GST, EPF, everything.
Good. Yeah, the writ petition is dismissed as infructuous and then.
Although my Mulad, I did not succeed, Mulad, in the bid, but nevertheless, Mulad, I produced both the copies. It was, Mulad, I failed in the
copy.
writ petition, Mulad, it was withdrawn, Mulad, on 13th of March 2023 because I could not succeed in the financial bid, Mulad, I had to withdraw. The only grievance I have, Mulad, is it is designed in such a way, Mulad, to deliberately keep me out. Me or, Mulad, similarly placed persons. What is required, Mulad, to be seen is whether I have the wherewithal, Mulad, to carry out the work.
Barcode. ಯಾರು ಹುಬ್ಬಳ್ಳಿ ಎಲೆಕ್ಟ್ರಿಕ್ಸ್ ರವೀಂದ್ರನ
Mr. Ravindra Reddy, Mulad.
Ravindra Reddy is directed to accept notice for respondents. It is the case of the petitioner that is a manufacturer of
I am a manufacturer and
equipment, manufacturer of electrical equipment such as motors, generators, transformers, and electric distribution and control apparatus. Full stop. It is his case that the respondents have invited bids for repair and reconditioning of faulty conventional and BEE, any star-rated distribution transformers of various capacities of different makes at Chadachan subdivision. Full stop. It is his case that the respondents have incorporated a condition in the notification inviting bids that the bidder should have bidder bracket transformers repairer get close should have repaired a minimum 80% of average failed distribution transformers at respective division in 5 preceding years. Full stop. This he contends is designed to keep the petitioner out of the bidding process. He contends that the petitioner has all the expertise to not only manufacture but also repair transformers, and therefore this condition should not come in the way of the petitioner participating in the tender. The contention appears to be reasonable, and therefore
the petitioner deserves to be granted permission to participate in the bid for the aforesaid work invited by the respondents 1 and 2. However, this shall be subject to the result of this writ petition.
May I seek, my lord, the hand delivery of the interim order? My lord. Today is the last date.
No, you will get it tomorrow. Yes, next.
Today is the last date, my lord, of
Right, hand delivery, yes.
highly obliged.
Ratna Shivayogi Mutt.
My lord, here the respondent was dismissed from the petitioner corporation in the year 2012. And the
Urgent notice. Whether reinstatement is ordered.
Yes, my lord.
The petitioner shall pay 17B wages subject to the respondent filing an appropriate affidavit. Yes. Reinstatement is there an order of reinstatement?
Yes, my lord.
The impugned order reinstating the respondent.
After reinstatement, they again filed before the labor court the under the Industrial Dispute Act, my lord, for payment during the due time.
Now, what have you sought for?
My lord, here in the labor court under the section 33C2 of ID Act, the amount during the due period is granted, my lord. But it is calculated by the counsel for the petitioner corporation without getting instructions from the corporation, my lord. The calculation is not at all in the consent of the corporation. And based on that calculation, the labor court has allowed the application. Quashing the annexure F, my lord. Order passed by the labor court, which is at annexure F, my lord.
Yes. Deposit money.
My lord.
Deposit this money subject to the outcome of the writ petition. You deposit this money, madam.
Please.
Interim issue emergent notice. Interim stay of the impugned order subject to the petitioner depositing rupees 1,47,000 before the labor court Kalaburagi within 6 weeks from today. However, the said amount shall not be released to the respondent without orders from the court, from this court. Yes. Gurraj Bhandari. Gurraj Bhandari.
For the petitioner, your lordships, it is a case wherein your lordships petitioner is a student of respond number 2 college, admitted for 3 years course, your lordships. Examination fees has not been accepted. He has made a representation on 21/12/2024, requesting to accept the examination fees. Last date for examination fees was 31/12/2024, your lordships. The representation has not been considered. Your lordships, due to oversight, your lordships,
KSLU.
Mr. Subhash Malapur and Mr. Mantesh Patil both.
Mr. Mantesh Patil is directed to accept notice for response 1 and 3. Notice to R2 is dispensed.
Your lordships, due to oversight, I have not sought for an interim relief. Examination is ensured to commence from 20th of this month, your lordships.
20th of this month?
Yes, your lordships. For that
List
reason,
on yavattu?
It may be taken on Monday or Tuesday.
Seeking permission
Monday or Tuesday. Monday, madam.
Education matter yavattu puttidi?
We've taken 16th, it may be taken, my lord.
Thursday.
Please,
I am permitted to pay the examination fees, your lordships. That is the
Meanwhile,
application.
Let him pay the fees.
Right, right. 16th.
16th, please.
ಅಲ್ಲ ಸ್ವಾಮಿ 20ನೇ ತಾರೀಕೆ ಇದೆ ಆಲ್ ಟಿಕೆಟ್ ಎಲ್ಲ ಇಶ್ಯೂ ಆಗ್ಬೇಕು.
ಆಯ್ತು 16 ತಾರೀಕು ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಡ್ತೀವಿ, ಹೋಗಿ ಫೀಸ್ ಕಟ್ಟಿ. ಏನು ಎಸ್ ನೆಕ್ಸ್ಟ್? Ravi B. Patil.
Petitioner number 1 is owner of this land in survey number 127. Petitioner is the owner of the land in survey number 127/7, your lordships. His name is already entered in the digital khata also, your lordships. Petitioner number 2 have approached this person, petitioner number 1, to purchase the land. The sub-registry office have illegally cancelled all the layout was formed in this survey number, your lordships. This person had sought to purchase the same land, and when he had approached the
Yes, madam. Yaar, who appears?
Respond number 1 and 3 kindly.
Yaar.
Deputy Commissioner Bidar and Sub-Registrar.
HCGP has directed to accept notice for respond number 1 and 3. Jilla Panchayat, Bidar, Yaro. Prashant is Kuman for respondent number 2.
Krupa Sagar Patil. Krupa Sagar Patil.
Krupa. Alright, Prashant Kuman. Yes, next.
Lordships, till then there may be interim.
What interim relief?
Annexure D and E may be stayed, your lordships.
Madam, it's already cancelled.
That is illegally been done, your lordships. Impugned order is at annexure C, which have been stayed by the
ಪ್ರಯುಕ್ತ ಬೀದರ್ ತಾಲೂಕಿನ ಜನವಾಡ ಸಂಸ್ಥೆ 15
more than 200 allotments have been illegally cancelled, your lordships. Behind the back of the petitioner number 1, impugned order.
There's some proceedings pending under section 269.
According to that, they have cancelled, your lordships. Annexure E, page number 30 is the order.
Annexure?
E, page number 30.
Hmm.
Here they tell that more than 200 digital khatas behind the back of the all over 200 digital khatas have been cancelled, your lordships. This petitioner was neither given any prior notice before cancelling the mutation and this digital khata is still valid in this petitioner number 1's name, your lordships.
Where is the khata in
Annexure
your
B.
annexure?
B, page number 23. Only when petitioner number 2 had sought to purchase and he had uploaded all the required documents online, your lordships, only then this was brought to our notice.
Well, there's some kind of everybody are involved. No conversion, no plan.
Conversion was already done, your lordships.
Where's the plan? 8 acres of land.
No,
You form a 20 feet road, 10 feet road, 15 feet road. And khatas are given. Panchayati ಹೋಗ್ತಾರೆ, ದುಡ್ಡು ಕೊಡ್ತಾರೆ, ಅವ್ರು ಖಾತೆ ಮಾಡ್ತಾರೆ.
As regards petitioner number 1, your lordships, he is owner only to an extent of 2 acres and 1 gunta. And this was already got converted by his previous owner.
There's interim stay of the impugned order till the next date of hearing. Yes.
This is identical as previous one, my lord.
Same order, ma. Emergent notice, deposit of so and so, Within 4 weeks, 6 weeks,
6 weeks.
6 weeks. Yes. Ganesh Subhash Chandra Kalaburagi.
For the petitioner, your lordships.
Hmm?
For the petitioner, your lordships, it is a case wherein your lordships, respondent number 4 and 5 have filed a previous writ petition, wherein they have been issued with the notice from the respondent number 3 corporation, your lordships, for having constructed by encroaching the road area. That notices were challenged, your lordships, and thereafter that writ petition was disposed of on the memo filed by the respondent number 3 corporation, saying that they will hand over the possession and with liberty to initiate action under the proceedings of Karnataka Municipal Corporation Act. Your lordships, the issue in that writ petition was, your lordships, CTS number 1614 and 1615. Whereas now, your lordships, after disposal of that writ petition, now they are making construction by encroaching the road area in respect of 1604, your lordships, which is my property. In fact, that writ petition was filed on 29/11/2024. On the same day, the writ petition was listed, and it was adjourned at the request of petitioner. And without there being notice, your lordships, on 2/12/2024, the commissioner files a memo undertaking to hand over the possession. Previously, your lordships, other localities have filed a writ petition.
Take out notice
Your lordships, I am seeking an interim relief.
of what?
Your lordships, directing the respondent number 3 to not to permit, your lordships, the respondent number 4 and 5 to construct in the area, your lordships, encroaching the road portion.
What is there to show that your property is adjacent to the property of the
Your lordships, I have enclosed the CTS map, your lordships.
Illide.
Annexure B.
Annexure?
B, your lordships, page 30. 30. 1604, your lordships, is on the right side, your lordships. It is a triangular portion, your lordships. On both the side, your lordships, there is a road, even on the north side and even on the south side. They are encroaching on the southern portion, your lordships.
Now, where is your property?
1604, your lordships. Entire 1604 is my property.
Our property is one.
Or property ne illa swami. Or oath sati writ petition hakid on the basis of lease deed without producing the lease deed. And they, your lordships, produce a trade license, and it is pertaining to ward number 4, whereas the present survey number, CTS number, is of ward number 3. Your lordships, the previous writ petition which they have filed, the copy of it.
What is it? What is the writ petition number?
Your lordships, 203385, your lordship.
203385.
And close the judgment copy. In that, your lordships, they claim their property to be there in the CTS number 1614/1615.
Respondents are idರಲ್ಲಿ demolition structure put over the petition also without finding the but remember this counter
In their writ petition, your lordship, they claim that they have obtained the premises by way of an lease in respect of CTS number 1614/1615.
No, correct, but ಇದೆಲ್ಲ civil dispute ಅಲ್ವಾ?
Your lordships, because of, your lordships, previously there was a litigation filed by the other localities of the same ward, wherein, your lordship, direction was given to the respondent number 3 corporation to consider their grievance and address their grievance. And thereafter, your lordships, they have not considered it. Contempt proceedings were initiated. In the contempt proceedings, your lordships, on the same day, that is on 2/12/2024, the respondent number 3 corporation files an affidavit saying that, your lordships, all the encroachments will be removed. I have enclosed the contempt order also. Noting the affidavit filed by the respondent number 3 corporation, your lordships, the contempt petition was dropped. On the same day, your lordships, he makes the submissions in the writ petition saying that the portion will be handed over. It is not that, your lordships, it is the road portion which they are encroaching along with my property, which is left out for setback.
No, but then you have to go for the civil court, alva.
Because of these proceedings, your lordships, they have got the right. In the writ petition, they have been permitted to construct, if I am permitted to read the relevant portion, your lordship.
Seek for review of this order.
Page number 42, even these honorable court has not permitted them to construct over the road portion, your lordships. Page number 42, para 8. Upon restoration of possession of the subject property by the respondent number 2 to the petitioners, the petitioner would be entitled to put up a structure on the subject property. The subject property here is 1614/1615, not 1604. The writ petition.
ಇಲ್ಲಿ 1614.
Para 1, your lordships, page 7 of my memo.
Para?
1. The petitioners are running fruit shop and shop bearing CTS number 1614/1615 situated at ward number 3, so and so.
Purple. AGS, HCGP is directed to accept notice for response 1 and 2. CMC Vijaypura.
My lordship, Mr. Amresh Rosa.
Amresh Rosa is directed to accept notice for response number 3. Till the next date of hearing, the respondent number 3 is directed to ensure that the respondents 4 and 5 shall not put up any construction over the property bearing CTS number 1604.
Yes.
Of?
Situated in ward number 3 of Vijaypur district.
Situated in ward number 3 of Vijaypur. Amir Hamza. Yes.
As per another A, petitioner was selected for the providing e-tender transportation of the food grains. Page number 10, my lord, serial number 13.
Yes.
Against this order, the respondent number 3 and 4 are filed before appeal filed before the commissioner, and as per annexure B, the appellate authority is passed the order. As per the order, the respondent number 1 till date not passed any order, sir. Still date not passed any order, sir. Page number 14, my lord.
ಏನಂತಾಗಿದೆ ತಾಂತ್ರಿಕ ಬಿಡ್ಡುಗಳನ್ನು ನಿಯಮಾನುಸಾರ ಮರುಪರಿಶೀಲಿಸಿ ಆದೇಶ ಹೊರಡಿಸಲು ಸೂಚಿಸಿದೆ.
ಹೌದು ಸರ್. 1.5 ತಿಂಗಳಾಯ್ತು ಸರ್, ಇನ್ನೂವರೆಗೆ ಆರ್ಡರ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಯಾರು?
Respondent number 1, my lord.
Yes, HCGP is directed to accept notice for response 1 and 2. Issue emergent notice to respondents 3 and 4. ಬೇಕಂದ್ರೆ notice 3 and 4 ಗೆ?
ಬೇಕಾಗಿಲ್ಲ ಸರ್, ಬಟ್ ಅಪೀಲ್ ನಾಗ ಇದ್ದಾರಂತಂದು ಇದು ಮಾಡಿದ್ದೆ ಸರ್. ಬಟ್
get instructions madam. ಯಾವತ್ತು? 16th. All other cases are too correct.
My lords, one submission. My lords, one submission. Serial number 11. Seek apology for infructuous on the basis of submission made by the respondent. It becomes infructuous. It is not become infructuous, my lords. I have challenged notice as well as representation. There is a stay order by this honorable court. Meeting is not held. Meeting agilla ಏನು ಆಗಿಲ್ಲ. Infructuous ಆಗಿಲ್ಲ ಅದರಲ್ಲಿ. Await notice ಅಂತಿದೆ ಅದರಲ್ಲಿ.
ಅಲ್ಲ ಏನು infructuous ಅಂತ ಹೇಳಿದಾರೆ ಅವರು?
ಇಲ್ಲ, ಎಸ್.
ಪಾಸ್ವರ್ ಆಗಿದೆ ಹೆಂಗೆ ಇದು?
ಇಲ್ಲ, infructuous dismissed ಅಂತ ಆಗಿದೆ.
ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ ಬಂದು ಹೇಳಿ.
ಎಸ್ ಪ್ಲೀಸ್.
ಕರ್ಕೊಂಬನ್ನಿ ಅದರ್ ಸೈಡ್.
ಬಂದಿದ್ದಾರೆ.
ಏನ್ ಮಾಡಿದ್ರು ಸರ್? ಸರ್ 54 ಏನ್ ಮಾಡಿದ್ರು? ಅದೇ 16 ಅಂತಂದ್ರೆ ನೀವು 20 ಅಂದ್ರಲ್ಲ?
ಮಧ್ಯಾಹ್ನ ಕಂಟಿನ್ಯೂ ಆಗತ್ತಾ? ಸರ್ ಮಧ್ಯಾಹ್ನ ಕಂಟಿನ್ಯೂ ಆಗತ್ತಾ? ಸರ್ ಮಧ್ಯಾಹ್ನ ಕಂಟಿನ್ಯೂ ಆಗತ್ತಾ? ಸರ್
Sir, list ಬರ್ತಾ ನಾವು ಹಂಗೆಲ್ಲ ಹೌದು $340.
Subramanya Bhatt.
Lord, I appear for the petitioner, my lord, in this case. Lord, in this case, the respondent, my lord, has filed a statement of objections to the review. Lord, a copy of which is also served on me. Now, my lord, the ground, my lord, with which I have sought for review of the order passed by your lordship is that, my lord, kindly have a look at the order passed by my lord at page 15, annexure A.
Yes.
I'll straight away invite my lord's kind attention to para 8 at page 21. Para 8 at page 20, in page 21, my lord.
Yes.
The contentions of the petitioner raised in this writ petition revolve around two grounds, namely, presenting officer who was the disciplinary authority was cited as a witness. Insofar as this contention is concerned, there is nothing to show that the presenting officer had any role in framing the articles of charges against the petitioner. There is also nothing to show that the presenting officer was the disciplinary authority. There is also nothing to show that the inquiry report submitted would be placed before the respondent number 2, who is the presenting officer. In that view of the matter, the contention of the petitioner that the presenting officer was also during the cap of disciplinary authority cannot be accepted at this stage. Insofar as the contention that the articles of charges was not produced before the committee for ratification, the inquiry proceedings cannot be halted on that ground since everything is still in fluidic state. The disciplinary authority is bound to look into these issues before accepting the report of the inquiry and thereafter take appropriate decision in that view of the matter as rightly so and so, so and so. Now, my lord, my main contention was that, my lord, this respondent, one Mr. Pradeep Kumar, my lord, who is arrayed as the third respondent, my lord, who was the disciplinary authority, he issued the charge sheet, then he became a witness, my lord, in the inquiry, and ultimately, my lord, now, after conclusion of the inquiry report has been sent to him for further action. So now, my lord, he becomes a judge in his own cause, apart from becoming a witness. So, my lord, that is where, my lord, I pointed out the error. So, therefore, my lord, my lords were kind enough to stay the order passed by your lordship on the last occasion.
Yes, Mr. Somseth.
My lord, I mean, I have already filed statement of objections, my lord, in that it is made very clear, my lord, at para, let me kindly have it at para 4, my lord, of my statement of objections. In para 6, 7, and 8 of the review petition, it is contended that the respondent number 2 has embroidered tendered evidence against the petitioner, and thus the respondent number 2 has played a role of disciplinary presenting officer and witness, and this is unheard in service law is totally untenable basis. The respondents
ಇದು respondent 2 na 3 na ಇದು
2 and 3 both is the same person. 2 and 3 are same.
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 4 ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದಿರಲ್ಲ.
ಅಲ್ಲಲ್ಲ ಅದೇ respondent 2, 3 are the same, my lord. One is managing director, one is Adarsh Film Institute represented by MD ಅಂತ ಇದೆ. I made it very clear in the statement of objections dated 9/2/23 in paragraph 5 that as per the rule of necessity, since there is no other person except the managing director to perform the acts of disciplinary authority, issuing charge sheet, acted as presenting officer, and also gave evidence on the misconduct committed by the petitioner. Paragraph 5 of the statement of objections dated 9/2 is reproduced here below. It is relevant to submit that the petitioner has indulged in serious acts of misconduct or misappropriating 20,000 to 32,000 as indicated in charge sheet dated 6/12/2018, Annexure B. The inquiry officer was appointed, and since there are no employees except the managing director and the executive committee, the respondent 2 and 3 as managing director being the disciplinary authority issued charge sheet and acted as presenting officer and also gave evidence on the misconduct committed by the petitioner. This is as per the rule of necessity, since there is no other person except the managing director to perform the above acts. Executive committee is the final authority for appointment of termination or dismissal of the employee. Then you will ask me kindly say I have produced the resolution at page 8. The typed copy, it is dated 14/10/2024. The typed copy is at page 11, my lord. It is the executive committee which has taken, my lord, page 11, paragraph 2, my lord. Writ petition number 21/632 of 2002 dated 19/9/2024 ಆದೇಶವನ್ನು ಸಭೆಯಲ್ಲಿ ಮಂಡಿಸಿ ತೆಗೆದುಕೊಂಡ ನಿರ್ಣಯ. ಸಭೆಗೆ ಮೇಲ್ಕಂಡ ಕೋರ್ಟ್ ದಾವೆ ನಂಬರ್ ದಿನಾಂಕ ಸೋನ್ಸೋ ಆದೇಶದ ಪ್ರತಿಯನ್ನು ಎಲ್ಲಾ ಸದಸ್ಯರ ಗಮನಕ್ಕೆ ತಂದು ಸುದೀರ್ಘ ಚರ್ಚೆಯಾದ ನಂತರ ಕೆಳಕಂಡಂತೆ ಸರ್ವಾನುಮತದ ನಿರ್ಣಯ ಕೈಗೊಳ್ಳಲಾಯಿತು. ಮಾನ್ಯ ಹೈಕೋರ್ಟ್ನ ಆದೇಶ 19/9 ದಿನಾಂಕದ ಆದೇಶವನ್ನು ಪರಿಗಣಿಸಲಾಯಿತು. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ವಿಚಾರಣಾಧಿಕಾರಿಗಳ ವರದಿಯನ್ನು ದಿನಾಂಕವನ್ನು ಪರಿಶೀಲಿಸಿ ಈಗಾಗಲೇ 9/11/22 ಎರಡನೇ ನೋಟಿಸ್ ಜೊತೆಯಲ್ಲಿ ಟೈಪೋಗ್ರಫಿಲಿ ಎರರ್, ಸಾರಿ ಮೇಡಮ್, ನೋಟಿಸ್ ಜೊತೆಯಲ್ಲಿ ವಿಚಾರಣಾಧಿಕಾರಿಗಳ ವರದಿ ಮತ್ತು ನಿರ್ಣಯಗಳನ್ನು ಕಳಿಸಿಕೊಡಲಾಗಿದೆ. ಕಾರ್ಯಕಾರಿ ಸಮಿತಿಯು ಮತ್ತೊಮ್ಮೆ ವಿಚಾರಣಾ ವರದಿ ಹಾಗೂ ದಿನಾಂಕ 3/12 ಪರಿಶೀಲಿಸಿ ದೋಷಾರೋಪ ಪಟ್ಟಿಯಲ್ಲಿ 6/12/18 ಮಾಡುವ ಅಪಾಂತರ ಸಾಬೀತಾಗದೆ ಕಂಡು ಬರುತ್ತೆ. ಆದ್ದರಿಂದ ಶ್ರೀಯುತ ಎಚ್ ಆಂಜನಪ್ಪ ಎರಡನೇ ಕಾರಣ ಕೇಳಿ ನೋಟಿಸ್ ಅನ್ನು ಕೊಟ್ಟು 15 ದಿನಗಳೊಳಗೆ ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಲು ಅವಕಾಶ ಕೊಡುವುದು. ವಿಚಾರಣಾಧಿಕಾರಿ ವರದಿ ಹಾಗೂ ನಿರ್ಣಯಗಳನ್ನು ಒಪ್ಪಿಸಿಕೊಳ್ಳುವುದಕ್ಕೆ ಅಂಜನಪ್ಪ ಏನಾದರೂ ಆಕ್ಷೇಪಣೆ ಇದ್ದರೆ ಸಲ್ಲಿಸಲು ಅವಕಾಶ ಮಾಡಿಕೊ. ಆದ್ದರಿಂದ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿಯ ವಿಚಾರಣಾಧಿಕಾರಿ ನಿರ್ಣಯದಂತೆ ಕಾನೂನು ಪ್ರಕಾರ ಮುಂದಿನ ಕ್ರಮ ಜರುಗಿಸಲು ನಿರ್ಣಯ ಕೈಗೊಂಡು ಅಂಜನಪ್ಪನ 21ನೇ ಕಾರಣ ಕೇಳುವ ಸೆಕೆಂಡ್ ನೋಟಿಸ್ ಮಾಡಿ ತಲುಪಿದ 15 ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸದಿದ್ದಲ್ಲಿ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿಯು ಕಾನೂನಿನ ಪ್ರಕಾರ ಮುಂದಿನ ಕ್ರಮ ಜರುಗಿಸಲಾಗುವುದು ಎಂದು ತಿಳಿಸುವುದು. ಈ ಬಗ್ಗೆ ಎರಡನೇ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್ ಅನ್ನು ಇಂದಿನ ಕಾರ್ಯಕಾರಿ ನಿರ್ಣಯದಂತೆ ಎರಡನೇ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್ ಅನ್ನು ನೀಡಲು ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕ ಆದೇಶ ನೀಡಲಾಗಿದೆ. So it is the executive committee which is taking final decision. But here,
what is the law and the rule of necessity?
My lord, for example, my lord, I am the proprietor of a company. So misappropriation assault takes place on me.
What is the law and the rule of? What is the law and the rule of necessity? You have quoted rule of necessity.
Rule of necessity, my lord. I mean, there is no other person to take these actions except the executive, which is the final authority.
Then the committee must have been the disciplinary authority.
I mean, that's what they are taking the final discipline, my lord. Because regarding issue of charge sheet and all that, the managing director is appointed because Annexure B may kindly be, he is appointed by the managing director.
In Delhi, ಏನಾದರೂ discipline regulations ಇದೆಯಾ ನಿಮ್ಮಲ್ಲಿ?
ಇದೆ.
C&D regulations ಇದೆಯಾ?
C&D regulations ಎಲ್ಲ bylaws ಇದೆ ಅಷ್ಟೇ.
ಆಯ್ತು, ಏನಂತ ಹೇಳೋದು bylaws?
ಅಲ್ಲ, bylaws ಅಲ್ಲಿ ಅದೇನೆ, the managing director can issue charge sheet and the committee is the final authority to dismiss him.
Yes, Mr. Subramanya, but
ಮ್ಯೂಟ್ ಆಗಿದೆ ಕೃಷ್ಣ ಭಟ್, ಸುಬ್ರಹ್ಮಣ್ಯ ಭಟ್ ಮ್ಯೂಟ್ ಆಗಿದೆ ನಿಮ್ದು.
I request your lordship to kindly turn to the statement of objections filed by the respondent, my lord, at annexure R2B, that is found at page 9 of the statement of objections. My lord, this is a bylaw number 9E.
Page number?
Page number 9, my lord, in the objections filed to the main writ petition, my lord. I'm sorry, I make it clear. My lord, page 9, annexure R2B.
Yes.
Appointment of staff and disciplinary action against staff employees. The executive committee shall be supreme authority to regulate appointments except resignation, enforce discipline, dismiss any member of the staff or employee appointed by the institute for misconduct or misbehavior. But before the disciplinary action is taken, every opportunity shall be accorded to the person concerned to offer explanation and defense. The managing director, secretary, coordinator, correspondent shall have the power to take disciplinary action against the employees and make temporary appointment in the interest of the institute, and such action shall be ratified at the next meeting of the executive committee of the institute. Now, my lord, this is the bylaw which they are relying on. So after filing this objections, my lord, I took up a contention that, my lord, the very issuance of charge sheet is not legal, because, my lord, that issuance of charge sheet has not been ratified by the committee. So, my lord, the very root of the matter, my lord, now the very basis of the issuance of the charge sheet itself becomes illegal. So, with that, my lord,
what are the contentions you have urged here, buddy?
Yes, my lord.
Charge sheet not ratified.
Yes, my lord. Charge sheet was not ratified. So that was one of, by the executive committee. That was one of the requirements, even according to them and as per the bylaws. So therefore, bylaws ಅದೇ ನಾನು ಓದ್ದೆಲ್ಲ page 9.
Ratify ಮಾಡಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ?
ಅದೇ last 4 sentence, second paragraph ಅಲ್ಲಿ, the managing director, secretary, page 9. The managing director, secretary, coordinator, correspondent shall have the power to take disciplinary action against the employees and make temporary appointment in the interest of the institute, and such action shall be ratified at the next meeting of the executive committee of the
only
institute.
regarding temporary appointment.
No, my lord, this deals with this disciplinary action also.
No.
My lord, this deals with the disciplinary action also. So therefore, my lord, having regard to this mandate, my lord, they should have ratified the action of the third respondent even in relation to issuance of charge sheet. That they did not do it. So immediately after filing this objection, I, my lord, filed an application seeking amendment to the main writ petition, seeking quashing of the charge sheet itself. That amendment is allowed.
Then,
my lord, yes. Then, my lord, since this was not ratified, the action of issuance of charge sheet was not ratified by the committee, the whole initiation itself, my lord, is vitiated. And that apart, this Pradeep Kumar, that is, my lord, respondent number 3, he issues the charge sheet, the same having not been ratified, my lord, that has lost its sanctity. Then he becomes a witness. And, my lord, he also plays the role of a presenting officer. Then, my lord, ultimately, now he will decide my fate.
No, he will not decide. It is the committee.
My lord, let me, my lord, assuming for a moment that the committee could take action, then, my lord, he should not have participated in the proceedings. My lord, he is one of the members of the committee here.
No. He is not member of the committee.
No. Please see, my lord, please see the resolution which is produced along with the objections filed to the review petition, page 8. Last person, serial number 7, BM Pradeep Kumar, MD. ಹಾಜರಿದ್ದ ಸದಸ್ಯರು. That is what, my lord, this caption says.
Page 8 ಅಲ್ಲಿ?
Page 8 ಅಲ್ಲಿ ಹಾಜರಿದ್ದ ಸದಸ್ಯರು ಅಂತ ತಾವು ದಯವಿಟ್ಟು ನೋಡಿ, ಇದು ಹ್ಯಾಂಡ್ ರಿಟನ್ ಡಾಕ್ಯುಮೆಂಟ್.
ಪ್ರದೀಪ್ ಕುಮಾರ್.
ಹೌದು, serial number 7. It is not as if, my lord, there is no person left with the...
Sorry.
My lord, it is not the case that, my lord, there is none to take care of this. Admittedly, my lord, there are all these members are there. So, my lord, this seventh respondent, my lord, he should have refrained himself from participating in these proceedings, especially, my lord, when he becomes a witness.
Yes.
So therefore, my lord, all these questions, my lord, will have to be reconsidered. So therefore, my lord, I have filed this review petition and the
Yes,
order may be
yes,
reviewed.
Mr. Somsekhar, everybody last.
My lord, I only rely on the judgment of this honorable court, my lord, division bench judgment of this honorable court, which I have filed on 19/9/2024 in the writ petition, my lord. Nagaya versus Indian Aluminium.
Nagaya versus?
Indian Aluminium division bench judgment at page 6, my lord. It is filed on 19/9/2024, my lord.
ಇಲ್ಲಿ ಇದೆ ನೋಡ್ರಿ 19/9/24 ಅಂತ. The writ petition.
In the writ petition, yes, my lord. In the writ petition.
19/9/24 ಯಾವ್ದು
There are two judgments produced.
ಕಾಪಿ ಇದೆಯಾ? 19/9 ಇಂದ ಇಲ್ವಂತಲ್ಲ ಇಲ್ಲಿ. What does it
Hello.
say?
A list of authorities, my lord. I just read para 20 in the judgment, my lord. To our mind, it appears that the matter has to be looked into a proper perspective. Have the workman suffered any prejudice? Was he in a position to understand the nature and scope of the charges? Was he in a position to meet the charges and therefore was he in a position to furnish proper explanation? If these are answered in the affirmative, we do not know how it could be contended, as is urged by the learned counsel, Mr. Rao, for the workman that the initiation of the disciplinary proceedings is bad. We should also state at this juncture that the disciplinary inquiry is only for the purpose of establishing the guilt of the particular workman or the delinquent officer, as the case may be. Beyond that, there is no logic in stating that the charge memo must be issued by the competent officer. There is no question of any competent officer issuing a charge memo. In this case, even the certified standing order 33D merely talks of the ultimate order being passed by the general works manager. It cannot be contended that the initiation of the disciplinary inquiry leads on ultimately to the order of dismissal, and where therefore the foundation has not been properly laid, the edifice cannot be remained. This argument does not appeal to us for the simple reason that initiation is one thing and the ultimate dismissal is another. That is very important, my lord. Initiation is one thing and the ultimate dismissal is another, though they are part of the same proceedings.
But why are you participating in the meeting?
My lord, he is a MD. He has to be present in the board to record whatever the board decides, my lord.
But then
He is an MD. MD has to be present and proceedings have to be written by him. Committee will not be
why do you
writing.
participate in the proceedings of the meeting?
My lord, he has to write the proceedings, my lord. It will all be written
Why
by
should he
him.
write the proceedings? Where proceedings ಬೇರೆ ಇಲ್ವಾ? See how, I mean, it should at least seem to be not biased, that there's no prejudice. He cannot participate in the meeting of the executive committee. As a
He has to record all the things. Only for that purpose he will be
He
present.
is the disciplinary, assuming that he is the one who has conducted the inquiry.
He has
and
not
if
conducted inquiry. He participated in the inquiry.
He participated in the inquiry.
Yes.
He was a witness in the inquiry.
Correct, man. Correct.
Now
Man.
the executive committee has to take a decision on the inquiry
Yes.
report.
Yes, madam.
How can a witness participate in the proceedings of the committee? How can you participate?
As a MD, my lord, he has to record all the proceedings. It is
Let him be the MD, let him be the DM. It doesn't matter. If he is a witness to the proceedings, how can he participate in the proceedings to decide the fate of the petitioner? He might be the MD, doesn't mind. How can he participate? He should not participate. He cannot participate.
But initiation will not go, my lord. Only second show cause notice has to be written by the committee, my lord, in his absence.
Second
The
show
charge
cause
sheet cannot be set aside, my lord, at this stage. That's my humble submission. Because issuing charge sheet, that's what the division bench says. Issuing charge sheet initiation is one
look
thing.
into it. I'll pass appropriate orders.
Much obliged.
List on date.
But I have also cited one judgment, my lord, copy of which will be there in the file on the last occasion, my lord, I had.
Not which
That
is
is, my
your
lord,
judgment?
2010 10 SCC, page 539. 2010 10 SCC 539. My lord, paragraph 29, my lord, I will not trouble your lordship. Just one paragraph at page 550.
Yes.
Para 29. Thus, the legal position emerges that if a person appears as a witness in disciplinary proceedings, he cannot be an inquiry officer, nor can he pass any order, the order of punishment as a disciplinary authority. This rule has been held to be sacred. An apprehension of bias operates as a disqualification for a person to act as adjudicator. No person can be a judge in his own cause, and no witness can certify that his own testimony. So on and so forth.
Judgment ಏನಕ್ಕೆ ಬೇಕು ಸುಬ್ರಹ್ಮಣ್ಯ ಭಟ್?
ಇಲ್ಲ, ಅದೇ it is only to
Yes.
assist me. Grateful to you.
ಇದು ಸೋಮಶೇಖರ್ ಅವರೇ, ನಿಮ್ದು ಯಾವ್ದು ಜಜ್ಮೆಂಟ್ ಅದು? ನಾಗಯ್ಯ ವರ್ಸಸ್ ಇಂಡಿಯನ್
This is Indian Aluminium. I will give the
Indian?
citation. I will give this Indian Aluminium, my lord, division bench. The
Indian?
citation is ILR 1990, Karnataka 2744, para 20, my lord.
ಆಯ್ತು, ಐ ಲುಕ್ ಇನ್ ಟು ಇಟ್.
Please.
ಡೇಟ್ ಕೊಡಿ, ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್ ಡಿಕ್ಟೇಷನ್. ನೆಕ್ಸ್ಟ್ ಕರೀರಿ.
Grateful to you.
ಕರೀರಿ ಬೇರೆ. ಪಾಸ್ವರ್ಡ್ ಇದೆಯಾ? ಕರೀರಿ. ಮಾಡಿದಾರಾ? ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದಾರಾ? ಮಾಡಿಲ್ಲ. Loan counsel for the petitioner has amended the cost rate. Office director to check and verify.
Millards.
Who appears for the other side? Busare.
Sare appears for RGHS.
Ah.
And for CBSE, last occasion, Lordship has directed to Sudhir Singh Bijapur to implead CBSE and directed to take notice. I have served the copy also.
Where is Mr. Bijapur?
I have served copy.
There is no representation for the respondents.
Kindly a short date because students might have
Date
exams.
put. Execution, re-examination,
Exam.
education. 16th. Rathod Subhash Chandra.
Compliance was needful. Needful is done, my lord.
Learned counsel for the petitioner submits that he has complied the office objections. Office is direct to check and verify. List after service of notice to the respondent.
My lord, I'll argue on the merits, my lord, because in this case, my lord, tomorrow is a date fixed for trial, my lord, before trial, family court, wherein our application for recall also dismissed, rejected, my lord. So,
notice allow ಮಾಡಬೇಕು ಅಂದ್ರೆ ಅವ್ರು ಗೊತ್ತಿಲ್ಲದಾಗ
yes,
ಮಾಡಕ್ಕಾಗತ್ತಾ?
yes. Meanwhile, further proceedings will be stayed, my lord, because we have challenged the interim maintenance order, my lord. Our contention is that, my lord, the respondent before this formal court, he's got married with some Raymond Siddhappa Chauhan, but the marriage was not dissolved by the court of law, my lord. Only on the, I have produced the documents, my lord, that the very marriage was suppressed by the respondent herein, my lord, and got married with the present petitioner. We have filed the objection on the interim application, my lord, but same was not considered, and the Honorable Additional Family Court was passed the interim order, my lord, 8,000 per month from the date of petition till disposal of the main petition, my lord. So very same impugned order may be stayed, my lord.
ಏನ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? How much are you paying?
8,000 per month, my lord.
You're paying.
No, my lord, in last, on 30 only, the order was passed, my lord. We have challenged before this honorable court, and where, there, my lord, our chance ಕೊಟ್ಟಿಲ್ಲ, you have to pay the amount ಅಂತ ಹೇಳಿ ಅವರು the cross was taken as nil ಅಂತ ಮಾಡಿದ್ರು. Thereafter we filed the recall application, my lord.
You accepted her as your wife.
Yes, my lord, but later we came to know that the respondent has not taken the divorce from the earlier husband, my lord. I'm producing the documents, my lord.
ಇದೆಲ್ಲ ಇವಾಗ ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
Yes, we have produced at the time argument also, my lord. Our objection was filed. We have produced all the documents.
Have you raised any such contention in the objections to the IA?
Yes, we have filed the objection at page number 41, 47.
41.
Yes, my lord.
Hmm. ಎಲ್ಲಿ ಹೇಳಿದ್ರ?
At further clearly, my lord. Further para numbers 19 ಆದ್ಮೇಲೆ. The petition is not good that the earlier petitioner first marriage was performed with one Revan Babu.
Then why did you marry her?
My lord.
Why did you marry her?
Later we came to know that.
ಮದ್ವೆ ಆದ್ಮೇಲೆ ನಂಗೆ ಗೊತ್ತಾಯ್ತು ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದಿರ ಇಲ್ಲಿ? ಮದ್ವೆ ಆದ್ಮೇಲೆ ಗೊತ್ತಾಯ್ತು ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದಿರ?
ಇಲ್ಲಿ ಹೇಳಿ my lord.
ಎಲ್ಲಿ ಹೇಳಿದಿರ?
ಇಲ್ಲಿ further plea ಅಲ್ಲಿ ಹೇಳಿ my lord, objection ಅಲ್ಲಿ further pleas ಅಲ್ಲಿ. My lord, ಇಲ್ಲಿ. Without disclosing the first marriage, the petition married the respondent and played fraud with the respondent without disclosing the facts. ಇಲ್ಲಿ we ಹೇಳಿ my lord. In objection only we mentioned, also we filed the documents, my lord. Even in order also it was brought on record, my lord.
How many children do you have from this lady?
My lord?
ಎಷ್ಟು ಜನ ಮಕ್ಕಳು ಈ ಅಮ್ಮನಿಂದ?
ಇಲ್ಲ my lord, there are no
children from
no
this
children from this marriage.
So you also had an earlier marriage?
Earlier marriage, my lord, but she died.
You also were married earlier?
Earlier married, 3 children, my lord. They are under custody of petitioner only.
4
And
children.
after death of the wife, he got married with respondent, my lord.
Issue emergency notice. ಇದು ಆಗಿದೆಲ್ಲ. Since notice to the respondent is not yet served, and in the meanwhile proceedings are underway before the trial court, it is appropriate to stay the impugned order subject to the petitioner depositing, paying 4,000 rupees per month to the respondent.
And,
Yes, the arrears of maintenance at the rate of 4,000 rupees per month from the date of the petition till the date of the impugned order shall be deposited within 4 weeks. Deposited before the trial court within 4 weeks. Yes.
And meanwhile, he may be permitted to cross-examine the. Yes, I will find
ನೀವು
that.
ಐ ಹಾಕೊಂಡು ಕೇಳಿ.
Yes, my lord.
Next.
In this matter, petitioner engaged senior counsel, kindly have it on Tuesday, my lord.
Mister, you asked for a passover. I passed it over. ಹೇಳಿ ಏನು ಅಂತ ಹೇಳಿ.
Appointment ಸಿಗ್ಲಿಲ್ಲ senior counsel.
ಹೇಳ್ರಿ ಏನು ಅಂತ ಹೇಳಿ.
Notice issued by the Assistant Commissioner 15 days not completed, my lord.
ಅಷ್ಟಕ್ಕೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಏನಕ್ಕೆ ಬೇಕ್ರಿ? ನೀವೇ ಮಾಡ್ರಿ.
But as per petitioner wish.
ಯಾವತ್ತು ಹೇಳಿ? ಯಾವತ್ತು ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದ್ದು?
Notice issued on 17/12/2024, my lord.
17/12/24.
And petitioner has issued on 21. 21/12.
Received,
Yes. Received on 21/12. The meeting schedule date given on 3/1/2025.
3/1/2025.
25.
Yes, my lord, 25.
And there is violation of rule 3, 15 days not completed.
My lord.
ಯಾವತ್ತು ಸರ್ವ್ ಆಯ್ತು ನೋಟಿಸ್?
My lord, I have produced memo of production of document.
ಯಾವತ್ತು ಸರ್ವ್ ಆಯ್ತು ಹೇಳ್ರಿ.
I have to ascertain because 17/12 notice has been issued, my lord. 3/1 with.
3/1, but ಸರ್ವ್ ಆಗಿದ್ದು ಯಾವತ್ತು?
I will ascertain, because.
15 days clear notice under from the date of service only. Of course, what is the law? What is the law? 15 days clear notice ಅಂದ್ರೆ ಏನು? 15 days clear notice ಅಂದ್ರೆ ಏನು? Is it from the date of notice or from the date of service of notice?
My lord.
So it should be from the date of service of notice. ಅವ್ನು ಗೊತ್ತಾಗತ್ತೆ ಯಾವಾಗ? ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ 17ನೇ ತಾರೀಕು ಇಲ್ಲಿ ಕೇಳ್ರಿ ಮಿಸ್ಟರ್, 17ನೇ ತಾರೀಕು ನೋಟಿಸ್ ಇದೆ, ಕೇಳಿ 17ನೇ ತಾರೀಕು ನೋಟಿಸ್ ಇದೆ, 30ನೇ ತಾರೀಕು ತಗೊಂಡು ಕೊಡ್ತೀರಾ, 3ನೇ ತಾರೀಕು ಇದೆ, 17ನೇ ತಾರೀಕು ನೋಟಿಸು ತಗೊಂಡೋಗಿ ಕೊಡೋದು 30ನೇ ತಾರೀಕು, ಬಟ್ ಮೀಟಿಂಗ್ ಇರೋದು 3ನೇ ತಾರೀಕು, ಅವಾಗೇನಾಗುತ್ತೆ? ನೀವು ಹೇಳಿದ ಅರ್ಥ ಆಗ್ಲಿಲ್ವಾ? ಅವಾಗೇನು ಮಾಡೋದು? ರೂಲ್ 3(2) ಏನು ಹೇಳುತ್ತೆ ನೋಡಿ.
The Assistant Commissioner
Hmm.
thereafter convene a meeting for the consideration of the said motion at the office of the Gram Panchayat and the date appointed by him. It shall not be later than 30 days from the date on which the notice under subroute 1 was delivered to him. He shall give the members of a notice not less than 15 days of such meeting in form number 2.
ಏನು ಹಂಗಂದ್ರೆ ನಾಟ್ ಲೆಸ್ ದೆನ್ 15 ಡೇಸ್ ಅಂದ್ರೆ ಏನು?
Here notice. Notice.
ನಾಟ್ ಲೆಸ್ ದೆನ್ ನೋಟಿಸ್ ಆಫ್ ನಾಟ್ ಲೆಸ್ ದೆನ್ 15 ಡೇಸ್ ಅಂದ್ರೆ ಏನು?
From the date of the notice with Assistant Commissioner, not be within 15 days.
ನನಗೆ ಮೆಂಬರ್ ನನಗೆ ನೋಟಿಸ್ ಬರಬೇಕು, 15 ದಿನ ನೋಟಿಸ್ ಬರಬೇಕು ಅಂದ್ರೆ ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ಸರ್ವಿಸ್ ಆರ್ ನೋಟಿಸ್ ಆನ್ ಮೀ ಆರ್ ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ದ ನೋಟಿಸ್ ಮೆನ್ಷನ್ಡ್ ಇನ್ ದ ನೋಟಿಸ್. ಹೆಂಗೆ ಅದು? ಟೈಮ್ ಬೇಕಾ? Learned counsel for the respondent, proposed respondents, Learned counsel for the proposed respondent seeks time to research on the question whether the 15 days notice contemplated under Rule 3(2) of the Rules 1994 should be reckoned from the date of service of notice or from the date marked on the notice. This list on ಯಾವತ್ತು ಬೇಕು ನಿಮ್ಗೆ ಹೇಳ್ರಿ, ಕೊಡ್ರಿ ಡೇಟ್. 16th. ಇದಕ್ಕೆ ಯಾಕೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬೇಕು?
ಇಲ್ಲ
ಮಿಸ್ಟರ್ ಇನ್ನು ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಅದೇನಾ?
Same matter.
Connected matter.
Yes, next.
On each page of, on each page, my lord. This
Yes.
time I may be pardoned, my lord. I will not repeat it.
ಈಚ್ ಪೇಜ್ ಎಲ್ಲ ಹಾಕಿದ್ರಿ?
Each page ಹಾಕಿದೆ.
ಅದೊಂದೇನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್?
ಹೌದು.
ಬರ್ಕೊಳ್ಳಿ. ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್, ಸಾರಿ, AGS directed to accept notice for respondent number.
Respondent number 1,
1, 2, 3, 4. 4 ಇದ್ದೀರಾ?
4, my lord, Amresh Roja sir.
3, 5, 6, 7.
8 and 9 notice has to go.
7. Mr. Amresh Rosa for R4, issue emergent notice to respondent number 8 and 9. Next para. It is a case of the petitioners that the respondent number 8 and 9,
9, my lord.
respondent number 9 has declared them to be ineligible voters. Full stop. The petitioners contend that the respondent number 9 has not complied with Rule 13D of the Karnataka Cooperative Society Rules 1960 in declaring the petitioners to be ineligible voters list, ineligible voters. The petitioners contend that the respondents are now proposing to hold a meeting of the general body to elect the managing committee on 12/1/2025. In that view of the matter, without expressing any opinion on the merits of the case of the petitioner, interest of justice would be met by permitting the petitioners to cast their votes in the ensuing elections to the managing committee of the respondent number 9, scheduled to be held on 12/1/2025. Full stop. The votes cast by the petitioners shall be received and kept in a separate box and shall not be counted. The returning officer shall proceed to declare the results of the election, and the same shall be subject to the result of this writ petition. Full stop. The votes cast by the petitioner shall be counted only after obtaining orders of the court.
We are not standing counsel for
Election.
Huh?
We are not standing counsel.
यार response for यार इधर है
पूरे election authority नहीं
cooperative election authority
Not standing.
ಆಯ್ತು ನೋಟಿಸ್ ಅವ್ರಿಗೂ ಇಶ್ಯೂ ಮಾಡ್ಬಿಡಿ ಅಷ್ಟೇ.
Lord, hand delivery me.
Yes.
Hello. 38 will be taken tomorrow. I have
38.
received copies. I have to take print out and along with memo tomorrow.
This tomorrow, 38 tomorrow.
Obliged. And 82 as well.
80,
82 also
82 as well, Your Lordships.
38
Common
and
order.
82.
They may be connected, Your Lordships.
ಎರಡು connect ಮಾಡ್ಬಿಡಿ 38 and 82. Yes,
Obliged.
next. Ganesh Naik.
I have received, there is not yet in notice, my lord. In copy, my lord. He has received, he has not mentioned date. in
Police colleague. Yes, signed.
Sign.
Oh, my lord, is the 26 is the served the notice, my
You
lord. I ready
welcome
to
the
file
date.
the affidavit, my lord, along with the, my lord, the other 4 members, my lord. ನಮ್ಗೆ ಟೋಟಲ್ 6 ಜನಕ್ಕೆ my lord is the without any endorsement, my lord, ಅದ್ರಲ್ಲಿ ಏನು ಬರ್ದೇ ಇಲ್ಲ, ಸುಮ್ಮನೆ ಸಿಗ್ನೇಚರ್ ಇನಿಷಿಯಲ್ ಹಾಕಿದ್ದಾರೆ.
One more submission.
24th ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ ಈ ಬಸವರಾಜಿಗೆ ಸರ್ವ್ ಆಗಿದ್ ಯಾವಾಗ?
Sir, 26 ಗೆ my lord.
ಇದರಲ್ಲಿ ಬಸವರಾಜ್ ಸಿಗ್ನೇಚರ್ ಇಲ್ವಾ?
Is a my lord, it is.
Not the signature, not the, as per the annexure A, sir.
He has signed only, he has not mentioned date.
ಡೇಟ್ ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ನೀವು.
ನಾವು ಕೊಟ್ಟು 26 ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು.
ನೀವಿಲ್ಲಿ ಬರಿಬೇಕಿತ್ತಲ್ಲಪ್ಪ.
ಅಲ್ಲ ನಮ್ಗೆ ಬರ್ದಿದ್ದು ನಮಗೆ ಕೊಟ್ಟೋಗಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು ವಿಡಿಯೋ ಅವರು. ಜಸ್ಟ್ ಮೈ ಲಾರ್ಡ್ ಎಸ್ ದಿ ವೆರಿಫೈ ನಾವು ಮಾಡಿದ್ ಅವ್ರು ನಾವು ಇನಿಷಿಯಲ್ ಮಾಡಿ ನಮಗೆ ಕೊಟ್ಟೋಗಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಇದೆ ನೋಡಿ ನಿಮ್ ಸಿಗ್ನೇಚರ್ ಇದೆ.
ಹೌದು ನಮ್ಮ ಸಿಗ್ನೇಚರ್. ನನ್ನ ಸಿಗ್ನೇಚರ್ ಹಾಕೊಂಡು ಇದ್ದೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು.
ಸರಿ, ಬಟ್ ವೈ ಡಿಡ್ ಯು ನಾಟ್ ಮೆನ್ಷನ್ ಇರ್ಲಿ ತಕ್ಕೋವಾಗ?
ಅಲ್ಲ ಅವ್ರು ಕೊಟ್ಟಿರೋದು ನಮ್ಗೆ ನೀವೇ ತಗೊಂಡ್ಬಿಡಿ, ರಿಶ್ಯೂರ್ ಮಾಡ್ಕೊಂಡದ್ದು ಯಾವ ಡೇಟ್ ಮಾಡ್ಕೊತೀರಿ ನೀವು 26 ಕೊಟ್ಟಿದ್ದೀನಿ 26 ತಗೊಂಡ್ಬಿಡಿ ಅಂತ ಹೇಳಿ. ಬೇಕಿದ್ರೆ ವಿ ಆರ್ ದಿ ರೆಡಿ ಟು ಮೈ ಲಾರ್ಡ್ ಹ್ಯಾವ್ ಫೈಲ್ ದಿ ಅಫಿಡವಿಟ್ ಮೈ ಲಾರ್ಡ್ ಅಲಾಂಗ್ ವಿತ್ ಅದರ್ 4 members ಮೈ ಲಾರ್ಡ್. ಸೇಮ್ ಡೇಟ್ 26 ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವತ್ತು. ಬಿಕಾಸ್ ಅವರು ಇವ್ರು 2 petitioners along with the 4 members were they ready to file the affidavit my lord on date.
ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಯಾವಾಗ ಶುರು ಮಾಡಿದೀರಾ ಬೇರೆ ಮೆಂಬರ್ಸ್ಗೆ?
Then because it is specific.
Let's one more submission. Totally 9 persons have given a representation, but they have added only 7 persons as the respondents. 2 have been left out. The writ petition itself not maintainable. In view of the, they have mentioned only 7 persons have given representation before the assistant commissioner. That is not correct, my lords. I have producing the copy of the same. Totally 9 persons have given.
ಇಲ್ಲ ಅವರು ಇಶ್ಯೂ ಮಾಡಿ ಕೊಟ್ಟದ್ದೇ ಹಾಕಿದ್ವಿ ಸರ್.
Yes,
ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಇಶ್ಯೂ ಮಾಡಿದಾರ ಆ ತರ?
ನಾನು ಅದೇ ಹಾಕಿರೋದು, ನಾನು ಬೇರೆದ ತಂದು ಹಾಕಿಲ್ಲ ಸರ್.
9 persons, 2 ಹೆಸರು ಕಟ್ ಆಗಿದ್ದೇವೆ ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದ್ರಲ್ಲಿ.
ಕಟ್ ಆಗ್ಬಿಟ್ಟಿದ್ಯಾ?
ಕಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅವ್ರ ಹೆಸರಲ್ಲಿ.
ಆಮೇಲೆ ಆಯ್ತು, ಇವ್ರಿಗೆ ಯಾವತ್ತು ಸರ್ವ್ ಮಾಡೋದು ಬೇಕಲ್ಲ.
20 in between 24th and so more than 15 days cleared notices and 24th
is served on him.
24th itself.
ಅದಕ್ಕೆ ಏನಾದ್ರು ತೋರಿಸ್ಬೇಕಲ್ಲ. ಏನೋ ನೋಟ್ ಶೀಟ್ ಮಾಡಿರಲ್ವಾ?
ಇಲ್ಲ
26th ಗೆ ಅವ್ರು ಸಬ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆಫೀಸ್
ಅಲ್ವಾ?
my lord, those who have.
ತರ್ಸಿ ಅದನ್ನು ನೋಟ್ ಶೀಟ್ ತರ್ಸಿ ಬರ್ಕೊಳ್ಳಿ. The Lord AG is directed to secure the the file relating to the no confidence motion initiated against the petitioners.
So
This
that
one,
tomorrow,
yavat-
tomorrow is the no confidence.
My lord, sir.
Tomorrow is the no confidence.
Tomorrow is a no confidence, then I can't.
11 o'clock, my lord.
Since the PDO is endorsed on it, the proceedings were quashed and again the.
ಹಂಗಿದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Majority has lost.
My lord, there is
Out of
the
39
tomorrow, at
members
least, my
have
lord, is
against
the
him.
key.
ನೋಡ್ರಿ ನೀವು ಸೈನ್ ಮಾಡುವಾಗ ಡೇಟ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು.
But we are the key ready to fight, my lord, affidavit along with other four members, my lord. There is the key.
Affidavit for what?
My lord, the 26th, he has served the notice to the key PDO, my lord.
Affidavit ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ಬೇಕು?
But he has the, even though he is the key producing the same documents, neither do he has the mentioning and the
What
date, my
prevented
lord,
you,
there is the key.
what prevented you from marking the date when you received the notice?
But ಅದರಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಯಾವ ಡೇಟಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ರು ಅಂತ ಅಟ್ಲೀಸ್ಟ್ ಹಿ ಹ್ಯಾಸ್ ದಿ ಮೆನ್ಷನ್
ನೀವು ತಗೊಂಡಿದ್ ನೀವಲ್ವೇನ್ರಿ?
ನಮಗೆ ತಗೊಂಡದ್ ನಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು ನೋಟಿಸ್.
ಅದ್ ಕೊಡ್ರಿ ಇದು. ಇದೊಂದ್ಸತಿ ನೋಡ್ರಿ ಅದು. ಇದು ನೋಡ್ರಿ.
ನಮ್ ನೋಟಿಸ್ ಅಲ್ಲಿ ನಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅದೇ ಡೇಟ್.
ನೀವು ಕೊಟ್ಟು ನೀವು ಡೇಟ್ ಬರ್ಕೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ ನಾವ್ ಬರ್ಕೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ ಅವರೇ ನಾವ್ ಬರ್ಕೊಂಡು ನಮ್ಗೆ ಇನಿಷಿಯಲ್ ಮಾಡಿ ನಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಅವರು.
ಕೊಡಿ ಫೈಲ್ ಕೊಡ್ರಿ ಇಲ್ಲಿ. ಇದು ಕೊಡಿ ಇದು.
ಬಟ್ ಅಲ್ಲಿ ಯಾವಾಗ ಸರ್ವ್ ಮಾಡಿದ್ವಿ ಅಂತಾನು ಬರ್ದಿಲ್ಲ ಸ್ವಾಮಿ.
ಇದು ನೋಡಿ.
ಹೌದು ಸರ್.
ನೀವು ಡೇಟ್ ಏನಂತ ಬರ್ದಿದೆ? ದಿನಾಂಕ 26/12/2024 ತೆಗೆದುಕೊಂಡಿರುತ್ತೇವೆ.
ತೆಗೆದುಕೊಂಡಿರುತ್ತೇವೆ.
ಹಾ, ನೀವು ಬರ್ದಿದ್ದೀರಿ.
ಇಲ್ಲ ಅವ್ರು ಬರ್ಕೊಂಡ್ ನಮ್ಗೆ ಇನಿಷಿಯಲ್ ತಗೊಂಡಿದ್ರಿ ಸ್ವಾಮಿ ನಮ್ಗೆ.
ನೋಡಿಪ್ಪ ಇದು.
ಹೌದು ಇದು ನಾವು ತಗೊಂಡಿದ್ದು ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಅದ್ ನೀವು ಬರ್ಕೊಂಡಿದ್ದೀರಾ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿರೋದು.
ಇದೆ ಸ್ವಾಮಿ ನಾನೇ ಬರ್ಕೊಂಡಿರೋದು. ಬಟ್ ನಾನು ಕೊಟ್ಟಿರೋ ಡೇಟ್ 26 ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಬರ್ತಾರೆ.
ಅದು ನೀವು 26, 27, 28, 29 ಬರ್ಕೋಬಹುದು.
ನಾನು ಬೇಕಾದ್ರೆ 27, 28 ಬರೀತಿದ್ದೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ.
15 ದಿನ ನೀವು
24th ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿ 25 ಗೆ ಮಾಡೋದು ಕ್ರಿಸ್ಮಸ್ ಹಾಲಿಡೇ ಮಾಡೋದು.
ಮಿಸ್ಟರ್, this is an afterthought.
No, my lord, there is the
This is an afterthought.
genuine reason, my lord. There is the key. Without genuine reason, we are the key not filed to the petition, my lord. There is.
But the petitioners have challenged a no confidence motion. Have challenged the notice of no confidence motion.
At least, my lord, the called documents along with my lord, the subject to result of writ petition to ಮತ್ತೆ in mail, my lord, he has the served the notice.
ಆಯ್ತು, ನಾಳೆ ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಅಂತೂ ಆಗುತ್ತೆ. ಆಯ್ತು.
Subject to result.
ಫೀಸ್ ಬಂದಿಲ್ವಾ?
Fees in the last, if there is the genuine reason, my lord, there is not.
Fees ಬಂದಿದ್ರೆ we can give you some order. The no confidence motion scheduled to be held tomorrow,
please,
shall be subject to the result of this writ petition.
Please. But meanwhile, my lord, has the produced the documents. When was the served the petitioner to the notice, my lord?
ಆಯ್ತು, ನಿಧಾನಕ್ಕೆ ನೋಡೋಣ ಬಿಡಿ ಏನಂತ. ಆಯ್ತು, ಕರೀರಿ.
Please.
My lord, so one submission in the morning hours I have made, serial number 11.
ಯಾರಿದ್ದಾರೆ ಅದ್ರಲ್ಲಿ? ಅದರ್ ಸೈಡ್ ಯಾರು? serial number
11, my lords.
ಏನದು?
My lords, as per on the basis of submission made by them, it becomes infructuous and that is not becomes infructuous. No meeting was held. There was a stay by this honorable court.
No meeting was held under infructuous ಆಯ್ತಲ್ಲ.
No, I have challenged the representation as well as the notice of the meeting.
ಆಯ್ತು, ಅದು ಮುಗಿದೋಯ್ತಲ್ವಾ?
17/12/2024.
ಈಗ 17/12/24 was the meeting.
Yes, my lords.
ಮುಗಿದೋಯ್ತು.
I have challenged the representation made by them before the assistant commander. That is a defective one ground. There is no clear 15 days notice. That was also.
ಅದು ಸತ್ತೋಯ್ತದು. ಅದು ಸತ್ತೋಯ್ತು. ಅವ್ರು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದು, ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದು, ಅದೆಲ್ಲ ಸತ್ತೋಯ್ತು. ಬಿಕಾಸ್ ಮೀಟಿಂಗ್ ಡಿಡ್ ನಾಟ್ ಹ್ಯಾಪನ್.
Yes, boss.
ಇವಾಗ ಫ್ರೆಶ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ತಿರ್ಗಾ ಏನೋ ಸತಿ ಮಾಡಿ. All contentions raised in this writ petition are kept open to be considered in an appropriate proceedings. ಇವಾಗ 17/12 ನೋಟಿಸ್ ಇತ್ತಲ್ಲಪ್ಪ.
Yes, please.
No
There is
confidence.
also a representation made by them before the assistant commissioner.
Correct.
That remains, my lords.
Where does it remain? ಮೀಟಿಂಗ್ ಆಗದಿದ್ರೆ ಹೋಯ್ತಲ್ಲ ಅದನ್ನು.
ಅಲೌ ಆದಾಗ ಹೋಗುತ್ತೆ. ಅಲೌ ಇನ್ಫ್ರಕ್ಚುಸ್ ಆದಾಗ ಹೋಗುತ್ತಿಲ್ಲ. What my understanding.
Our representation ಸತ್ತೋಯ್ತು. It died a natural death because the meeting did not happen. So ಆ ನೋಟಿಸ್ ಇನ್ನೊಂದು ಮೀಟಿಂಗ್ ಮಾಡ್ಬೋದು ಅಂತ ನೀವು ಅನ್ಕೊಂತೀರಾ?
Yes,
ಅದೇಂಗಾಗುತ್ತೆ?
That allowed both set aside ಆದ್ರೆ I will.
ಏನ್ ಮೇಡಮ್ ಆಯ್ತು? ಅದೇನಾಗುತ್ತೆ?
ಅಲ್ಲಲ್ಲ ಅದೇನು ಬೆಳಿಗ್ಗೆ ಯಾರು ನೀವು
With that observation,
Infractions ಅಂತ ಹೇಳಿ.
ಬರ್ಕೊಳ್ಳಿ. The petitioner has challenged a meeting notice, challenged a notice proposing to hold a no confidence motion against him or her, against her on 17/12/2024. Next para. It is a case of the petitioner that the meeting was not held on 17/12/2024, and therefore the notice of the meeting as well as the representation filed by the members of the panchayat expressing no confidence is unenforceable, full stop. He submits that this writ petition may be disposed of as having become infructuous, and at the same time holding that the assistant commissioner, bracket respondent number 3, shall not act upon the representation submitted by the members, full stop. Next para. The learned counsel for the private respondent submitted that since the meeting did not happen on 17/12/2024, the entire process has become infructuous. Next part. In view of the aforesaid submission, this writ petition is disposed of as having become infructuous. It is needless to mention that the representation submitted by the private respondents to the respondent number 3 shall not be given effect to, full stop. It is, however, open for the private respondents to take fresh proceedings if they are so interested.
please,
If they are so interested or advised. Yes.
please.
ಮುರಳಿಗೆ ಅವರೇ, ಬುದ್ಧಿವಂತಿಕೆ ಉಪಯೋಗಿಸಿದ್ರೆ ಅಕಸ್ಮಾತ್ ಇದೇ ನೋಟಿಸ್ ಮೇಲೆ ಇನ್ನೊಂದು ಹಾಕಿದ್ರೆ ಇನ್ನೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿ ಸ್ಟೇ ತಕೊಂಡು ಇನ್ನೊಂದು 2 ವರ್ಷ 1 ವರ್ಷ ತಳ್ಬೋದಾಗಿತ್ತು. ಯು ಮಿಸ್ ದಟ್ ಆಪರ್ಚುನಿಟಿ. ವಿ ಶ್ರೀನಿವಾಸ್.
My lord, I appear for petitioner in this case. My lord, the petitioner in the instant case have participated in a writ called by, in a tender proceedings called by the third respondent, my lord. My lord, a tender booklet is at annexure B. My lord, page number 11, my lord. Now, my lord, may I take your lordships to the one condition which says, page number 16, my lord. Page number 16, my lord. I will just read that condition and then I will take your lordships to the other annexures, my lord. ಉತ್ತಮ ಆರ್ಥಿಕ ಸ್ಥಿತಿ ಹೊಂದಿರಬೇಕು, ಉಳಿತಾಯ ಮಾಡಲಾದ ಅನುದಾನ, ಬ್ಯಾಂಕಿನೊಂದಿಗೆ ಹಣ ವ್ಯವಹಾರ ಹಾಗೂ ಅಧಿಕೃತ ನೋಂದಣಿ ಹೊಂದಿರುವ ಚಾರ್ಟೆಡ್ ಅಕೌಂಟೆಂಟ್ ರವರಿಂದ.
ಪೇಜ್ ನಂಬರ್ 16 ಅಂತ ಅಂದ್ರೆ where are reading?
My lord, annexure B, page number 16, my lord, it is a condition, tender conditions to
page number 16 ಅಲ್ಲಿ ಏನಂತಿದೆ?
My lord,
ಪೇಜ್ ನಂಬರ್ 16 EMD ಮೊತ್ತವನ್ನು ಈ ಕೆಳಗಿನ ಪ್ರಕರಣಗಳಲ್ಲಿ ಮುಟ್ಟುಗೋಲು ಹಾಕಿಕೊಳ್ಳಲಾಗುವುದು ಅಂತ ಪೇಜ್ 16 ಅಲ್ಲಿ ಇದೆ.
I'm sorry, my lord, if there is any pagination, ಅಲ್ಲ ನಂಬರ್ ಏನಾದ್ರು ನಂಬರ್ ರಿಟ್ ಪಿಟಿಷನ್ ಏನಾದ್ರು ನಂಬರ್ ವೇರಿಯೇಷನ್ ಆಗಿರ್ಬೋದು, ನಂಗೆ ರಿಪ್ ನಂಬರ್ ಸಿಕ್ಕಿಲ್ಲದೆ ಇರ್ಬೋದು. ಸೊ
ಏನಂತ ಹೆಡ್ಡಿಂಗ್ ಇದೆ ಅದನ್ನಾದ್ರೂ ಹೇಳಪ್ಪ.
My lord, this is my lord EMD ಅದು ಮುಟ್ಟುಗೋಲು ಹಾಕಿರೋಲ್ಲ ಆದ್ಮೇಲಿಂದ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ 1, 2, 3ನೇ ಪೇಜ್ ಅದಾದ್ಮೇಲೆ 3rd ಪೇಜ್ my lord.
ಅದಾದ್ಮೇಲೆ 3rd ಪೇಜ್.
Yes, my lord. ಉತ್ತಮ ಆರ್ಥಿಕ ಸ್ಥಿತಿ my lord, second condition my lord, from the front the up, your lordship, this is regarding financial condition my lord.
Page 20. ಎಲ್ಲಿದೆ? ಉತ್ತಮ ಆರ್ಥಿಕ ಸ್ಥಿತಿ.
ಉತ್ತಮ ಆರ್ಥಿಕ ಸ್ಥಿತಿ ಹೊಂದಿರಬೇಕು, ಉಳಿತಾಯ ಮಾಡಲಾದ ಅನುದಾನ, ಬ್ಯಾಂಕಿನೊಂದಿಗೆ ಹಣ ವ್ಯವಹಾರ ಹಾಗೂ ಅಧಿಕೃತ ನೋಂದಣಿ ಹೊಂದಿರುವ ಚಾರ್ಟೆಡ್ ಅಕೌಂಟ್ ಅವರಿಂದ ಹಿಂದಿನ 3 ಆರ್ಥಿಕ ವರ್ಷಗಳ ವಾರ್ಷಿಕ ವಹಿವಾಟಿನ ದೃಢೀಕರಣ ಪತ್ರ ಲಗತ್ತಿಸಿರಬೇಕು. ಟೆಂಡರ್ದಾರರ ವಾರ್ಷಿಕ ವಹಿವಾಟು ಹಿಂದಿನ 3 ವರ್ಷಗಳಲ್ಲಿ ಸರಾಸರಿ 50 ಲಕ್ಷ ಇರಬೇಕು. This is the technical specification mentioned in the tender, my lord. Now, my lord, if I may take your lordships to my this thing, my lord, which is at annexure D. Pagination, my lord, maybe little variation, my lord, but my pagination is 41, my lord. 3 pages down, my lord, 44, my lord, it may be. Annexure D. My lord, my financial conditions is, my lord, 13 crores, 16 crores, 11 crores, 6 crores is my turnover per annum. Now, my lord, they reject in the technical bid with the reason, if annexure F is the reasons assigned by them, my lord.
Annexure?
F, my lord. My lord, last condition, last one, my lord. Taloku Mahila Vividodosha, your lordship got it, my lord.
Annexure F ಅಲ್ಲಿ pay last.
Yes, my lord, last paragraph. ತಾಲೂಕು ಮಹಿಳಾ ವಿವಿಧೋದ್ದೇಶ ಸಹಕಾರ ಸಂಘ ನಿಯಮಿತ ಯಾದಗಿರಿರವರು ಎಲ್ಲಾ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಆದರೆ ವಸತಿ ಶಾಲೆಗೆ ಸಿದ್ಧಪಡಿಸಿದ ಆಹಾರ
ಗೊತ್ತಾಗ್ತಿಲ್ಲ ಶ್ರೀನಿವಾಸ್.
Milord, annexure F, page number 43, Milord. It is page number, it may be for page number 46, Milord. There. Dated 14/11/2014, Milord. 24, I'm sorry, 2014/11 to 2024.
ಎಲ್ಲಿದೆ ಟೆಂಡರ್ನ ತಾಂತ್ರಿಕ ಬಿಡ್ನಲ್ಲಿ ಅರ್ಹತೆ ಹೊಂದಿದೆ ಬಿಡ್ಡುದಾರರು. ಈ ಮೇಲಿನಂತೆ ಟೆಂಡರ್ನಲ್ಲಿ ಭಾಗವಹಿಸಿರುವ ಎಲ್ಲಾ 7 ಜನ ಬಿಡ್ಡುದಾರರಲ್ಲಿ 4 ಜನ ಟೆಂಡರ್ ತಾಂತ್ರಿಕ ಬಿಡ್ನಲ್ಲಿ ಅರ್ಹತೆ ಹೊಂದಿರುತ್ತಾರೆ. 1, 2, 3, 4.
ಬ್ಲಡ್ ಅಲ್ಲಿ ನಾನು ಬೇರೆ ರಿಟ್ ಅಲ್ಲಿ ಎಲ್ಲ ಒಂದೇ ಇರೋದ್ರಿಂದ ನಾನು ಬೇರೆ ರಿಟ್ ತಗೊಂಡಿದ್ದೀನಿ. ಅಲ್ಲಿ ಇನ್ನೊಂದು ರಿಟ್ ಇದು ಬಂದಿದೆ ಸರ್. ಐ ಆಮ್ ಸಾರಿ, I'll go to that writ petition, my lord. ಅದರಲ್ಲೇನೆ your lordship may kindly come, my lord. Your lordship, which one holding page number 47, my lord. Page number 47 ಅಲ್ಲಿ ಈ ಮೇಲಿನಂತೆ ಟೆಂಡರ್ ಭಾಗವಹಿಸಿರೋ ಎಲ್ಲಾ
ರಿಟ್ ಪಿಟಿಷನ್ ಇದೆ. ಅದ್ಯಾರು 2000051 ಅಂತ ಅದಾ?
ಅಲ್ಲ, ಇಲ್ಲಿ ನನಗೆ FR ನಂಬರ್ ಮೇಲೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನನಗೆ ಅದೇ ಕನ್ಫ್ಯೂಷನ್.
ನಿಧಾನಕ್ಕೆ ನೋಡ್ಕೊಳ್ಳಿ. ಡೋಂಟ್ ವೇಸ್ಟ್ ಟೈಮ್.
ಮಿಲಡ್, ಐ ಆಮ್ ಸಾರಿ ಮಿಲಡ್, ಇದು ನಾಳೆ ಫೈನಾನ್ಷಿಯಲ್ ಬಿಡ್ ಓಪನ್ ಆಗೋಗುತ್ತೆ, ಅದಕ್ಕೋಸ್ಕರ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ದು ಅಷ್ಟೇ ಸ್ವಾಮಿ.
ಫಸ್ಟ್ ನಿಮ್ ಫೈಲ್ ಅರೇಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಆಮೇಲೆ ಟೆಕ್ನಿಕಲ್ ಬಿಡ್ಗೆ ಹೋಗೋರಂತೆ. ಫೈಲ್.
Yes, my lord. My lord, I will take your lordship, my lord. I got the file, my lord, which your lordship was holding.
ಪಾಸ್ವರ್ಡ್ ನಿಧಾನಕ್ಕೆ ನೋಡಿ ಹೇಳಿ.
ಅಲ್ಲ, ಅಲ್ಲಿ ನೋಡಕ್ಕೆ ನನ್ ಕೊಲಿಗ್ ಇಲ್ಲ ನನ್ಗೆ, ಅದಕ್ಕೋಸ್ಕರ ಐ ಆಮ್ ರಿಕ್ವೆಸ್ಟಿಂಗ್, my lord. I am my humble request, my lord.
Please ask the assistance of some lawyer here. Yes. Next career, Gauri Shesh Kashampur.
The only issue is that, my lord, 12th cooperative primary agriculture cooperative society election was scheduled on 12th, my lord. On 5th, nominations were scrutinized, my lord.
ಇದು ಪ್ರೈಮರಿ ಯಾವತ್ತು? 12th.
Election ಇರೋದು 12th ಗೆ ಸ್ವಾಮಿ. 4th is nomination filing of last date, my lord. 5th is scrutiny date. 6th is withdrawal date, my lord. My lord, kindly see the page number 10, my lord. One Shri Vijay Kumar, son of Subhash Rao, who is in defaulter in the
ಎಲ್ಲಿದೆಯಪ್ಪ ವಿಜಯ್ ಕುಮಾರ್ ಹೆಸರು?
serial number 11, my lord. ಇಲ್ಲಿ ಮೇಲ್ಗಡೆ ಇದರ ಆಡಳಿತ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘ ನಿಯಮಿತ ಗಾದಗಿ ತಾಲೂಕು ಜಿಲ್ಲಾ ಬೀದರ್ ಇದರ ಆಡಳಿತ ಮಂಡಳಿಯ ಚುನಾವಣೆಯ ನಾಮಪತ್ರ ಪರಿಶೀಲನೆ ನಂತರ ಕಣದಲ್ಲಿರುವ ಅಭ್ಯರ್ಥಿಗಳ ಪಟ್ಟಿ shows as ವಿಜಯ್ ಕುಮಾರ್ ತಂದೆ Subhash Rao is nomination is accepted, my lord. Even I have filed an objection to that extent, my lord. Iವರು ಡಿಫಾಲ್ಟರ್ ಇದಾರೆ ಅಂತ ಹೇಳಿ along with the document I have filed an objection, my lord. Kindly see the page annexure C, my lord. Page number 12. Defaulters list was published by the DCC Bank on 1/1/2025. Vijay Kumar name is shown as serial number 2, last name, my lord. It is a defaulter list, my lord. I have filed a detailed objection, my lord. To this extent, even though, my lord, they are accepted the nomination and given a reasoning, my lord. Kindly see the annexure D. ಇದು ಒಂದೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ, ಟೈಪ್ಡ್ ಕಾಪಿ ಅಂತ ಸ್ವಾಮಿ. ಮೇ ರೀಡ್, ಮೈ ಲಾರ್ಡ್. ಈ ಮೂಲಕ ತಿಳಿಸುವುದೇನೆಂದರೆ, ಶ್ರೀ ವಿಜಯ್ ಕುಮಾರ್ ತಂದೆ ಸುಭಾಷ್ ರಾವ್ ಇವರು ಸುಸ್ತಿ ಸಾಲಗಾರರಾಗಿದ್ದು ನಾಮಪತ್ರವನ್ನು ಮಾನ್ಯ ಮಾಡಬಾರದೆಂದು ಶ್ರೀ ನಾಗಶೆಟ್ಟಿ ತಂದೆ ವಿರಸಂಗಪ್ಪ ಪಾಟೀಲ್ ಸಾಕಿನ್ ಗಾದ್ಗಿ ಇವರು ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ ಹಾಗೂ ಅದಕ್ಕೆ ಪ್ರತಿಯಾಗಿ ಶ್ರೀ ವಿಜಯ್ ಕುಮಾರ್ ಅವರು ಹಣ ಪಾವತಿಸಿರುವ ರಸೀದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಆದಾಗ್ಯೂ ಸಹಕಾರ ಸಂಘದ ಅಧಿನಿಯಮ 1959 ಕಲಂ 13(2)(a), 13(d), 2(a) ಪ್ರಕಾರ ಪರಿಶೀಲಿಸಲಾಗಿ ಮತದಾರರ ಪಟ್ಟಿಯು ಉಪನಿಬಂಧಕರ ಕಚೇರಿ ಬೀದರ್ನಿಂದ ಅಧಿಕೃತ ಪಟ್ಟಿಯ ಪ್ರಕಾರ ಹಣ ಹಾಗೂ ತರಬೇತಿ ದಿನಾಂಕ 21/11/2024 ತರಬೇತಿಯಲ್ಲಿಯೂ ಸಹ ಮತದಾರರ ಪಟ್ಟಿಯ ಪ್ರಕಾರ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುವಂತೆ ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಇದರಲ್ಲಿ ಆರೋ ಆದ ನನ್ನ ಕರ್ತವ್ಯ ಇರುವುದಿಲ್ಲ ತಿಳಿಸಲಾಗಿದೆ. ಮತದಾರರ ಪಟ್ಟಿಯಲ್ಲಿ ಇರುವ ಹೆಸರು ಇರುವುದರಿಂದ ಮಾನ್ಯ ಮಾಡಲಾಗಿದೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. As per the provisions of law, my lord, kindly see my objection, my lord. Section 22, subclass A1, my lord. Any defaulter, my lord, he can't participated in the election proceedings, my lord.
But he says that he has paid the money.
ಅಲ್ಲಲ್ಲ ಅದ್ರಲ್ಲಿ ಪೇಡ್ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ ಪ್ರೇಯರ್ ಟು ದಟ್, ಮೈ ಲಾರ್ಡ್, ಸಾರಿ, ಆಫ್ಟರ್ ದಟ್, ಮೈ ಲಾರ್ಡ್, ಆನ್ 1/1/2025, institution itself is published the defaulter list, my lord.
There is a mistake in the institution.
ಅಲ್ಲಲ್ಲ, they are not.
If they are not brought it to the, ಇದು ಏನ್ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲಲ್ಲ, ಈಗ ನನ್ಗೆ based on the vote defaulter list, my lord, I am filed an objection, my lord.
If he has paid the money.
ಅಲ್ಲಲ್ಲ, it is the version of the respondent, my lord.
But who has to confirm that?
Authority has to confirm, my lord.
Yaru?
Government.
For the pivot respond number 6. First of all, Lord, election was declared. I have been declared as elected. And more so, Lord.
Election ಯಾವತ್ತಿದೆ election?
12th ಗಿದೆ, unanimous ಆಗಿ ಡಿಕ್ಲೇರ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. Calendar of events will conclude on 12th, my lord. ಅದು ನಮಗೆ ಅದು ಕೊಟ್ಟೇ ಇಲ್ಲ. Calendar of, as per calendar of events, 12th is the election date, my lord. ಯುನಾನಿಮಸ್ ಆಗಿ ಎಲೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. ಬಟ್ ಮೈ ಇಶ್ಯೂ ಇಸ್ ದಟ್, ಮೈ ಲಾರ್ಡ್, he is in defaulter, my lord. How can he is elected as a?
You have to challenge it in the manner known to law. You have to challenge it.
My lord, I have filed as per the provisions of law. If
But election is already declared. Wrong. It might be a wrong declaration.
ಅಲ್ಲಲ್ಲ, ಈ that result has to declare after 12th only, my lord. ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ಯಾಕೆಂದ್ರೆ after completion of calendar of events only the election officer has to declare the result, my lord.
On the date of the last day of withdrawal of nomination.
Please.
If there's nobody else.
Even though, my lord, he has to declare the result on the 12th only, my lord. After completion of election process only, he has to declare the
and uncontested election. 14G of Lord Karnataka Cooperative.
14?
G. Only one. If the number of contesting candidates in any area or constituency is more than number of seats to be filled from that area or constituency, the poll shall be taken. Number 2, if the number of such candidates in any constituency is equal to the number of seats to be filled from that area or constituency, the returning officer shall forthwith declare all such candidates to be duly elected to fill these seats in form 19 as may be proper. For this, my lord, on 5th only, my lord.
Even will accept, my lord. Prior to scrutiny, my lord, I have filed an objection. Without considering my objection, my lord, nomination is accepted.
Objection is considered. Objection is
ಅಲ್ಲಲ್ಲ, they are not considered my objection as per the provisions of law. ನಾನು law ನ kindly see the my objection, my lord. ನಾನು ಯಾವ ಸೆಕ್ಷನ್ ಹೇಳುತ್ತೆ ಅನ್ನೋದನ್ನ ಕೂಡ ಕೋಟ್ ಮಾಡಿದ್ದೀನಿ. ಆ ಸೆಕ್ಷನ್ ಬಗ್ಗೆ ಅವ್ರು ಹೇಳೋದಿಲ್ಲ ಕನ್ಸಿಡರೇಷನ್ ಅಲ್ಲಿ. ಅಲ್ಲ, kindly see the page number 11, my lord. Page number 11 of my petition, my lord. I'll take only 1 minute of my lord, sir. Page number 11. ಅದು ಹೈಲೈಟ್ ಮಾತ್ರ ಓದ್ತೀನಿ ಸ್ವಾಮಿ. ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ 1959 ಕಲಂ 22A1 A2 ಪ್ರಕಾರ ಸುಸ್ತಿ ಸಾಲಗಾರರನ್ನು ಸದಸ್ಯರನ್ನಾಗಿರುವ ಸಹಕಾರ ಸಂಘಗಳಲ್ಲಿ ಬಾಕಿದಾರನಾದ ಒಬ್ಬ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಅಥವಾ ಮಂಡಳಿಯ ಸದಸ್ಯರ ಚುನಾವಣೆಯಲ್ಲಿ ಮತ ಚಲಾಯಿಸಲು ಸ್ಪರ್ಧಿಸಲು ಹಕ್ಕನ್ನು ಹೊಂದಿರತಕ್ಕದ್ದಲ್ಲ. I have filed specific objection that was not answered by the returning officer.
Please read the objection that is considered.
Please.
ನಾ ಪಾವತಿಸಿರುವ ರಸೀದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
Yes.
ಆದಾಗ್ಯೂ ಪರಿಶೀಲಿಸಲಾಗಿ ಮತದಾರ ಪಟ್ಟಿಯು ಉಪನಿಬಂಧಕರ ಕಚೇರಿ ಬೀದರ್ನಿಂದ ಅಧಿಕೃತ ಪಟ್ಟಿಯ ಪ್ರಕಾರ ಹಾಗೂ ತರಬೇತಿ ದಿನಾಂಕ 21/11/24ರಂದು ತರಬೇತಿಯಲ್ಲಿಯ ಸಹ ಮತದಾರರ ಪಟ್ಟಿಯ ಪ್ರಕಾರ ಕರ್ತವ್ಯ
ಅಂದ್ರೆ ಇವರಿಗೆ ತರಬೇತಿ ಕೊಟ್ಟಾಗ ನಮಗೆ ಓನ್ಲಿ ಮತದಾರರ ಪಟ್ಟಿಯಲ್ಲಿ ಇರೋರ ಹೆಸರು ಎಕ್ಸೆಪ್ಟ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ.
ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ says that he has paid the money.
ಪೇಡ್ ಅಂತ ಹೇಳ್ತಾರೆ. There is no supportive document that extent, my lord.
Challenge it in the manner known to law.
Subject to result ಅಂತ ಇರ್ಲಿ ಸ್ವಾಮಿ, I'll place the at least subject to result I'll place the at least subject to result.
Sir, he has to go before the authority. No.
Yes, my lord. I at least subject to result, my lord, I'll play.
Subject.
ಅಲ್ಲ ಅದನ್ನ ಇದನ್ನ ರೆಸಿಪ್ಟ್ ಕೊಟ್ಟಿದಾರೋ ಇಲ್ಲ ಅಲ್ಲಿ ಸೀಕ್ ದಿ ಅಲ್ಲಲ್ಲ ಅಲ್ಲಿ ನಾನು ಅಲ್ಲಿ ಪ್ಲೇಸ್ ಇದೆಯೋ ಇಲ್ಲೋ ಅದನ್ನ ಇಲ್ಲಿ ಫೈಲ್ ಅಂಡ್ ಅಪ್ಲಿಕೇಶನ್ ಐಲ್ ಗೆಟ್ ದಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್. ಈ ರಿಸಿಪ್ಟ್ ಬಗ್ಗೆ ಕಟ್ಟಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ. ಫಾರ್ ದಟ್
ಐ ಲಿಸ್ಟ್ ಇಟ್ ಟುಮಾರೋ. ನೋಡಿ ಹೇಳ್ಬಿಡಿ.
ಅಲ್ಲ ಸರ್, ಸಬ್ಜೆಕ್ಟ್ ರಿಸಲ್ಟ್ ಅಂತ
ಕಾಪಿ ಕೊಡಿ. ಸುಮ್ಮನೆ ಕಾಪಿ ಕೊಡಿ.
ಕೈಂಡ್ಲಿ ಟುಮಾರೋ
ಬರ್ಕೊಳ್ಳಿ. The Learned Counsel for the Cavator respondent number 6 has handed over a copy of the receipt to show, handed over a copy of a receipt to the petitioner, to the Learned Counsel for the petitioner, to establish that the Cavator respondent number 6 had paid up all dues before his nomination was accepted. Full stop. Full stop. The Learned Counsel for the petitioner seeks time to verify the same. Please tomorrow.
Obliged.
Election lordships. In this matter, in the voters list, dead persons have been included, your lordships. People who have died in the year 2018 and 19 have been included. And unfortunately, your lordships, their identity card is also being issued to some people, your lordships.
Identity card photo match ಆಗ್ಬೇಕಲ್ಲ.
Your lordships, that is the sad state of, if they have the ability to include the persons, if they do not comply with the rules and include the dead persons.
That is not a ground to set aside an election, Mr.
At least a direction to change.
Irregular estate, it's all.
No, your lordships, they are issuing identity cards in their name, your lordships.
Yes.
That is the issue, your lordships.
You can't do it at this stage.
Allah, your lordships, but
ಯಾವತ್ತು elections ಯಾವತ್ತು?
12th ಇದೆ, your lordships.
ಮತ್ತೆ?
We came to know when we found an identity card.
ಒಳಗೆ ನೋಟ್ ಎಲ್ಲ ಇದು ವೋಟರ್ಸ್ ಲಿಸ್ಟ್ ಚೇಂಜ್ ಮಾಡಕ್ಕಾಗುತ್ತಾ?
But your lordships, now the irregularities is on the face of it, your lordships.
The dead people cannot come and vote.
Lordships, but they are issuing the identity card. Returning officer himself is
Issue
issuing the
identity
identity card, your
The
lordships.
dead people cannot come to vote.
They are giving it to some random members to cast the vote, your lordships.
ಹುಷಾರಾಗಿ ಅಲ್ಲಿ ನಿಂತ್ಕೊಂಡು ನೋಡಿ. Please ensure that those people do not vote.
Your lordships, we cannot do that, your lordships. They are it is on the face of it, your lordships.
There is an identity card. You know who is dead. Oppose the election. Oppose if that person comes to vote. Not at this stage.
Allah, your lordships. But if it happens so, then the entire process of election will be haphazard, your lordships.
AG has that would accept notice for respondent number 1.
1, 2, 3, man.
2 ಇದ್ದೀರಾ?
Cooperative election.
ಅವ್ರಿಗೆ ಹೆಂಗ್ ಅಪೇರ್ ಆಗ್ತೀರಿ? 1, 3.
1, 3, 1.
1, 3. Issue emergent notice to the other respondents. The elections scheduled on 12th.
12th,
will be subject to the result of this petition.
My lord, may I seek, my lord, to take up my matter, my lord? I got the numbers, my lord. Correct numbers I got.
Sir, please wait.
Yes, I am appearing for petitioner. In this case, my lord, the petitioner is the elected member of the Gram Panchayat. Petitioner is the elected member of the Gram Panchayat. The complaint filed by the 6th respondent, my lord, the inquiry has been conducted. He has been removed from the, my lord, the membership. I have filed this writ petition, my lord, the challenging the removal of the membership. So lordship, my lord, they granted the interim order of stay, my lord. Now the, my lord, the general meeting has been called. It is tomorrow, my lord, 11 o'clock, my lord. No more notice has been issued to the, my lord, the petitioner, my lord, the meeting notice has been issued.
ಎಲ್ಲಿದೆ ಸ್ಟೇ ಎಲ್ಲಿದೆ?
On, my lord, 6/6/2024.
What is
6/6/2020.
it? 48A na? 43A proceedings.
Please,
Where is the order?
not order annexure L, my lord.
Annexa?
L.
Idin L.
Ink page number 33, my lord, it starts, my lord. Operative portion, my lord, the.
What are they doing now?
37 is.
ಆಯ್ತು ಏನ್ ಮಾಡ್ತಿದ್ದಾರೆ ನಿಮ್ಗೆ ಈಗ?
Now the general meeting is, tomorrow is the, my lord, the Panchayat general body meeting is there, my lord, the. After passing this interim order, my lord, the fifth respondent Panchayat has written a letter to the third respondent, whether the notice can be issued to the petitioner or not, my lord. The third respondent stated that notice can be issued, my lord, the ink page number 5, I have, along with the IA, my lord, I have. Ink page number 5 is the, my lord, the letter written by the third respondent, notice can be issued. Or the ink page number 6 is the, my lord, the notice tomorrow, my lord, the 11 o'clock is the meeting. Again, the third respondent and letter, my lord, on, my lord, the 2/1/2025, on pink page number 7, notice cannot be issued. The very same third respondent has issued one more letter, my lord.
What is the subject matter of the meeting? Vasati Yojana.
Subject matter is that, my lord, in the year 2017-18, my lord, the house has been allotted to my wife, my lord, Rupa, in the Panchayat, my lord, under Basava Vasati Yojana. But I was not the member on that period, my lord. Subsequently, I have become the member of the amount has been sanctioned subsequently, my lord. That amount we have already deposited to the, my lord, the Panchayat, my lord. Whatever the amount we have received, my lord, 59,000, we have deposited entire amount, my lord. After inquiry, my lord, I have been removed from the membership. And, my lord, the further disqualified for the.
Correct, how are you going to be affected? Anyway, you can't participate in the meeting.
But I can, my lord, otherwise my area, my lord, I cannot, my lord, develop my.
Array, you have already been disqualified. There's only an order of stay, suspension agide. The order of disqualifying you is suspended.
Please, my lord.
It is not set aside. So how can you participate in the meeting?
Otherwise, my lord, development in the Panchayat, my lord, our area hampered, my lord.
ನೀವಿದ್ರು ಇನ್ನೂ hamper ಆಗ್ತಿರೋದೇ ವಾಸಿ.
Otherwise.
You are disqualified, mister.
All funds are coming, my lord, otherwise we have to, my lord, develop the area, my lord.
Succeed in the writ petition, Barcode. IA 1/25 is filed by the petitioner for a direction for stay of the general meeting of the Panchayat.
Not sought for direction, my lord, I may be permitted to participate.
IA 1/25 is filed by the petitioner seeking for a direction to permit the petitioner to participate in the general meeting of the Panchayat. Full stop, next para. It is seen that the petitioner was disqualified under section 43A of the Panchayat Raj Act 1993. This court has granted an order of stay of the said order. However, this does not mean that the order of disqualification is effaced, EFFACED, but is merely suspended during the pendency of this writ petition. Therefore, until the petitioner succeeds in getting the disqualification set aside, he does not get a right to participate in the meetings of the general meetings of the Panchayat. Hence, IA 1/25 does not merit consideration. The same is rejected. Yes, next.
The interim order may kindly be extended. Till today, it is there. Earlier interim order.
Interim order granted on 6/6/2024 is extended till the next date of hearing. Yes, serial number 5. Serial number 7, Mahantesh Patil.
Petitioners, cooperative society election matter, my lord. Petitioners are seeking permission to cast their votes in the election.
Cast their votes. Then a government advocate is directed to accept notice for respondent number so and so. There are
1,
2,
3 is
5,
yes.
6. Issue emergent notice to the other respondents. Make it same. Permitted to pass to kept in a separate box. So this Yes, next.
Hand delivery same, my lord. It is also same.
Field number 8, same order. Field number 9.
Hand delivery of interim order, my lord. Supply.
My lord, appearing for petitioner. In this case, my lord, kindly see the annexure A, my lord.
Annexure A,
A calendar of events starts from 28/12/2024 to 4/1/2024 for filing of nomination date, my lord. 5/1 is scrutiny of nomination. 6th is the withdrawal of the nomination, my lord. My lord, petitioner filed a nomination for director post, my lord, that was scrutinized on 5/5/5/1/2025, my lord. Earlier, what happened in this case, my lord? Respondent number 6 is appointed as a returning officer in first occasion, my lord. Till 5/1/2025, he is worked as a returning officer. He completed his scrutiny process, my lord, and he published the eligible candidates list whose nomination is accepted. Kindly see my name in serial number 35, my lord. 34, my lord. Dattatray, son of Bapurao.
Yeah, page. Page number?
Page number 16, 17, 18 ali, Swami. 18, page number 34. Sorry, serial number 34.
18, huh? 18 ಅಲ್ಲಿ 34 ಇಲ್ವಲ್ಲ?
Sorry, ಅದು ಹೆಚ್ಚು ಹಿಂದೆ ಮುಂದೆ 16 ಅಲ್ಲಿ 34 ಬಂದಿದೆ ಸರ್. ಪೇಜ್ ಹಿಂದೆ ಮುಂದೆ. Typed copy ಅಲ್ಲಿ correct ಬಂದಿದೆ ಸ್ವಾಮಿ.
Dattatray.
Dattatray is the petitioner, my lord. My nomination is accepted. Kindly see the heading lines, my lord. ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘ ಯರ್ನಳ್ಳಿ ಬೀದರ್ ಇವರ ಆಡಳಿತ ಮಂಡಳಿ ಚುನಾವಣೆ ನಾಮಪತ್ರ ಪರಿಶೀಲನೆ ನಂತರ ಕಣದಲ್ಲಿರುವ ಅಭ್ಯರ್ಥಿಗಳು. This is published by the 6th respondent. On 7th morning, all of a sudden, on shocking, my lord, 7th respondent is appointed as a returning officer.
ಯಾರು? 7th.
7th respondent. By on the political pressure, there is no reasoning. My kindly see the annexure D, my lord. She is appointed as a returning officer on 6th, my lord. Idralli, my lord, it is the appointment order, my lord. On 6th, my lord, after assuming the charge, my lord, she issued an endorsement by saying that, my lord, rejected the nomination of petitioner. ಏನು ಬರೀತಾರೆ ಅಂದ್ರೆ, may I read, my lord, typed copy. Annexure E typed copy, my lord. I'll read operative portion, relevant portion only. 3rd para, my lord. ಮುಂದುವರೆದು ಸದರಿ ದೂರು ಪತ್ರದನ್ವಯ ನಾಮಪತ್ರ ಪರಿಶೀಲಿಸಿ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ಲಗತ್ತಿಸದೇ ಇರುವುದು ನಿಜವಿರುವುದರಿಂದ ಈ ಹಿಂದಿನ ರಿಟರ್ನಿಂಗ್ ಅಧಿಕಾರಿಯು ಅದೇ ದಿನಾಂಕ 4/1/25 ಸದರಿಯವರಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಾಮಪತ್ರ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ಲಗತ್ತಿಸದೇ ಇರುವುದರಿಂದ ಸದರಿಯವರು ಸಲ್ಲಿಸಿರುವ ನಾಮಪತ್ರ ತಿರಸ್ಕರಿಸಲಾಗಿದೆ ಎಂದು ತಮ್ಮ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿ ನೋಟಿಸ್ ಬೋರ್ಡ್ ಸೂಚನೆ ಫಲಕಕ್ಕೆ ಲಗತ್ತಿಸಿರುತ್ತಾರೆ. 4th is on last date of accepting nomination. ಅವತ್ತೇ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಆದರೆ ಪ್ರತಿ ಕಡತಕ್ಕೆ ಅದರ ಪ್ರತಿ ಕಡತಕ್ಕೆ ಲಭ್ಯವಿರುತ್ತದೆ. ನಂತರ ದಿನಾಂಕ 5/1/25 ಪರಿಶೀಲನೆ ಕುರಿತು ನಾಮಪತ್ರಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಪರಿಶೀಲನೆ ನಂತರ ಕ್ರಮಬದ್ಧವಾಗಿದ್ದ ನಾಮಪತ್ರ ಸಲ್ಲಿಸುವ ಅಭ್ಯರ್ಥಿಗಳ ಪಟ್ಟಿಯಲ್ಲಿ ಸದರಿಯವರ ಹೆಸರು ದಾಖಲಿಸಲಾಗಿದೆ. ಕ್ರಮಬದ್ಧವಾಗಿರುವ ನಾಮಪತ್ರಗಳ ಪಟ್ಟಿಯಲ್ಲಿ ಹೆಸರು ಸೇರಿಸಿದಂತೆ ಕಂಡು ಬರುತ್ತದೆ. My lord, subsequent returning officer saying that on the writing ಸೇರಿಸಿದಂತೆ ಕಂಡು ಬರುತ್ತದೆ. On the assumption and injunction, she rejected my nomination. ಯಾವಾಗ withdraw ಆಗಿದೆ, ಯಾವ calendar of events against the calendar of events, she rejected my nomination and she published one more list, my lord, on 6th. Kindly see page number annexure F, page number 26, my lord. ಅಲ್ಲಿ 35 ಜನ accepted nominated list ಇದ್ರೆ ಇಲ್ಲಿ 34 members ಕೊಡ್ತಾರೆ. On 6/1/2025.
ಅಲ್ಲ, ಬಟ್ ವಾಟ್ ಅಬೌಟ್ ದಿಸ್ ನಿಮ್ದು ನಾಮಪತ್ರ ರಿಜೆಕ್ಟ್ ಆಗಿರೋದು ನೋಟಿಸ್ ಏನೋ ಹಾಕಿದಾರಂತಲ್ಲ, ಅದೇ ಏನಂತೀರಾ?
Select ಆಗಿದ
ಇನ್ನೊಂದ್ಸತಿ ಓದಿ ಫಸ್ಟ್ ಇಂದ ಮುಂದುವರೆದು ಬೇಡ ಮುಂದುವರೆದು ಓದಿ.
ಮುಂದುವರೆದು ಸದರಿ ದೂರು ಪತ್ರದನ್ವಯ ನಾಮಪತ್ರಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ಲಗತ್ತಿಸದೇ ಇರುವುದು ನಿಜವಿರುವುದರಿಂದ ಪರ್ಟಿಕ್ಯುಲರ್ ಪಾಯಿಂಟ್ ಸಲ್ಲಿಸಿರುವುದು ನಿಜವಿರುವುದರಿಂದ ಈ ಹಿಂದಿನ ರಿಟರ್ನಿಂಗ್ ಅಧಿಕಾರಿಯು ಅದೇ ದಿನಾಂಕ 4/1/25 ಸದರಿಯವರಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಾಮಪತ್ರ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ಸಲ್ಲಿಸದೇ ಇರುವುದರಿಂದ ಸದರಿಯವರು ಸಲ್ಲಿಸಿರುವ ನಾಮಪತ್ರ ತಿರಸ್ಕರಿಸಲಾಗಿದೆ ಎಂದು ತಮ್ಮ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿ ನೋಟಿಸ್ ಬೋರ್ಡ್ ಸೂಚನಾ ಫಲಕಕ್ಕೆ ಲಗತ್ತಿಸಿರುತ್ತಾರೆ. 4ನೇ ತಾರೀಕು ಹೆಂಗ್ ಲಗತ್ತಿಸೋದು ಬರುತ್ತೆ ಸ್ವಾಮಿ? ದಟ್ ಇಸ್ ದಿ ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಫೈಲಿಂಗ್ ಆಫ್ ನಾಮಿನೇಷನ್. ಸ್ಕ್ರೂಟಿನಿ ಇಸ್ ಆನ್ 5th. ಮುಂದುವರೆದ ಏನ್ ಹೇಳ್ತಾರೆ? ಇದರ ಪ್ರತಿ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುತ್ತದೆ. ನಂತರ ದಿನಾಂಕ 5/1/25 ಪರಿಶೀಲನೆ ಕುರಿತು ನಾಮಪತ್ರಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಆದರೆ ದೂರುಪತ್ರದನ್ವಯ ಶ್ರೀ ದತ್ತಾತ್ರೇಯ ತಂದೆ ಖಾನಾಪುರಿ ಅವರು ನಾಮಪತ್ರ ತಿರಸ್ಕರಿಸಿಕೊಂಡಿರುವ ನಾಮಪತ್ರವನ್ನೂ ಸಹ ಪರಿಶೀಲನೆ ನಂತರ ಕ್ರಮಬದ್ಧವಾಗಿ ನಾಮಪತ್ರ ಸಲ್ಲಿಸಿರುವ ಅಭ್ಯರ್ಥಿಗಳ ಪಟ್ಟಿಯಲ್ಲಿ ಸದರಿಯವರ ಹೆಸರು ದಾಖಲಾಗಿರುತ್ತದೆ. ಇದು ರಿಟರ್ನಿಂಗ್ ಅಧಿಕಾರಿಯವರು ಜೀವ ಬೆದರಿಕೆ ಹಾಗೂ 2 ಗಣಗಳ ಒತ್ತಡಕ್ಕೆ ಮಣಿದು ಕ್ರಮಬದ್ಧವಾಗಿರುವ ನಾಮಪತ್ರಗಳ ಪಟ್ಟಿಯಲ್ಲಿ ಹೆಸರು ಸೇರಿರುತ್ತದೆ. ಸೊ ಅರ್ಲಿಯರ್ ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ಯಾವುದೇ ಕಂಪ್ಲೇಂಟ್ ಲಾಡ್ಜ್ ಮಾಡೋದಿಲ್ಲ, ಏನಿಲ್ಲ ಅಂತಿಲ್ಲ. ಆಲ್ ಆಫ್ ಎ ಸಡನ್ ಯಾಕೆ ಅವರನ್ನು ಚೇಂಜ್ ಮಾಡಿದ್ರು ಅನ್ನೋದು
already other candidate is unopposed elected on 6/1. They have declared result, man.
Results already declared.
Accepting my nomination. Having jurisdiction.
AG has directed to accept notice for respondents 1, 3, 4, 5. Issue emergent notice to the other respondents. Since it is stated by the learned AGA that the elections, since it is stated by the learned AGA that the elections, that the results of the elections is already declared, the elections so declared shall be subject to the result of this petition. Yes. Staying madakatri. Staying madakagutte.
Not one.
ಚೆಕ್ ಮಾಡೋಣ ಅದು ಬಿಲ್. ಲುಕ್ ಇನ್ ಟು ಇಟ್. ಇವಾಗ ಎಲೆಕ್ಷನ್ಸ್ ಆಗ್ಲೇ ಆಗೋಗಿದೆ, ರೈಟ್ ಆರ್ ರಾಂಗ್? He says that because there is no contest, the elections results are already declared ಅಂತ ಹೇಳಿದ್ದಾರೆ. That will examine it. Can we stay the elections?
Milord, my matter, Milord, tender matter, Milord. Milord, my matter, tender matter, Milord, which was passed over. May I request, Milord, to take it up?
ಅರೆ ಆಗೋಗಿರೋದ್ರಲ್ಲಿ ಏನ್ರಿ ಮಾಡ್ತೀರಾ? ಆಗೋಗಿದೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ. Now the returning officer is gone. He is gone. ಮುಗಿದೋಯ್ತು ಒಂದು.
May I request my matter to be taken up, Milord?
Mr. Gaurish Kashampur. Now the returning officer's role is over. Once the results are declared, right or wrong, his role is over. How can I?
Direct the respondent authority, both the returning officer, to place entire records, my lord, on political pressure, my lord. They are playing
Who is the officer concerned? The respondent number 6 and 7, The respondent number 6 and 7 are directed to place on record the entire records, all the original records relating to the elections to the respondent number?
Respondent number 7,
7. Respondent number 8. List on yavat beku. ಅವ್ರು ಇನ್ನ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ. List on date put.
22nd.
Yes, Srinivas.
Milord, now, Milord, may I take your lordships to page number 47, Milord? Because the time is running short, I'm just going to straight to the point without taking
Allah, you should also understand that many lawyers are also waiting, so you can't waste time.
Yes, Milord, I'm sorry, Milord.
2:30, there are about 9 matters listed.
Yes, Milord, I'm sorry.
I was supposed to get up at 3:45.
Yes, Milord. Milord, page number 47. Milord, ಮೇಲ್ಕಂಡ ಟೆಂಡರ್ ಭಾಗವಹಿಸರು ಎಲ್ಲ 5 ಜನ ಟೆಂಡರ್ಗಳಿಗೆ 2 ಬಿಡ್ಡಿದಾರರು ತಾಂತ್ರಿಕ ಬಿಡ್ ಅರ್ಹತೆ ಹೊಂದಿರುತ್ತಾರೆ. ನಾವು 3 ಜನ ಅರ್ಹತೆ ಹೊಂದಿರುವುದಿಲ್ಲ. ಅದರಲ್ಲಿ ತಾಲೂಕು ಮಹಿಳಾ ಮಲ್ಟಿಪರ್ಪಸ್ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಯಾದಗಿರಿರವರು ವಸತಿ ಶಾಲೆಗೆ ಸಿದ್ಧಪಡಿಸಿದ ಆಹಾರ ಸರಬರಾಜು ಮಾಡಿದ ಆರ್ಥಿಕ ವ್ಯವಹಾರ ಹೊಂದಿರುವುದಿಲ್ಲ. ಆರ್ಥಿಕ ವ್ಯವಹಾರ
ಶ್ರೀನಿವಾಸ್ ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಪ್ಪ? ಯಾವ ಪಿಟಿಷನ್?
Milord, first petition, my lord, I am taking the first petition, my lord, which your lordship took up at the first time.
ಹೌದು.
20048, my lord. 20048.
48 ತಗೋಬೇಕಾ?
Yes, my lord.
48 ಕೊಡಿ.
All are similar, my lord. Grounds are also similar.
47.
Page number 47.
ಓದಿ, ಎಲ್ಲಿ ಹೇಳ್ತೀರಿ? ಓದಿ.
My lord, page number 47, ಇದು ಮೇಲ್ಗಡೆ ಕರ್ನಾಟಕ ರೂರಲ್ ಎಜುಕೇಶನ್ ಸೊಸೈಟಿ ಸೊ ಅವ್ರು ಹೇಳಿದೆ. ಮೇಲ್ಗಡೆ ಇದರಲ್ಲಿ 5 ಜನ ಭಾಗವಹಿಸಿರ್ತಾರೆ, ಇಬ್ರಿಗಿದೆ 3 ಜನ ಅರ್ಹರಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. 3ನೇದ್ರಲ್ಲಿ ನಾನೇ ಫಸ್ಟ್ ಬಂದಿದ್ದೀನಿ. ತಾಲೂಕು ಮಹಿಳಾ ಮಲ್ಟಿಪರ್ಪಸ್ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಯಾದಗಿರಿರವರು ವಸತಿ ಶಾಲೆಗೆ ಸಿದ್ಧಪಡಿಸಿದ ಆಹಾರ ಸರಬರಾಜು ಮಾಡಿದ ಆರ್ಥಿಕ ವ್ಯವಹಾರ ಹೊಂದಿರುವುದಿಲ್ಲ. ನೋ ಮಿಲಾಡ್, ಆಹಾರ ಸರಬರಾಜು ಮಾಡಿದ ಆರ್ಥಿಕ ವ್ಯವಹಾರ ಹೊಂದಿರುವುದಿಲ್ಲ. ದಿ ಕಂಡೀಷನ್ ವಾಸ್ ನಾಟ್ ಆಹಾರ ಸರಬರಾಜು ಮಾಡಿರೋದ್ರಲ್ಲೇ ಇರಬೇಕು ಅಂತಿಲ್ಲ. ನಾನು ಫುಡ್ ಗ್ರೇನ್ಸ್ ಸಪ್ಲೈ ಮಾಡ್ತೀನಿ, ಆಹಾರನು ಸರಬರಾಜು ಮಾಡ್ತೀನಿ. ಮಿಲಾಡ್, ಅನೆಕ್ಷರ್ ಸಿ ಸೀರೀಸ್ ಇಸ್ ದ ನಾನು ಪ್ಯಾಕೇಜ್ಡ್ ಆಹಾರ ಅದೇ ಹಾಸ್ಟೆಲ್ ಸಪ್ಲೈ ಮಾಡಿರುವಂತ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಫ್ರಮ್ ಪಾಸ್ಟ್ 5 years.
ವಸತಿ ಶಾಲೆಗೆ ಸಿದ್ಧಪಡಿಸಿದ ಆಹಾರ ಸರಬರಾಜು ಮಾಡಿದ ಆರ್ಥಿಕ ವ್ಯವಹಾರ ಹೊಂದಿರುವುದಿಲ್ಲ.
ಆರ್ಥಿಕ
ವ್ಯವಹಾರ ಫುಡ್ ಗ್ರೇನ್ ಸಪ್ಲೈ ಮ್ಯಾನ್ ಪವರ್ ಸೇರಿಸಿ ತೋರಿಸಿರುತ್ತಾರೆ.
Yes, my lord. My lord, your lordship may kindly come to condition number, page number 17 again now. What is the condition in the tender? Page number 17. From the bottom, second condition. ಉತ್ತಮ ಆರ್ಥಿಕ ಸ್ಥಿತಿ ಹೊಂದಿರಬೇಕು. ಉಳಿತಾಯ ಮಾಡಲಾದ ಅನುದಾನ, ಬ್ಯಾಂಕಿನೊಂದಿಗೆ ಹಣ ವ್ಯವಹಾರ ಹಾಗೂ ಅಧಿಕೃತ ನೋಂದಣಿ ಹೊಂದಿರುವ ಚಾರ್ಟೆಡ್ ಅಕೌಂಟೆಂಟ್ ರಿಂದ ಹಿಂದಿನ 3 ವರ್ಷಗಳ ಆರ್ಥಿಕ ವಾರ್ಷಿಕ ವಹಿವಾಟಿನ ದೃಢೀಕರಣ ಪತ್ರ ಲಗತ್ತಿಸಬೇಕು. ಟೆಂಡರ್ ವಾರ್ಷಿಕ ವಹಿವಾಟಿನ ಹಿಂದಿನ ವರ್ಷಗಳಲ್ಲಿ ಸರಾಸರಿ 50 ಲಕ್ಷ ಇರಬೇಕು. ನೆವರ್ ಸ್ಟೇಟ್ ಬರೀ ಫುಡ್ ಗ್ರೇನ್ಸ್ ಅಲ್ಲಿ ಇರಬೇಕು ಅಂತ ಹೇಳಿ, ಫುಡ್ ಪ್ಯಾಕೇಜ್ ಫುಡ್ ಅಲ್ಲಿ ಇರಬೇಕು ಅಂತ ಹೇಳಿ. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ನೌ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು Annexure C series. Annexure C series is my experience certificate having supplied the food articles to the same hostel. 16-17, 21-22, 22-23, 23-24. I satisfy that condition for having supplied from past 3 years. Now, my lord, turnover listing what I have produced before them is at Annexure D. My total turnover of my company, including of packaged food and food grains, it is 6,21 lakhs in 2019-20. 2021 6 crore 37 lakhs. 21-22 16 crores. And 21-22-23 11 crores. 23-24 13 crores. That was my turnover.
In column number 7.
ಏನಂದ್ರೆ
ಸಿದ್ಧಪಡಿಸಿದ ಆಹಾರವಧಿಸಿದಂತೆ ಇಟ್ ಇಸ್ ಕಂಡೀಷನ್.
ಆಯ್ತು, ಬರ್ಕೊಡಿ. ದಿ AGS directed to accept notice for respond number 1.
Tomorrow is the financial bid opening, my lord.
1, 2, 1 and 3. 1, 3, 6 and 7. Issue emergent notice to the other respondents. Next para. Since the technical bid of the petitioner is rejected on the ground that the petitioner did not possess the requisite
turnover for having supplied packaged materials.
Did not possess the eligibility for eligibility of supplying packed
packaged food article.
Packed food.
Food articles.
ಸೆಂಟೆನ್ಸ್ ಏನಂತ ಶುರು ಆಯ್ತು? While the petitioner claims to have supplied packed food to the very same institutions in the past, it is during 2016-17, 21-24.
Till 23-24.
Till 22?
23-24.
Till 23-24, it is appropriate that notwithstanding the rejection of the technical bid of the petitioner, comma, the financial bid of the petitioner shall be opened. Full stop. The finalization of the bids shall be subject to the outcome of this writ petition. Yes.
My lords, may I submit, my lords?
My lord, all three are same, my lord.
Yes.
Serial number 76.
My lord, all three are same. May I request for hand delivery, my lord?
Yes. Yes, Kadaganchi ಹೇಳಿ.
76 ಅಲ್ಲಿ interim order ಇದೆ, my lords. It
ಅಲ್ಲ
may
ಎಲ್ಲ
be
ಇಂಟ್ರಿ ಮಾಡಿಸಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತಾರೆ.
Your lordship, serial number
75, my lord. May I have it?
68. ಕೊಡ್ತಾರೆ, ಡೇಟ್ ಕೊಡ್ತಾರೆ.
Court officer, 70 ಮಂಡೆ ಹಾಕಾಗತ್ತೆ ನೋಡಿ. Court officer, 71. 71. Court officer, 71.
ಆನ್ಲೈನ್ ಅಪ್ಲೋಡ್
ಮಂಡೆ
ಗೊತ್ತಾಗಲ್ಲ.
ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ತಾವು ಮಾತಾಡೋದು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ಎಂಡ್ ಆಫ್ ಲಿಸ್ಟ್ ಆಯ್ತು.
71.
ಇದೆಲ್ಲ ನಾವು ಬರ್ಕಂತ
ಕೋರ್ಟ್ ಆಫೀಸರ್,
ಮ್ಯಾಗ ಹೋಗಿ ಬರಮ್ಮ ಆಮೇಲೆ ಎಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್, ಹಾ ಮಂಡೆ ಡೇಟ್ ಸರ್ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ರಾ?
ಅಲ್ಲ 80 ಒಂದು ಅರ್ಜೆಂಟ್ ಇದೆ, ಅದರಲ್ಲಿ ಯಾವಾಗ ಕೊಡ್ತಿರೋದು?
Court officer, 75.
ಮಂಡೆ ಆಗ್ಬಿಟ್ಟ ಸರ್.
ನೋಡಿದೆ 17 ಒಂದು ಬಿಟ್ಟು all 4 days except Sunday. Friday ಒಂದು ಬಿಟ್ಟು ಯಾವ ಡೇಟ್ ಅಂತ
ಈ ಫ್ರೈಡೆ ಯಾರು ಬರ್ತಾರೆ?
Friday ಬಿಟ್ಟು ಅದು ನಾಳೆ 13 days.
ಫ್ರೈಡೆ ಯಾರು ಸರ್?
Friday ಹನುಮಂತಯ್ಯ ಬಸಪ್ಪ.
ಕೊಟ್ಕೋಬೇಕಲ್ಲ, ಕೈ ಕೊಟ್ಕೋಬೇಕಲ್ಲ ಇವನಿಗೆ ರಘು ಹೇಳ್ಬಿಟ್ಟು.
Court officer?
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಏನು ಆನ್ ಔಟ್ ಹೊರಟೋದ್ರ? ಕೋರ್ಟ್ ಆಫೀಸರ್
ಅವ್ರೇನು ಮಾತಾಡ್ತಾನೆ ಇಲ್ಲ ಸರ್.
ಅದೇ ಸರ್ ಏನು ಮಾತಾಡ್ತಾ ಇಲ್ಲ. ನೀನು ಮಾತಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಬಿಟ್ಟಿರ್ಬೋದು ಸ್ವಲ್ಪ ಹೊತ್ತು. ಇಷ್ಟಲ್ಲ ಒಂದು ದೋಣ ಹಾಕೊಳ್ಳಿ.
Court officer,
ಹಾ ಸರ್ ಹೇಳಿ.
75.
75 ನಾ?
24 ಹಾಕಕ್ಕಾಗುತ್ತಾ ಸರ್?
75
ಹಾ, ರವೀಂದ್ರ, ಕೆ ರವೀಂದ್ರ ಅಂತ.
GM ಟೆಂಡರ್ ಅಂದ್ರೆ ನಿಮ್ಗೆ 13 ಅಥವಾ 20ನೇ ತಾರೀಕು ನೋಡಿ, ಯಾವ್ದು ಯಾವತ್ತು ಬೇಕು?
ಅಲ್ಲಲ್ಲ, ನಂದು GM ಟೆಂಡರ್ ಅಲ್ಲ ಅದು, 75.
ಅದೇ GM ಟೆಂಡರ್ ಇದೆಯಲ್ಲ.
ಅಲ್ಲ ಸರ್. ಹಾ, ಎಸ್ ಕರೆಕ್ಟ್, ಸರಿ ಕರೆಕ್ಟ್.
ಮ್ಯಾಟರ್ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ.
ಇಲ್ಲ ನಾನು ಅದು ಇದ್ರದ್ದು ಅನ್ಕೊಂಡು ಕೋಆಪರೇಟಿವ್ ಅನ್ಕೊಂಡಿದ್ದೆ, ಇನ್ನೊಂದು ಇತ್ತು.
GM ಟೆಂಡರ್
ಹಾ,
ಇದೆ. GM ಟೆಂಡರ್ ಅಂದ್ರೆ ಸೋಮವಾರ ಅಷ್ಟೇ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಇದೆ, ಅದು ಅವತ್ತೇ ಬರುತ್ತೆ ನೋಡಿ. ಸೋಮವಾರ ನೆಕ್ಸ್ಟ್ ಸೋಮವಾರ ತಗೋಬೇಕು, ಈ ಸೋಮವಾರ ತಗೋಬೇಕು. ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕು?
20ಕ್ಕೆ ಹಾಕಿ ಸರ್.
20? ಓಕೆ
ಸರ್ ಸೀಲ್ ನಂಬರ್ 71 ಸರ್.
ನಿಮ್ದು ಯಾವ್ದು?
71
21
71 ಮಂಡೇ ಆಗುತ್ತೆ ನೋಡಿ ಸರ್. ಮತ್ತೆ ವಿತಿನ್ 40 ಇದ್ರೆ ಹಾಕಿ ಸರ್, ಇಲ್ಲಾಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಡೇ ಕೊಡಿ ಸರ್.
ಸರ್ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಬುಧವಾರ.
ಸರ್
ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಬುಧವಾರ. ಸರ್ವಿಸ್ ಅಂಡ್ ಲೇಬರ್
ಬುಧವಾರ
ವೆನ್ಸ್ಡೇ.
ಓಕೆ ಸರ್, ವೆನ್ಸ್ಡೇ ಹಾಕಿ. ಬಟ್ ದಯಮಾಡಿ ಒಂದು 20 ಹಾಕಿ ಸರ್, ಯಾಕೆಂದ್ರೆ ನಾವು ಕಳೆದ ಭಾಳ ಸರ್ ಬಂದು ವೆಯ್ಟ್ ಮಾಡಿ
ನಮ್ ಕಡೆ ಇರಲ್ಲ ಸರ್.
71 ಸರ್, ಶಾಂತರಾಜು.
ಆಯ್ತು ಹಾಕಿದೀನಿ ನೋಡಿ.
ಗುರುವಾರ ಅಲ್ಲ ಸರ್, ವೆಡ್ನೆಸ್ಡೇ.
15 ಮಂತ್.
ಹಾ ಸರಿ ಸರ್, ವೆಡ್ನೆಸ್ಡೇ.